Crooked Fanny playing dirty tricks in the courtroom. She always picks, bending the rules. She'd know win, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her ways and put her to shame.
Hey-o! And welcome to... I've been reading up on Rich Homie Quan for the past 24 hours, and he gets to you. He does. All too soon. And I was looking forward to him testifying in this trial. He was on the prosecution's witness list. And, well, okay. Welcome to this, I don't know what to call it, a Thugger-thon, marathon, young thug trial. I covered Monday, half of it, and then I've been swamped with work. Rich Homie Quan was big part of Young Thug's music career. They did a lot of music together. Then at some point they had a falling out, but they were, according to Rich Homie Quan in his last interviews, he was looking to amend. And now he's gone. So, love your Bigfoot. Yay! For you who don't know, I was in the United States in August, and one of the places I visited was the Sasquatch Museum and Research Center in Blue Ridge, Georgia. So, okay, but yeah, let's go back in time to do this final, maybe. Oh, that poor man. Maybe the final time we saw him in this trial. Maybe. Maybe. You never know. You never know. But here he is again. See here.
I'll let you know. I say about you.
Okay. I don't know how far we're gonna get today, if we're gonna finish Mr. Copeland, but do y'all have your next witness lined up, just in case? Okay. All right, let's get Mr. Copeland back in and get the jury.
Yeah. I have roughly 9.5 hours to cover Tuesday, Wednesday, Thursday, and today. And then it is time for the panel show at 6 p.m. So, going to speed through this a bit. Now, I will not play everything, but if there is something you believe, hey, you missed this, let me know a rough timestamp in the Law and Seaward, and I will get to it.
Well,
Yeah, temperature is as per usual. And here the prosecution's table is at their funeral. All wearing black.
I didn't hear you. You're welcome. Anybody know?
I'll do it.
all right, thank you. Go ahead, Ms. Holden.
Playing in 1.5 speed. Who you don't know.
Before we went to lunch, I believe you had testified that you did not recall ever telling the police that that Nard and Dolly had bragged about killing Nut. Do you remember saying that before?
I didn't say nothing about it. I don't ever recall. I never heard anybody bragging about killing him.
Okay, I'm going to play for you Stacey Exhibit 378 Yankee Echo at 3:48:46.
The dude telling me story, he's like, but they talking about it, you know what I mean? I ain't never heard chance about it. I heard about it talking that, I mean, police are fine, fuck they did. I mean, so then I heard the first time she talked about that. I mean, what she said? She said, second act girl, yeah. She didn't talk about like, yeah, fuck they did. Sometimes I take my brother. And wait.
Did you hear when you told the police you heard Thug's sister talk about it and say, F that nigga, he should something, he shouldn't play with my brother?
No, I didn't hear. I didn't understand not one word out of the whole thing.
You need to play it again?
You played 10 times. I just can't understand. I can't make out the words.
Why did you bring up that Thug's sister talk about killing Nut?
Miss Hilton, it's about trying to convince them. So I'm pretty sure you watched the interview and you laughed at the stuff I said and you knew that I'm lying, but.
And you told this to the police on June 10th. Correct. That was the day that you got arrested, correct?
I don't know what I said in the interview.
All right. And it was on June 13th that we heard the phone call of the Dolly saying we killed Nut, correct?
Again, she said they saying.
But that was on June 13th that jail call happened.
I can't say what date it happened, but I heard it on jail call.
And it said that jail call was after your interview with Gaither and Dennis.
You tell me?
All right. Now, you've said on numerous occasions throughout your testimony that you feed the police whatever lies that you're telling in the moment, correct?
What you mean?
That whatever lies you're making up, you make it up in the moment, correct?
Not necessarily. Sometimes they might ask me a question where I'm not prepared for. Like, my only thing is, being interrogated, my only thing is get them off of me. So, by any means necessary, get them off of me. With Detective Gaither and Dennis, I know that, you know what I mean? I got to be more convincing with it. I keep telling you that.
And all the lies you make up while you're in the interview, correct?
No.
So you make it up beforehand?
Yeah, I actually tell myself lies on a daily basis that, you know, like, I'll put stuff in my head and make myself believe it so that, but they just when it comes to
Sure. He tells himself lies and then convince himself it is true, and that way it is more convincing when he gets interrogated. That's one way of doing it, I assume.
so, you know what I mean? Like, I don't know, man. I'm just, at this point, I'm over it. You know what I mean? Like,
So when you're sprinkling your truths with your lies, is it fair to say that you don't make up the lies with anyone else?
now what I'm saying is, I'm trying to tell you that that was back then. Like, you feel me? Trying to make me go back into, you know what I mean? Like, I play games like that was back then. So now it's like, it's hard for me to answer your question because you keep going back then.
We're talking about the interviews that you did back then.
Right. So I'm in the interrogation room. I'm scared. I'm nervous. I keep going to jail every chance the police see me. So some things I just knew where they out there.
And my question to you is, it is fair to say that you made up these lies on your own, correct? Whatever you were telling the police back in 2015 to finesse yourself, you were making those lies up on your own, correct?
I'm not up here trying to reveal my hand. So what I'm telling you is, I lied back in 2015. If you want me to be speaking in general, like over the whole curse of the thing, like, you gotta be more specific. Like with this situation right here, they questioned me one time. I told them out the real, when he questioned me, I told him whatever I told him, I don't remember. The next time he questioned me, I told him something different. I don't remember. Every time he questioned me, only thing I could remember was to convince them that I didn't do these crimes.
And
There you go.
And my question to you is, in all of your interviews in 2015, you keep telling the jury that you sprinkle a little bit of lie with a little bit of truth. My only question to you is, those lies that you were sprinkling in, you made them up on your own, correct?
Was somebody supposed to help me make it up? Like, I don't get what you're asking.
That's all I'm asking. Did you make up those lies on your own?
Did I make them up on my own? What the heck? Did I make them up on my own? You need to be more specific.
Did you make up the lies with anyone else?
Somebody like, did I go to somebody else tell them lie with me?
Yeah.
I went to people and told them what was going on,
Okay.
what the police questioned me about, and I said certain things to certain people.
Who did you tell those lies to?
I don't remember who all I told it to, but I told it. I have
Who were some of the people you told the lies to?
Mounk Tounk, Lil D,
Which little D?
from my neighborhood.
Okay, from Mechanicsville.
Yep.
Okay.
My brother. Shit, I told Vlad to excuse my name. Yeah.
Did you tell Shannon about the lies that you told the police?
Yeah, I think so. I'm pretty sure I probably did.
Did you tell Thug about the lies you told the police?
Yeah.
Did you tell Yak the lies that you told the police?
No, I don't think I told. I don't, because I ain't really talk yet much, so I don't think I told yet.
And what lie did you tell them that you told police?
And then I spent the story that, you know what I mean? Shit, I told her, goddamn it, you know, shit, these motherfuckers on me, so I put it up on everybody else, get my food.
So you told Mounk Tounk that you told the
I can't know. I'm trying to. I got you.
So I'm gonna be clear, because you said you told Mounk Tounk. So you told Mounk Tounk, I went to the police and I told them that Little D told me about what happened the night of the murder.
No, I told Mounk Tounk that the detective questioned me, and he let me right back out. I said, nigga, don't lie. My bad. I said, I told Mounk Tounk that, shit, you can tell the detective anything. He gonna go for it.
Did you tell him specifically about what Little D told you?
But he never told me nothing. So this how I go. They don't question me so many times. Even over the phone, they don't call me. Now, who did this and then Gaten? Who did this and then third? I ain't do it. I don't care nothing about it. I don't want to hear nothing about it. Why? I ain't in handcuffs, so I didn't really have to come up with no story.
I want to talk specifically about the June interview, okay? When
Yes.
you gave up most of the information.
Most what information?
Did you tell Mounk Tounk that in that June interview, I told the detectives that Little D told me what happened the night of the murder?
I told, okay, every time they question me, and I left, the one y'all didn't lock me up on, and I mean, I was telling the D, I mainly told the D, I mean, because I felt like the D always had my back, so I was telling the D what the police would question me about, and the answers that I was giving him, and the D like, damn, what you hear? Like, with Mounk Tounk, I just like, talk to them, they own me, you feel me? Like, what they trying to get me, you know what I mean? Like, I put off on shell kill, like, I just told Mounk Tounk stuff like that.
So I'm asking you specifically, because this is my question. Did you ever tell Mounk Tounk that you told police that Little D told you what happened the night of the murder?
Well, I can't be specific about that because, like I said, I know I went back to Mounk Tounk. I got into Mounk Tounk because, like, I was telling him, like, but they own me, and I felt like he was starting stuff up. So, yeah, I felt some type of way towards him.
So yes, you did tell him what.
I told Mounk Tounk, I feel like I was telling him that how I was spending the police, and he was creating a problem. So I stopped talking to Mounk Tounk at one point. So I can't be specific on what I was telling him, but I just kept telling him that No, I told him that they asked about me and him. They asked about me, him. I mean, not me, him, but me, Dr. Head. So they keep tying me to the murder, and I just kept throwing it off on shit. But they nutting them right the plug, this and then third. Like, shit, they just going for it. That's why I can't really be specific on what I was saying because it was so long ago.
Let me ask you this. Did you tell Mounk Tounk that it was Shannon, Nard, Yak, and Duwop that shot Nut?
No, I mean, we don't discuss that. Like, I don't know nothing about saying none of that.
You said you also talked to Shannon about what you said to police. Did you tell Shannon that you told police that he, Yak, Duwop, and Nard shot and killed Nut?
Why would I tell him that? I mean, Shannon probably was surprised to hear that I said it. So I don't.
Did you tell Thug that you told police that he drove the Infinity? That he rented the Infinity, that Shannon, Yak, Nard, and Duwop were in the Infinity when the murder happened?
I didn't think this stuff was gonna come out, so because like I said, so I didn't tell them none of it. What I'm telling them that for? I don't want to.
And did you not tell them because you knew you snitched on them about what happened the night of the murder?
Huh? I can't snitch on nobody that I don't. Like I said, if I knew that the problems that I caused would have did this, like I said, you know what I mean, I didn't even think y'all would do this. So talking about snitching on somebody, this ain't the case.
Let me ask you this. Outside of Deshaun, did you tell anyone what you told police about Yak, Shannon, Duwop, and Nard killing Donovan Thomas?
I'll make sure you hear me this time. I don't know. I never seen Yak, Shannon, Duwop, and Nard. They never told me they did anything to Donovan Thomas. I never saw them do anything to him. I'm not trying to defend nobody, no nothing. Y'all trying to use lies that I told in the past against these men. And I'm just here to straighten it up on my behalf that I lied. So you can't sit here and say I snitched on them for a crime that I don't know if they committed.
I ask a better question. Did you ever tell anyone outside of Deshaun that you told police what Little D told you about the night of the murder?
You saying outside Deshaun? I never told Deshaun that they did this. I told Deshaun that people were saying I killed Nut and I didn't do it. That's what I told Deshaun. And I told her that she needed to let the police know that I didn't do it.
And so I ask you again. Did you tell anyone that you told police that Shannon and Yak killed Nut?
You said, did I tell the police?
Did you tell anyone that you told the police that Shannon and Yak killed Nut?
Did I tell anyone that I told the police that Shannon and Nut killed?
That Shannon and Yak killed Nut?
Now, did I know? I don't know. You confusing me.
Now,
This, I must say, is probably planned by Miss Hilton because she's not interested in the answers here. She's interested in planting this information in the head of jurors. But I do believe that Woody, by now, in this point in time, thoroughly convinced everybody that he lied in those police interviews about knowing who did what to whom. So I do believe, even though she is performing somewhat good, it's worthless because it's Woody on the stand.
so is it fair to say you never told anyone that you told the police that Yak and Shannon?
You trying to trap me up?
Sustained.
Did you ever tell anyone at all? Yes, no, or you don't remember?
I don't know that he's answered it, so I'm going to overrule that.
Is it yes, no, I don't remember. Did you ever tell anyone that you told police that Yak and Shannon killed Nut?
I don't know how to answer that because I don't want to say yeah I did. I don't want to say no I didn't because I can't remember.
And can you not remember because you don't want to tell me an answer?
I've been telling you the answer since I've been in here. So what's the purpose of me getting up here saying it now? Like I told you last week, or whenever I told you that if I was seeing them, they would have told me that they killed Nut. I would stop right here and say that Shannon said he killed Nut, or Yak said he killed Nut. Neither one of those told me that. I told you that I was going through a phase in my life, you know what I mean, and trying to tell the police anything. Yeah, every time they question me, I told Mounk Tounk, hey, yeah, man, I just left down there, they trying to question, but they trying to basically put it on me. They trying to do that. Why they, I called him a squirrel brain back then. I said, man, that nigga did tell the story, so stupid. You know what I mean? Like, so, and I told it to Lady. Lady laughed at me like, boy, you crazy. I put it off on anybody to get them off of me because they keep coming at me. They keep trying to get me. They keep trying.
Earlier, did you say that I don't recall means I don't want to speak on it?
No, I said I don't recall because you're confusing me and I don't want it. You trying to make me lie. So you're asking the question in a way like you talking to me back there in a way I can comprehend you well. So even though I'm talking the way I'm talking, I can hear you, but I don't like my level of understanding is different. So if you taught me like how you taught me in a bad street way, then I can answer you better. But the way you ask me now is just like, it seems like it's a trick question. You want me to say something? Just straight up say it to me.
Last week, do you recall when Mr. Weinstein asked you about an interview that you did recently?
With DJU.
Yes. And that, I guess in the interview, you were thanking God that you were not on this indictment. Do you remember Mr. Weinstein asking you that?
Yes.
Okay. Why did you thank God that your name wasn't on this indictment?
You said, why I'm thanking God that I'm on that?
Yes.
Because how y'all keep locking me up? Like, y'all done lock me up. Y'all lock me, they locked me up for looking at the police the wrong way. Like, so to see y'all lock up everybody and I'm so traumatized by keep going to jail. I'm expecting to be, I'm already in jail at the time. So I'm already expecting y'all to come down there and get me again. So
I'm not entirely sure. Is he in jail at the moment or not? I have no idea.
The crimes that you talked about last week that you said you committed, you said that you
when I said,
shot up,
I'm sorry. Go ahead.
that you shot up Rich Homie Quan's dad's barbershop with threat. Do you remember?
I said it out of frustration.
Was that a crime that was done on behalf of YSL?
Huh?
Was that a shooting that was done on behalf of YSL?
Miss Hills, you know me. You know what I mean? If I do anything, I do anything on my own. Like, ain't no a crime on behalf of YSL. Like, I keep telling you, y'all trying to make YSL be a gang. And now a gang, you got shot callers, you got scorchers, you got leaders and all of that. Like, YSL a label. So if like how y'all got all these people in here or whatever, you can't say that, oh, for instance, I got charged, y'all charged me with a possession of a firearm and a possession of some pills. And the gang charge saying I had you because I'm a gang member. No, I'm not a gang member. I don't have drugs, had drugs because I'm a gang member. Like, but y'all making this stuff be what y'all want it to be because y'all can do that. But it's not right.
Back in 2015, did you have a beef with Rich Homie Quan?
No, I never had beef with Rich Homie.
And isn't it true that you told police that Thug had an issue with Rich Homie Quan because he brought some IF gang members to his condo?
No, Threat had issues with Rich Homie Quan.
I didn't ask about threat. I asked about what you told police regarding Thug having an issue with Rich Homie Quan bringing individuals from IF gang to his apartment.
Thug was protecting Rich Homie Quan. That's what I'm trying to tell you. So like I keep telling you, y'all don't have y'all facts together.
So I'm asking you a specific question. Did you tell police that Thug had an issue with Rich Homie Quan bringing members of IF gang to his condo?
Again, when I'm talking to the investigators, I'm gonna tell them anything to get them off of me. But as I sit right here, I'm telling you the gut and the truth that Thug, I had an issue with Rich Homie through threat. And about my partner, whatever he went on with, they don't have nothing to do with YSL. Y'all trying to make it seem like this has some, just because they don't have nothing to do with what I do and what Threat do, they don't have nothing to do with YSL.
I still think I heard answer. Did you tell police that Thug had an issue with Rich Homie Quan? I don't think you did. Oh, if you did, I did not hear you. So
I'm sorry. I said it. Thug was trying to protect Rich Homie. He was calling us saying that, man, hey man, leave Rich Homie alone. Like, yo, he don't tell me what to do.
So that's still the answer to the question. Yes, no, I don't recall. Did Thug have an issue with Rich Homie Quan bringing members of IF gang to his apartment?
So did you have an issue with Rich Homie?
I'm asking you for what you told the police.
And I'm answering you. I just told you several times. I tell the police anything.
Okay. Do you recall talking about the shooting at the studio with Rich Homie Quan's car last week with Mr. Sharp?
I don't know nothing about it.
And you asked him if he had proof. He asked you if it was you who did it, and you asked him if he had proof.
Right.
Why was that your response to his question?
I ain't answering it. I don't know.
Was that shooting done on behalf of YSL
What shooting?
at the studio? The one you asked him if he had proof of.
Yeah, because that was my first time hearing something about some shooting. I don't recall. I don't know. You talking about shooting at the studio?
All right. Now, Mr. Sharp, on cross-examination, I believe he said to you that you had time between January 11, 2015 and June 10th, 2015 to make up the lies that you told on your friends. Do you remember him asking you some questions around that?
Can you ask me that again?
Sure. Last week, Mr. Shard asked you whether or not you had between January of 2015.
Okay, Rick, can you sustain, but with regard to being able to hear you, do you have I think the mics might be working now, so pick it up and,
I'm going to.
yes, it
work-
works, yes.
I'm going to eject as a
Sustain.
mischaracterization of the testimony.
Do you recall testifying, because maybe I had the question wrong, about what happened between January of 2015 and June of 2015?
Can you ask it again?
Sure. Let me just ask you this.
Yeah, that'd be nice if you would just get to what you want to ask instead of whether he recalls what he said last week or not. I mean, just skip that part.
Thank you,
Just get
Your
to
Honor.
the question you want to ask.
Thank you. On January 11th, you did not tell the detective what you knew because you were trying to protect your friends, correct?
No, I told you I was raised to lie to the police. So if you look at my history, like police asked my name in the past. I told somebody else's name. No, I just do that for no reason. I walk down the street, police, what's your name? I say, I give my little cousin's name. Driving without license, what's your name? I give him somebody else's name. So this is how we raised up.
And in this interviews, all the interviews, you gave them your real name, correct?
Because they know who I am.
All right. And in all these interviews, you gave them your real phone number, correct?
Because you gotta understand, like, when you lying, you ain't lying to get caught.
But you said you just said you were raised to lie to the police. So, but you didn't do that in these interviews.
I did it to the ones who didn't know, like, know the information. Like, for instance, with Gaten knew my name and stuff. She knew my number. Why would I lie? And
But you didn't do that with Thorpe, correct?
yeah, because what I had to do that for?
And you didn't do
I
that.
had to. Go ahead, go
No,
ahead.
no, you go ahead.
Yeah, because it didn't take a rocket science. So they talking about a murder. This is serious. This is serious. So you gotta conquer it.
You didn't lie to Detective Curry about your name and who.
I don't know who that is.
The one who interviewed you after they shot at you, they shot in the baby.
I'm a victim.
All right. And in that June interview, when multiple detectives came and talked to you, you didn't lie to them about who you were, correct?
About who I was.
Who you was.
They knew who I was.
Okay.
They get to the point police don't even ask me my name no more. They just walk up on me. Yeah, they already know everything about me.
In January of 2015, you hoped or you thought that your friends were going to protect you out in the street, correct?
I've been protecting myself since I've been protecting myself.
By the time June came, Shannon wasn't talking to you anymore, correct?
That's a lie.
Okay. If Gang wasn't shooting at you, correct? If Gang was shooting at you, correct?
You know who's shooting at me?
People from If Gang were shooting at you, correct?
I can't say for a fact.
In June, you thought that Thug was trying to kill you, correct? In June of 2015.
I was gonna use that for a platform to start problems with. So I use people to, you know what I mean? I don't, to be honest with you. Yeah, I let people get in my head.
And by June of 2015, you thought that you were out here all by yourself, correct?
I still feel like I'm out here by myself. I'm just trying to just keep myself free.
And that is why you told the police what you knew or what Little D told you about Nuts murder, correct?
Like, you never told me anything. And again, if you ask me now, we can speak now. But if you want to keep going in the past, I'm gonna keep telling you the same thing. Like, I didn't tell the police anything.
Now, you've known that you've had to testify in this trial since, or that you were going to be asked to testify since about November 2022, correct?
The way y'all played it, man, y'all kind of kept me in a blind. But I in my heart, I feel like y'all probably was gonna call me, but people tell me, oh, well, not people, but I was hearing that y'all won't call me because y'all knew I was lying. So until the day you can't see me in Pittsburgh, that's when I like, oh damn, when the day you can't see me in Pittsburgh, I was like, dang, they for real.
And ever since you either heard about it in 2022 or I actually came to see you, you have not wanted to testify in this case, correct?
Say that, yeah, because I lied. I knew I lied. You can't put me up here to lie. Why you think I'm so scared because I don't know. I can't remember my lies. So it's just like, you don't know which one to lie and which one to truth. So you can easily be like, well, you lying, we'll lock you up. I ain't trying to go back to jail.
And for the last 2 years, you've been trying to figure out how you're going to get around having to face your YSL counterparts about what you told the police back in 2015, correct?
If anybody know me, they better be serious with me.
And you made up in your mind that you were going to tell this jury whatever it is that you were going to finesse, that you were finessing the police back in 2015, correct?
I had no intentions in saying in front of this jury. Y'all forced me to sit up here. Y'all gave me immunity. I told y'all I lied and I'm going to plead the fifth.
And because we forced you, you had to figure out how to finesse your way through testifying in front of this jury, correct?
I'm not finessing my way. I'm telling my truth. Like, and this is that.
Now, in 2015, you consistently said you told the police whatever you could to get yourself out of jail, correct?
Yes, ma'am.
And your finessing was about you getting out of jail, correct?
And me only.
It was never about protecting Thug back in 2015, correct?
And it still ain't about right now. It's like, and you might try to say I'm protecting him now. It's just my conscience. You know what I mean? My conscience knows this man ain't did anything. And I'm not trying to have it on my conscience.
Okay. But in 2015, when you talked to the police in any of those 2015 interviews, you always omitted your roles in crimes because that would make sure that you did not go to jail, correct?
I don't understand.
In 2015, when you talked to the police about crimes that you were involved in, you left yourself out of it, correct?
I don't know what you're talking about.
Okay. Because that would make sure that you didn't go to jail, correct?
What you mean?
When you talked to the police, you didn't tell them about your role in Rich Homie Quan's dad's barbershop shooting, correct?
Did they ask me about that?
You told them that Rich Homie Quan wanted to pay money for Threat to shoot up the barbershop, or wanted to pay people to harm Threat because he shot up the...
Yeah, because I'm trying to make the police believe that I can help them. So a lot of stuff I told them back then is just like, okay, I'm the key. I'm the one with all the information. You know what I mean? So that was my motive back then.
Okay.
So I was speaking on a lot of stuff that, you know what I mean? Like anything make police feel like, oh, I know all the business. I can tell them everything they want to know.
So again, you didn't tell them about your part in shooting up Rich Homie Quan's barbershop, right?
Did I tell them about my part?
Correct. You did not tell the police that you and Threat shot up the barbershop, did you?
So what, you gonna charge me now?
I didn't say that. I'm just asking you a question. Did you tell the police back in 2015 that you and Threat shot up the barbershop?
All right. PSA from funding member from 14 months. Put the phone down while driving. Yes, please do. Because otherwise you can end up like the daughter of Fannie Willis, who got herself caught with the phone in hand, with a suspended license, and Bonnie Willis revealed to the world that her and Nathan Wade still together. So put your phones down while driving. All right, let's continue.
No.
Right, because telling them would not let you get out of jail, right? If you told them that, you would get in trouble for that, correct?
Well, they might get hurt, so I ain't think no. My whole thing is lie to the police. I'm not going to tell them the truth about nothing that took place for real, especially what got something to do with me.
Also, you didn't tell them about your parts in the stolen items that were found in your house in June of 2015, correct?
They told me about the stolen stuff that they found.
But you didn't tell them about your part in those stolen items being found in the home, correct?
And Dunbar?
Yes.
Why would he admit to crimes he did back in 2015 when he had specifically now for weeks saying he lied back then to get out of jail? So why would he say things that would put him in jail?
What you mean?
You told him it was Little Mike and Quez, correct?
I don't get what you asked me though. I told the police that I gave them their names. Yeah, that's what you asked.
Lil Mike and Quiz. Yeah, remember who those people were? They don't exist.
Quiz in the line, they be strolling through Atlanta streets. Crimes unfolding, but here's the twist. They're just a myth, ghosts in the night. They don't exist. Streets are buzzing.
Quiz and Lil Mike, who doesn't exist.
So you did not tell the police about any crimes that you were involved in, correct?
I wasn't committing crimes on the behalf of nobody but myself. Anything I do is beneficial to myself. If that's what you're asking, I don't get what you're asking me.
Right. Anything is beneficial to yourself.
I don't take shots from nobody. Can't nobody tell me what to do. Nobody knows able to tell me what to do. I'm gonna do what I want to do regardless.
So when you were meeting with police, you did things that were beneficial for you, correct?
What do you mean?
You just said I did things that's beneficial for me. That's what you just said, right?
I'm saying like my anything. I'm a selfish person. If that's what you're asking.
So when you were in those interviews, it was all about self-preservation for you, correct? You want to do anything so that you did not go to jail, right?
That's what I said.
Okay. So even if that meant telling on your friends, that's what you were going to do so that you did not go to jail, correct?
No. Telling on my friend would be like, okay, Bobby robbed this store, and Bobby did rob the store, and it's proof that Bobby robbed the store, and I was with Bobby when he robbed the store. But making up things saying, okay, Bobby shot Tony. Bobby was over there somewhere else where he could prove that he had nothing to do with it wouldn't make sense. They're just getting the police off me. That's what I was doing.
So the finesse was, I'm going to tell the police what I know about the murder because that's going to keep me out of jail. But I'm not going to tell them what I've done because that's also going to keep me out of jail. Correct?
No, my whole thing was, I don't got nothing to do with nothing, and nothing got nothing to do with me. So when I'm talking to the police, they're so convinced that I did this crime, and they're not going for the stuff I don't told them in the past. So I'm just keep trying to talk my way out of it, and I'm making stuff. I'm stupid at the time.
And the finessing that you did to police back in 2015 is always and only was going to be about you and what you needed, correct?
I don't get what you're asking me.
You told Mr. Weinstein last week that you were a BSer. Do you remember telling him that last week?
You told me that yourself one day we was in the back talking.
Do you remember telling Mr. Weinstein that last week?
Yes.
And right now, you're still trying to finesse this jury because it's still always about you, correct?
I'm not trying to finish this jury. I'm trying to, because other two trying to get up out of here so I can move on with my life. And that's it.
You're still YSL, correct?
What you mean? Am I still YSL?
And you're still YSL for life, correct?
I don't get what you're saying. Like,
you're still YSL for life. That's what you said in the off the porch video, correct?
But you're trying to make it seem like it's a game, though. My only purpose is it's not a game. So you saying what you're saying. If you drop the game, like, you confusing like a more.
All I'm asking you is, are you still YSL for life?
Am I still YSL for life?
Yes.
I don't know how to answer that. Like, I don't know.
And what you're doing and what you've been doing for the last couple of months that you've been on the stand is you're still trying to stay loyal to YSL, correct?
If that was the case, I wouldn't even be up here lying on them. If I'm trying to be loyal to them, I wouldn't be trying to lie and put the blame off on them.
And you feel guilty now because you told the police what Shannon, Yak, Thug's involvement was in the murder of Donovan Thomas back in 2015, correct?
No, ma'am. I feel guilty because I have put my hand in some stuff that I should never even done. It's a difference. Like I keep telling you, if I knew that these boys did this and that I saw them do that, and I can say for facts they did this.
And matter of fact, in the October interview, October 2021 interview, you talked to Investigator Viverito about what you told police back in 2015, correct?
Oh, all right. It seems like Miss Hilton watched Mr. Shard's final half hour, 45 minutes, and tried to replicate it. Not doing good, are you, Miss Hilton?
Probably so.
And you talked to her about the fact that you feel guilty. Do you recall doing that?
I said, I thought about, I do. I have a conscience. Like, you know what I mean? Y'all caught me in a vulnerable, in 2015, y'all caught me in a vulnerable state. And then, you know what I mean? I was going through a lot. I have done so much stuff. And it was just like, and police got me, and I'm trying to throw the blame off on other people that I should never did.
And in 2021, 7 years later, you told investigator Verito what I told you back then was the truth, correct?
Because you gotta understand. So I know you don't know. Verito, those people touch us. You feel me? Like they literally sit there and follow us around and pull the car over, lock us up because they know we don't have a license. Like they constantly do that like on a daily basis. So when I'm in front of them, I already know they about to lock me up. And I'm just Verito, she's better than Gaten because she know how to play on you good. And I knew she was playing on me, and I was trying to play back on her. I was trying to convince them that I would be truthful with them.
And did you tell her that I told them everything in 2015, but no one ever helped me out?
I never needed nobody else because my only thing was, shit, I knew they was playing on me, but like I said, they sitting here, I didn't want to go to jail. If I could prolong it out, or they go for what I'm saying, then hopefully I could get out of here.
So what you're saying, what you told investigator Verito was not the truth?
What I'm telling you is, I mean, June, whatever date you said, when they questioned me, I have made it up. I told you that before you put me on the stand in front of the jury. The jury didn't even have to hear or see me. But y'all still forced me up here. I told you I was going to plead the fifth, and y'all like, why would I plead the fifth? And I told y'all why, because I lied. So don't put me up here and expect for me to say something that is a lie. If you ask me the truth, and I can tell you the truth. And the truth is, I didn't see these boys commit no crime. I'm not trying to protect nobody. I don't even know some of them over there.
Your Honor, they would like to send Stacy Exhibit 378, Yankee, Frank, and play portion of the October 2021 interview. All right. Well, first.
You may. Tell me that number again also, please.
Yes, Your Honor, 378, Yankee, Frank.
Okay.
Yeah.
Any of y'all need
Guess what that is? It is Sidebar counter 229. Oh.
I can leave out.
yes, thank you.
How long?
Just stay for 5 minutes at least. Probably more.
Yes, I am. Still counting sidebars. There has been fewer since Judge Whitaker took hold of this, but still ongoing.
All right, so yeah, Mr. Short, you were saying that this was not one of the statements that we had kind of litigated in detail or at all, and I think that's right. And Ms. Hilton has 4 specific little excerpts that instead of trying to sort that out up here, let's just, if you'll go ahead and put on the record what those are and let the defense attorneys have a chance to see what you're talking about and whether there are any objections that we need to go ahead and sort out without the jury being present.
And we can play it right now. There's only about 2 minutes in total, Your Honor, the 4 sections.
I'd really not want to hear it 2 and 3 and 4 times if necessary. If we've got a transcript of it, do we have a transcript of it? Do the defense attorneys have a transcript of it? All right, just reference the page numbers.
Yeah.
And Your Honor, I have a copy for the court.
Okay, thank you.
Yeah, the judge doesn't really want to litigate by listening to the damn video anymore. She's done enough of that.
Page 12. Investigative research about what?
I can read it. I mean, we can all read it. We don't need you to read it out for us. Issue is to that, and it may be that there are some unintelligibles that aren't unintelligible that might be problematic. So I guess that part you could fill me in on.
I would need to go back, but I believe essentially he's saying I told them everything that I knew back then. That's the way he's talking about.
Okay.
Why is it being played? Why is the out-of-court statement being played?
Your Honor, it's impeachment by contradiction. Mr. Copeland has, again, testified that everything he said in 2015 is a lie. in 2021, they can see his demeanor about how when he's talking to Investigator Viverito, Investigator Flores, he is referencing everything he said back in 2015 is not a lie, that he gave them information. He gave them what he knew about what happened in 2015. And so this would be a contradiction of what he's now testifying to in court.
Okay, all right. By the time this is going on in 2021, right? This
Yes.
interview with Viverito?
Yes.
So he's given all of the 2015 statements, right? The January and February ones, but also the June one.
Correct. And he's now telling them what I told you all back in 2015 was true. Like I told you these things. I told you what I knew. And he says them multiple times in this interview to again negate this idea that everything he said in 2015 is a lie. In 2021, he's telling the police when he's in custody, I told you things in the past that were true, and I ended up getting tortured. This is, and you're right, we did actually talk about this statement last week, because this is on the heels of us discussing, it's in this interview that he discusses the plot to kill Shell Kell. And we talked about the fact that the state could not get into the fact that he plotted on Shell Kell or that he knew about a plot to kill Shell Kell, but there were specific areas that we said we were going to get into. We weren't going to talk about the Shell Kell plot, but in this interview, he talks about the fact that what he knew in 2015 was true or was accurate, was verifiable. And so that's what this portion is, Your Honor.
I guess I don't agree with the state's characterization of his testimony here today. He's saying that he has lied on these gentlemen in the past, and he is in court telling the truth, and that it was a lie before. I don't recall him specifically limiting when he lied or how he lied. So to me, this is just bolstering, and it's just pointing out that he's made the same statement more than once, which I don't believe that is a path to admissibility.
The fact that he is now saying in court in 2024, I lied to the police. In 2021, it's a prior inconsistent statement because he's telling the police in 2021 that what I said back in 2015 is true. So now
No, he's not saying it's true. He's saying that's everything I knew. And what he has said on the stand is every time I have ever talked to the police in my entire life, I have lied to them. And that would include this 2021 interview. You haven't had him say that yet, but
that's the point, right? When he says here, I didn't have any parts. What I did was I heard after the fact things. I said everything I knew when
let him. He's not going to be able to take that down.
Sorry. And I said everything I knew when I went through that. He's now telling this jury, I never told the police anything Little D told me. What I told the police about what Little D told me is a lie. This is what he's saying now. What he said in 2021 is, I told the police everything that I knew, which is what Little D told him.
Well, that's your version of it.
But when you continue to look at the other sections, Your Honor, that will illuminate.
Okay, let's look at the next section.
The next section is page 28, line 15 through 16.
Oh, I was running low on my nicotine pouches, so I brought a few more because I have a lot to go through.
Talking on lines 15 and 16 about the same thing that we've been talking about here in court. That appears to be about something else, doesn't it?
No, so that's what I said, Your Honor. So this interview starts with Copeland going into, after he's arrested, he goes into the interview and he's like, I have information I can provide.
Right.
The information that he can provide is about a plot to kill Shell Kell.
Mhm.
So when you get to page 55 and he starts at line 12, there's a murder.
We want page 28.
Excuse me, page 28, line 12.
Okay.
When he starts there. This is a murder that's about to take place with some very bad people. Bad people. The stuff that I know right now, you know what I mean, should be good enough, I think he says, to get out of my situation. You know what I mean? I'm not bullshitting. You know the last information I gave y'all was right. The last information that he gave was about 2015. That is what he's talking about here. And then I can further
Do
continue.
you have something that establishes that that's what he's talking about?
Yes, he tells Investigator Viverito, I think earlier, and I'll find the page.
Oh no. 2015 is not the last time he talked to cops before 2021. He has interviews and been in jail and in prison many times between 2015 and 2021. It might be that he's talking about something completely different.
Because he keeps bringing this up in front of Investigator Flores. Investigator Flores doesn't know about what happened in 2015. So Investigator Viverito says, are you talking about this stuff in 2015? He wasn't here. So you have to give him some more information because Flores wasn't around in 2015. So the context of this is he's referencing what occurred back in 2015.
So where's that part?
Let me find it. Before you get to page 12, when he gets into the interview room, he's about to get arrested, and he begins to tell them that he has information about some stuff that's going on tonight, getting ready to happen tonight. He then proceeds to tell them he's not going to give up a lot of information because previously when he's given up information, no one ever helped him out. So then he proceeds to give a little bit of information, but to say, I'm not going to give you much because when I've done this in the past, no one has helped me out. So what he's talking about is in 2015, when he gave information to Gaither and Dennis, no one helped him out. He still had to go to the feds. He still had to go to jail. So throughout this interview, when he makes references to
That doesn't mean that he's talking about 2015.
the past, he's making references to what he told police back in 2015.
That is an assumption, not actually substantiated by what is actually said.
When was she explaining to Mr. Flores? I'm getting this on page 12, Your Honor. At line 25, going to page 13, line 2. And Flores says, because you know I wasn't there, this is my first time meeting you. So he's talking about, was talking about 2015, and Flores doesn't know what he's referencing because he wasn't around in 2015 when all this stuff occurred. And that's why he says, you have to fill me in. And so that's when he goes into the paragraph that we want to play, which is start at line 12.
I'm not so sure. Hi, Tivo.
Yeah, I'm just looking for
finding my
anything
channel.
that lets me know or lets me have any comfort that when he says, I told him everything I knew about this situation last time, that's everything I knew, that he is talking about whatever he told police in 2015 about the Donovan Thomas murder, because I don't see.
Exactly. There are no specifics. What's the prosecution trying to do here? Entering evidence on the false presumptions, as they have done so many times before.
Any reference to that before he starts saying this.
So
Reminder, folks, this is a recap. I'm going through day 100.
I mean, he's saying
21, 22,
on page 9, they're saying you want to
and
talk about today.
correct, Your Honor, but when he's talking about the last time,
Yeah.
I think that Mr. Copeland, there are no other interviews between APD and Mr. Copeland between June 2015 and October 2021. So he does not ever meet with the Atlanta Police Department ever again until this occurred. So when he's getting locked up, he's referencing, and he even talks about Gaither, and I'll find where he talks about Gaither in here, that he didn't trust Gaither or Gaither.
You don't know that, because there are plenty of examples told by both the prosecution and Mr. Copeland when they were calling him, not in interviews. So no, I don't think you have.
Didn't help him out essentially. And so his whole reference is about 2015. Even if we continue to page 144, line 25 through 145, line 15.
So what does he say on 9 through 10? Everything I knew about what happened with that unintelligible situation.
Are you on page 144?
145? I mean, I do see he says everybody felt I had something to do with it. So that at least is some kind of circumstantial indication that he might be talking about the Donovan Thomas murder.
And if you give me, of course, it doesn't go 27.
Yeah.
23.
Mm-hmm.
Answer your question. According to my notes, the unintelligible on line 10 is same.
Is what?
Same.
Same.
Yeah, with that same situation.
Okay.
And then I also talked to you that he talks about Gaither.
All right.
And then, Your Honor, he mentions Gaither last page.
All right. And so is your position that he's essentially like protesting in this interview? Look, I told y'all what I knew, which was the God's honest truth the last time, and y'all didn't do anything to help me. And that establishes that he, at least in 2021, and your position is saying what I told you in 2015 was true. And that's inconsistent with what he's saying on the stand today and the past few weeks, which is everything was a lie.
Yes.
I mean, whether that actually accomplishes that or not, I guess will be up to the jury, but
Well,
yes, sir.
before it gets to the jury, I just don't know of any rule of evidence that allows someone to reiterate in between the time of the original statement and testifying. Okay, we'll say those two things are inconsistent. I don't know why a statement made in between those two times would be admissible as either a prior inconsistent or prior consistent statement. It just seems like we're at this point using another out-of-court statement to bolster the June 10th, 2015 statement.
So I think the state's position is that Mr. Copeland is now saying, he's now disavowing everything he said in 2015 and saying all of that was a lie. And it's only here today that I'm telling the truth. Everything before was a lie. And here is something prior to today that is him saying the exact opposite of what he is saying today.
Yeah, but then also between 2021 and now, he has told the prosecution and investigators on numerous occasions that everything he told back then was a lie. So, yeah, your courts have weird rules.
So it is inconsistent in that way.
Prior statements certainly has happened, and he's disavowed it. To me, as I've listened to the testimony, he hasn't specified, oh, I disavowed the June 10th, 2000. He said every time I talk to the police, it's a lie.
Mm-hmm.
And I don't know what playing another statement, which he's already saying is a lie, what that is accomplishing. I just don't see to me, the state needs to outline a path, an exception to admit a out-of-court statement. And I'm not seeing the exception to the general rule that out-of-court statements would not be admitted into trial.
Do you want to speak to that, Ms. Fulton?
I believe that the court said in its analysis that you just gave, what he's saying in court now in June of 2024 is inconsistent with what he has said in any of his interviews to police. And in 2021, 6 years after he gave his initial statement, he is still telling the police in 2021, what I told you in 2015 was true. You all didn't help me in 2021. What I told you all then is what I knew. I gave you the information. That is inconsistent with what he is saying now in court, that he's just finessing the police, that he's just telling them whatever, and the jury can determine if they believe what he's saying now in court, or if they believe what he told the police back in 2015 and in 2021. They can make that decision. But this is an inconsistent statement with what his court testimony is.
But isn't someone in 2021 saying what I told you in 2015 is the truth, was the truth? Isn't that exactly what we don't allow in the trials, is someone self-bolstering their own statements? Like, I mean, if I make a statement and then I just go around town and tell everyone, hey, that statement I made is the truth, that statement I made is the truth, are we going to have a trial where we call in 100 people to say I said it was the truth?
Yeah. So, I mean, Ms. Hilton, is your position that even though he is saying on the stand, everything I said before was a lie and what I'm saying today is the truth, that it's in fact the opposite of that?
Yes. What we believe that what he told the police back in 2015 and in 2021 was true. Like that's the state's position.
And that he is now, you believe, lying on the stand.
Correct. The state believes he is lying on the stand, saying that what he said back then isn't true. But even
and that his motive for doing so is,
we believe his motive for doing so is that he's now present and has to deal with what he said back in 2015, now sitting in front of the individuals he tested or he talked to police about. He now has to confront his own statements in front of these defendants who he talked about back in these interviews in 2015.
and so he's trying to wiggle out of it.
He's trying to wiggle out of what he told the police back then, back in 2015. And furthermore, in 2021, he's asserting again what he said back then was true, but now he's trying to tell this jury that everything he's always said is a lie. But in 2015, with no prompting from anyone else, he brings up what he told police in 2015. Investigator Rito didn't ask him about what he said in 2015. With his own prompting, he told the detectives his first line, which is on page 12.
All right. So I think that this would come in under 24-613 C, that essentially right now he has, and I'm not saying he does, but the state's position is that he currently
was taking care of your daughter, correct?
Correct.
All right. And you would agree that at least back then in 2015, you loved her?
Can you say that again?
Sure. In 2015, you loved Deshaun, correct?
I still do today.
All right. And you cared about her, correct?
I still do today.
And back in 2015, Deshaun was the person who was trying to get you a bond. Like she was trying to help you get a bond, correct?
How she gonna do that? She's not the judge.
No, she was trying to get you the money for the bond, correct? To help pay
Oh,
the
she was
bond?
doing what I asked her to do.
Yeah. And she's someone that you confided in, correct?
What you mean?
She's someone that you talked to, that you trusted with what you told her, correct?
I don't trust nobody.
But Deshaun was someone who can see right through you, correct?
You can't even see right through me.
I'm not talking about me, I'm talking about Deshaun.
No.
Deshaun isn't someone that you could finesse, correct?
Say that again.
Deshaun is not someone that you can finesse, correct?
She's not somebody I can confess.
Finesse.
And what make you figure that?
And in 2015, you talked to her repeatedly on these jail calls, correct?
Yes.
And you talked to her about what you felt.
I thought about what I felt.
Yes. Your feelings.
All right.
You talked to her about your interviews with the police.
I'm listening.
You talked to her about what you told the police, correct?
Here she go again. She knows this is going to rile him up. Talking about his baby mama who is no longer with us.
I talked about what I wanted to tell her.
And you told her everything that you were feeling back in 2015, correct?
No.
Right.
I didn't. No.
I want to play for you what's already been admitted as Stacey Exhibit 394. Why? And I'm only going to play from 7:50 to 11:24.
Right now?
Yes.
I have no interest in that.
See if you can play the.
Oh, sound issues. Sound issues. And a break, and they're back.
Queued up with what you want to, assuming we have sound that stays with us. We don't know why, but the first sound system took.
Shit, I'm the only one ever getting shot at.
And when you said you're going to rap about it, put their names, who did it?
Huh?
When you said to Deshaun, why the hell would you put these songs out there and have folks really think I did this shit? You feel what I'm saying? This N word, no, this N, no for a damn fact. He should have put these N name in it. You want to rap about it, put their names, who did it?
All right. So if you go back and look, I said it after the interrogation. So anytime before that, and I was in jail, I never said it. I knew that they were gonna be listening to my calls.
Okay. You said, you feel what I'm saying? Don't put my effing name in no shit. Did you tell Deshaun this?
That's what it said.
And I'm trying to be with my family. I ain't messing with, well, you didn't say messing. I ain't fucking with these N-words, bro, period. Only reason I called them just to see something. I don't want these folks to do nothing for me, bro.
That's what I said.
And who didn't you want them doing anything for you?
You talking about 10 years ago?
Then you further said to her, I had nothing to do with nothing. I was at the house sleep. These N-words did this shit. I had no problem with this N-word nut, bro. This shit's so crazy, man. They had a problem with Thug, bro. Who had a problem with Thug? Nut and them? And your response was Kel and them, correct?
That's what I said.
And this is what you're telling Deshaun, correct?
That's what we just heard.
The person that you trust and the person that you confide in.
And you heard her keep telling me, why am I lying? She said she see right through me, right?
She didn't say that on this call, though, did she? Did she say that on this call? Did you hear her say that on this call?
Oh, I heard her say it. So
Did you hear her say it in the call?
now the clip you just played.
All right. So next I want to play for you State's Exhibit 407Y. And we're going to start at 3:28.
Well, I do remember another call when she saw right through him. So skipping ahead.
Hello.
10th, you told Deshaun, not say June 10th, on that first call, you told Deshaun again that when D comes down and tell them, they will see that you're not lying, correct? You testified to this jury that Demikian never told you about Nuts murder, correct?
That's what I said.
Okay. So which one is it? Is it what you told Deshaun on his jail call, the woman that you love, or what you telling this jury here today?
What I'm telling the jury today is that Ladie never told me that.
Okay. But that's not what you told the mother of your child in a jail call back in 2015.
And you heard her telling me to stop lying. So she know that how I am. You
Did you hear her say stop lying in the call I just played for you?
she said, what are you telling 2 minutes? Like, just stop. You heard her, man. She get no different treatment from nobody else. I'm not trying to drag her in nothing I got going on.
And what were the houses that you were referring to when you told her these houses getting shot up?
Whatever houses that were being shot up.
Do you know which ones you were talking about in this particular?
No, I do not.
And what guns were you talking about?
None.
So why would you tell her that?
Because I mean, I'm in jail. Like, I don't know.
Isn't it true, Mr. Copeland, that when you talk to Deshawn, she's not the police? She's not anyone you have to finesse? That you told her exactly what was happening back in 2015?
Miss Hilton, you heard her say that her mouth. Why am I keep lying? I did say this. Why am I switching my? You doing it to yourself? Just stop.
In these last 2 calls, she never said anything about lying, did she?
No, she didn't.
And Mr. Copeland, is it fair to say that you still love Shannon?
Yes, I do.
You still love
Yes, I do.
and you don't want anything, and you don't want your testimony to hurt them, correct?
It's not about hurting them. I told you I lied. It's the truth. I lied.
I have no further questions.
All right, does anybody have recross?
Oh, that was weak. That was intensely weak. I mean, she didn't get anywhere, in my opinion. But her going into his baby mama like that, that's just bad. That's just bad.
Go ahead.
All right, recross.
Good afternoon, Mr. Copeland. I'll be brief.
Okay.
You recall this morning, Ms. Hilton spent a lot of time going over the fact that you're a liar, correct?
Yes.
And you told Ms. Hilton that before you ever testified to this court, correct?
Correct.
I did not call you here as a witness, right? You didn't receive a subpoena from me.
I haven't spoken to none of y'all.
Okay. You received a subpoena from the state to be here.
Yeah, from Miss Hilton.
Thank you.
Anybody else?
Yeah, that is that's all that on cross. I understand why they didn't go with that option. On recross, yeah, you're a liar, right? Yep. Enough. Doug.
I want to make sure we're all on the same page here. Your testimony is that what you told. Gotcha. Can you hear me now?
Yes.
Okay. Thank you. Remember, we went through your statements to the police in 2015, correct?
Correct.
All right. And you remember we pointed out the first time that you said that you had heard, first time you had claimed that you had heard that my client Shannon and Mr. Kendrick and others were responsible for Donovan Thomas. The first time you claimed that was June 10th of 2015, correct?
Yes.
Okay. And you claimed that your source of information was Demekion Garlington.
That's what I told the police.
That's what you told the police. And you have made it very clear, I think, that your testimony is that was a lie.
It is.
Right. Now, what I want to make clear is your intention at the time, June 10th, 2015, you were being arrested.
Yes.
That was the reason for the finesse, correct?
Yes.
Okay. And your intention was that Demekion Garlington, Lil D, was going to back you up.
That's what I said.
Okay. And I want to be clear that the statement Shannon, Yak, Duop, and Nard, you were asked by Ms. Hilton if you told that lie that you made up on June 10th, you were asked if you had shared those names with anyone else. And I believe you said with Little D, correct?
Yes.
Okay.
You said I shared the names with him?
Yes.
Yes.
Characterization of the question.
Okay.
You want to rephrase?
Those 4 names that you made up, you shared those names with Lil D, correct?
That's what I said.
Okay. And I'm not worried about what you said right now. I'm asking for the truth. So you shared those names with Lil D.
Y'all confusing me at this point, man.
I'm not trying to confuse you. You needed, in your mind, you felt you needed Demekion Garlington to back you up, correct?
That's what I thought he was going to do.
Okay. And you needed to share the lie you made up with him, correct?
I told the investigator that Ladie will come kill me.
Right. And so you shared the information that you gave to the investigator, the lie. You shared that with Lil D, correct?
I shared it with Mounk Tounk too.
Okay. And you, I believe your testimony was Lil D, after you shared it with him, said, "Damn boy, you hell." Is that?
He said, "Yeah, my bet."
Do you know If you know, do you know who Mounk Tounk might have shared that information with, that lie with? If you don't know, you don't know.
Yeah, I don't know.
Okay, do you know who Mr. Garlington, Lil D may have shared that information with?
Well, I thought you were gonna tell it to the police, but I guess you didn't.
Okay, do you know who he shared it with? And I'm not asking you to speculate. If you don't know, you don't know.
I don't know.
Okay. We just played some jail calls from 2015, correct? They just did. Yeah,
I guess.
all right. And that was 394 Yankee, I believe, was the exhibit number. Every time you speak on those jail calls from jail, every jail you've ever been to, they play a recording in the beginning. A lady's voice comes on in the beginning, right?
Your call is being recorded.
Right. You know your calls are being recorded, correct?
Right.
You knew in 2015 your calls are being recorded, correct?
I knew before you went to jail.
Right. That's common knowledge, correct? Right. Okay. And obviously, if you're being recorded, you can control what you say on recorded line, right?
Right?
So you can say things like, Lil D told me this or that, right?
I can say whatever I want to say.
Right. What you can't control is what the person you're talking to says. Like when Deshaun said, you're a liar, you're lying, you switched it up. That's the part you can't control on the jail recorded calls, right?
Well, you know that.
Talk about recordings. Let's move to meetings with the district attorney. You talked about several times the district attorneys, members from the district attorney's office coming to meet you in jail and in prison too, right? Federal?
Not federal,
Okay.
but state.
State jail
No,
and
no,
state prison?
County jail.
County jail. Okay. Rice Street
Fayetteville.
in Fayetteville. Okay.
And Verito came to Rice Street.
Okay. Viverito had a, when we say Viverito, we're talking about investigator Viverito.
Yes,
She had a cell phone, you said.
she did.
Okay. Now you didn't have, you're in jail. You don't have the ability to record your meetings with the DAs in jail, do you?
No.
Okay. Do you know if they recorded those meetings?
The one in Fayetteville, I thought I caught Verito recording me, and then I started watching her phone.
Have you ever heard the recordings of the DAs when they came to meet you?
No.
Okay. What about in judges' chambers? You ever hear a recording of that?
What you mean?
A recording, an audio recording of that meeting?
You talking when I recorded them?
No, I'm talking about June 10th, 2024. You ever hear an audio recording?
No.
Okay, so the state has been playing recordings of phone calls you're making from jail, right?
I don't
The
understand.
state has played phone calls, recordings of phone calls you've made from jail. We just heard some, right?
Yes.
Okay, but do you know where the recordings of the state meeting with you, those meetings are? Know
Objection.
where those recordings are?
Human facts not evidence.
Sustained.
Okay, let's talk about the warrants for the murder of Donovan Thomas. Okay, you acknowledge that you were charged with the murder of Donovan Thomas, correct?
They charged me.
Right. And when you say they, let's talk about that. When you say they, you're talking about Detective Thorpe, correct?
So I'm talking about the police, the DA. I don't know who did it, but they told me I've been charged with murder.
Okay. Do you remember in 2015, we talked about it, you gave statements about where you were that day, right? That you felt cleared you from the murder.
I did.
And you also lied to the police about Demekion telling you certain information,
But I don't say that for like being time.
right? And you would agree that if someone were to believe that lie, it would have cleared you from the murder, right?
I don't get what you say.
Speculation.
Sustained.
Okay, well, let me ask you this. Detective Thorpe, he took those warrants out on you in October of 2015, correct?
He took them out on me.
Yeah, so after all of those interviews, Detective Thorpe didn't believe him. He charged Woody for that murder. So how does that compute with the state now saying everything he said back then was truthful? Well, not according to the investigator who didn't believe a word. Right?
While I was in jail.
Right. After you gave that statement on June 10th, 2015, right?
Some months after, yeah.
Right. So he heard what you said on June 10th, 2015, and then months after that, he took out warrants for your arrest.
You said it again?
He heard what you said on June 10th, 2015, and then months later, warrants were taken out for your arrest for that murder, correct?
Yes.
And finally, may I approach the evidence, Your Honor?
Yes.
Mr. Kokomo, could you play that prior testimony? Do you remember testifying about do you remember when I stood up there and talked to you about your pending charges that were dismissed?
Yes.
Okay. Could you play that clip, Mr. Kokomo?
Like I listened to it?
If you would.
You're right. He said he remembered it, so I would.
Is there some reason we need to hear it again? Can you just ask him about it?
Okay. Yeah, I can.
Okay, let's do that.
you remember I was standing right there and reading the sheet?
Yes,
Okay. I was reading the sheet and you were agreeing with me, correct?
correct.
Okay. And I never said that Fonnie Willis signed the piece of paper, did I?
You say who name is that?
Okay. Mr. Copeland.
The prosecution earlier in the cross-examination made a big number out of the person signing this. That's not Fonnie Willis, is it? Well, you're in for a treat.
Mo, could you publish 27D?
Now, I cannot for the life of me get why the prosecution are this stupid. Oh, you're going to like, if you haven't seen this yet, you're going to enjoy this one.
Okay. And Mr. Copeland, I asked you if Fonnie Willis's name was on the decision of district attorney declined to prosecute defendant. And that's your name on the sheet, right, Kenneth Copeland?
Yes,
Okay. And I asked you if Fonnie Willis's name was on the sheet, right?
yes,
Okay. And the sheet starts out, comes now, Fonnie Willis, district attorney for the Atlanta Judicial Circuit, state of Georgia, and shows this honorable court the following, correct?
Yeah. How about that, prosecution? You made this huge number. That's not your signature, is it? Her name is word number 3 and 4 on this. Comes now Fannie T. Willis.
correct.
And it's signed by another man named Kenneth Hutcherson, whose title is labeled as executive district attorney, correct?
That's what she just showed me.
All right. And you know Miss Fonnie Willis to be the elected district attorney of Fulton County, correct?
I think she's like the head person.
The boss.
Yeah.
Mr. Hutcherson's boss. Let me ask you, this was from 2021, right? When you were first charged with this false statement and false report of a crime. It was 2021, right?
When I was in jail.
Yes. Okay. Who was the attorney that got this case dismissed for you? Who was your attorney on this case?
You?
I was?
You told me?
Did you ever hire an attorney on this case?
No, I'm saying you told me.
Okay. Well, let me ask you, what advocating for yourself did you do that convinced the district attorneys to dismiss this case in January 2024? What did you do to get them to dismiss it?
Sustained.
Mr. Copeland, you've said in your testimony that you've been the police have constantly sent you to jail for things you didn't even do, right? Right. The state has prosecuted you time and time again for things you didn't even do, right?
Yep.
People are picking on you, right?
Yep.
And then in January 2024, your case just got dismissed and you didn't even do a darn thing to make it happen, huh?
You told me. I didn't know.
All right. Thank you.
Yeah. The assumption Mr. Charlie is trying to convey here is that this is the prosecution handing him something and at the same time holding it over his head. You better testify as we want you to. She's arrayed. Hello, she sees. Hey, good to have you here. I'm doing a recap of this week in the Young Thug trial. Let's continue.
The recross.
With the court's permission, I'd like to publish 378 YD. It's in evidence already. Shannon Stillwell 24F as in Fox. It's 622-59 through 624-01, a minute and 2 seconds. Mr. Copeland, can you listen to this? And this is February 21, 2015. If you need better headphones with the court's permission, we have other ones if you need it.
All right.
I got somebody from his name. He killed him. He called the night. Well, I forgot what day they got killed with. It was a Friday night. They had murder Thursday night. They had a barbecue. The barbecue just about it was bloody. Everything bloody. And the whole meeting was based upon me.
I can't understand what I'm saying.
Is that okay? Thank you. Would this possibly help? Is that what you're saying?
I'm saying I can't understand what I'm saying. We can give it a try. I don't know.
No, may I approach?
Yeah, you can put it on.
You keep your knee.
For is any mention of Jeffrey Williams?
He called the night. Well, I forgot what they got killed with. It was a Friday night. It was Thursday night. They had a barbecue. The barbecue just about it was bloody. Everything bloody. Then the whole meeting was based upon me. They were all in there talking about this and this, talking about this and this. So the nigga Mo was on the phone. So Mo told everybody, all I need, every last one of y'all, whoever 90s scraps here, whoever else nickname, supposed to kill me. They gave all of them guns. The same night they every last one gun. Say treat me to a gas station and kill me. I forgot whatever. But he called me, he told me everything he said. Is this person in front of yours?
Did you hear anything about Jeffrey Williams or Young Thug or anything like that?
No, I didn't say nothing about him.
All right. And when the prosecutors asked you questions about your jail calls and Jeffrey Williams putting you in songs, do you know any other song that you are referenced in that Jeffrey Williams is featured on or performed with your name except Halftime?
You said do he got any other songs with my name in it?
Yes, sir.
Yep.
Which song?
Beat It.
Anything else?
I don't know.
Okay. All right. And then when you were questioned by the prosecutor about Monday, June 10th, 2024, coming from DeKalb County Jail to the chambers of Judge Glanville, do you remember those questions?
Yes.
With all of your time, Judge Glanville was there at that meeting, right?
Yes.
All of your experience and horrors with the criminal justice system, all the arrests and prosecutions, all your convictions that are in evidence, tell the jurors another time that you found yourself speaking about the case with the prosecutor and the judge and your lawyer.
Never.
You said that you were coerced and pressured. Do you remember using those type of terms to testify?
I am.
Do you remember being told, and I know it's corrected by the Honorable Judge Whitaker, but do you remember being told by Ms. Hilton and Judge Glanville that if you don't testify, you have to remain in jail, not only until this trial ends, but all 28 people who are charged in this indictment resolve their case? Do you remember being told that?
No, they told me indefinitely. Whatever they word, they don't sound like a good word. And I asked her to explain it to me. And then he explained it. And then she broke it down to me that every defendant, so that means the people that go to trial next and all of that.
Okay.
And it could take up to so many years and you're not about to sit in jail all them years.
And Judge Whitaker said that's not correct and corrected it, right?
Huh?
Later, the Honorable Judge Whitaker corrected that, said that's not true.
I didn't hear her.
Okay. I want to ask you, and if you need those, if those help, the headphones, I want to talk with you about the jail call. It's stage 295Y, as in yesterday, starting at 350, Your Honor. That's wrong. It's a little later. It's 407 to 420. I wonder if you can focus, if they help you, if it's they swear to God we killed Nut, so they going to stay on you. And at 411, they swear we smoked Nut. If you could listen to this.
Baby, yo, swear to God, we killed Nut, so they gonna stay on you. Hello. Stay away from shit, bro. You don't know it be your hood, bro. Your hood scared you, bro. Don't.
Were you able to hear that better?
Yeah, real good.
What was said? Tell the jurors, and they could listen to it their own at their leisure too.
Which part?
Both parts. When Max was speaking, who you call Max,
Mhm.
Jeffrey's sister,
She
What did
said,
tell the jurors.
they gonna swear to God we killed Matt. She said, Nut. She said, can I hear it again?
Of course, with the court's permission, Your Honor, we're going to replay. And that again is the same exhibit 295Y, and it's from 407 to 420.
Baby, yo, swear to God, we killed Nut, so they gonna stay on you.
Swear to God, we killed Nut, so they gonna stay on you.
Say it one more time.
Swear to God, we killed Nut, so they gonna stay on you.
Did it say they swear to God, or did you hear it? What did
Huh?
you? I apologize. Did you hear they swear to God we killed Nut?
Objection, asking.
So that's how Dolly talk.
Sustained.
Explain it. Explain what you were going to say.
She talk fast. So when he's on the phone, she's like, they swear to God we killed Nut, so they gonna stand on you.
And then Mr. Kokomo, with the court's permission, is going to continue. For that other person speaking, it's a man's voice. If you know who it is, tell the jurors and what that person said, if you can tell. That's at 411.
Look, they gonna stay on you.
They swear he smoked Nut.
They swear
He smoked Nut.
you smoked Nut. Okay. All right, Mr. Copeland. Now, you said, you can take off the headphones if you want to. You said multiple times that you were raised in a situation where law enforcement, you believe you had to lie to them. Do you remember saying things like that?
Y'all have to. Yeah.
And some people don't have that experience. Law enforcement assists them. Was that your experience growing up in your area?
Yeah, when I grew up, the police just ran in my house and beat my uncles up and kicking out the door. So my whole life, up until my mom died. So yeah, we didn't hate the police.
And when you get in that interrogation room, you said earlier, it's not about the truth. You remember saying that?
I'm listening.
Is it about just getting out of there?
Yeah, that's the purpose of going in the interrogation room, to finish your way out.
And do you know people, other people, do you personally know who lied to the police in the interrogation room?
Shit.
Sustained.
Last questions that I'd like to ask you, a series of questions. Ms. Hilton asked you, Jeffrey's not seen on the Texaco video changing cars like you told the police. You know what I'm talking about, right? I have you?
Yes.
She then asked you about, was there switching of cars in the back of the Texaco? Do you remember something like that?
Yes.
Where did that come from?
That's my first time hearing it.
To verify or support your statement, Ms. Hilton asked you the following items. Did the police show you found shell casings? Remember that question?
Yes.
How does that support whatever you told the police?
Oh, you lost me.
I lost you?
Yeah,
Okay.
you start over.
Yes, sir.
That question was withdrawn.
Okay, if it was withdrawn, it was withdrawn.
Did the police show you rental car records from Hertz? Do you remember that question?
Yeah.
And now, prosecution tried intensely during a redirect to show, but they verified this and that. And then Mr. Steele just reminds the jury, they not only didn't verify anything, remember, they even charged Mr. Copeland for this. They didn't believe him at all back then. But now all of a sudden, this prosecution wants you, the jury, to believe that what he said back then was true. Yeah.
Yes.
How does Jeffrey renting a car for you put Jeffrey into a murder?
They did it.
We talked about the surveillance video of the Texaco and about the back of this. I'm skipping that one. How about Duke? You know who Duke is?
Which one?
Martinez Arnold?
Yes.
Javaris Bradford or Tuda? Do you know who that person is?
No.
Ms. Hilton asked you about, did the police show you a jail call from Martinez Arnold in conversation with Tuda or Mr. Bradford? How does that implicate Jeffrey in a murder?
Your Honor, objection, Mr. Still invading the province of the jury.
Well, speculation, so sustained.
Okay, the way Ms. Hilton asked you, don't speculate. How does that support anything you told the police?
Sustained. I mean, it's not something he can answer.
Telephone calls on the jail phone recorded from Shannon Stillwell. Did the police share it with you? That was her question.
Yes.
Let me ask you a different verification or corroboration. Corroboration is a bad word. It just means it verify. You know what verify means?
Yes.
Okay. It verifies your story to the police. How about Detective Gaither speaking with Miss Quarterman, Deshaun Quarterman? And you told the police Deshaun Quarterman knows all about this, right?
I did.
Well,
I don't.
in one of your statements.
You said I told the police that she knows.
Yeah.
Okay.
How about the police ever recording a call with Deshaun Quarterman saying, tell us what you know? That ever happened? Did the police ever show you that?
I don't think they ever questioned her.
Okay. How about this? You have your cell phone, or the police have it, June 10, 2015, right? You got arrested with your cell phone at your home, right?
Yes.
How about give you the phone and the police are recording and you call Jeffrey Williams and the police can listen? Did that happen?
No.
Thank you, sir.
All right,
Thank
does
you,
anybody
Your
else have questions? Follow-up questions, note, everybody? All right, Mr. Copeland. Is he released or just excused?
He'll be excused for right now, Your Honor.
So he's excused, he's not released.
Of course, indulgent.
Okay. Ms. Copeland, you are excused.
Somehow the prosecution thinks their case will improve by having Woody back at some point, probably during redirect after the defense case in chief. Yeah, no. So, and jury's out. And so here we come to the Sylvia situation, where Miss Sylvia was escorted out from the courtroom by the deputy. So let's listen to what was actually said. Enhancing a bit.
All right, this next matter is going to concern a juror, so if the media could please.
No, this is not the juror. Sorry, I'm on the wrong day.
Stop recording.
And then they come back.
Once he's here, he's going to need to stay here until we're finished with that witness. He understands that, right? And once he's here, okay. Is he here now?
He should be.
Do you want to just have it anticipate? And then, so, I mean, if you're certain, but
3 hours.
okay.
That is the answer on the direct question from the judge. How long do you anticipate the next witness to be on the stand? 3 hours. That person is still on the stand. Still. 3 hours, they claim. 3. You lying sacks of shit. Whoops, did I say that out loud? I meant it.
All right. Okay. And if there's any,
That was the first.
you're not intending to,
Can't be used against anybody else.
Yeah, and then they had a long discussion, the end of this day, beginning of the next day, that Monty, I don't know. His plea deal, and this will come up on a later date, how they presented it. And for me, the rules are clear, at least the federal rules. A plea can only be used as evidence towards that person, not others. But this is a RICO trial, so yeah. But that was end of day 2020, no, day 121. So that brings us to day 120.
Mr. Sharp, we
Day 122. Let me change the banner. Day 122. State's witness. What's his name now again? Monty? Mr. Sledge? Dun, dun, dun. What's it? Well, we will find out. Let's just play it. Oh, first, something I haven't shown in a long time. Since we are changing days, I need to do a swoop. Yes, and this is my swoop. Did you catch that? Let's see it again. That, my friends, are the Norwegian fire-farting dragon. The fire-farting dragon is my swoop. All right, let's go.
accidentally started without you, so sorry about that. I thought everybody was here. Here's what you've missed. Mr. Harvey has proposed limiting instruction, and Ms. Love was just about to maybe provide some case law, but we're trying to actually figure out what it is that we're talking about, because the limiting instruction, as I understand it, would go to the fact that a co-defendant has pleaded guilty, and not to any kind of statements that might have been a part of taking the guilty plea and pleading guilty, and whatever kind of arrangements or agreements there were between the state and the co-defendant, or things that the co-defendant admitted. And Mr. Harvey nodded in agreement.
Good morning.
Good morning.
Yes,
Excuse me.
I think we need to separate
because I enjoy
the idea of admissibility versus the purpose of his admissibility. I do not contest that a testifying co-defendant's plea can be admitted into evidence. I merely request an instruction saying that can be used against the witness itself, but is not substantive evidence against the other.
The plea itself is not. The fact that he pled, the indictment, plea, and sentence. Now, we have a separate issue, which I think is what Ms. Love was about to discuss, which is, we know that there were kind of factual assertions made and agreements made with regard to Mr. Sledge's plea. And if he is testifying and he does not testify, I guess, as expected by the state, and the state needs to impeach him with what would then be a prior inconsistent statement within those factual assertions, that would come in as substantive evidence, and it could be considered as substantive evidence in this trial against every defendant.
Well, I think it can come in as impeachment, but it's a different kind of impeachment than impeaching with a prior inconsistent statement because it's part of a guilty plea. I think this form of impeachment would go to impeach the credibility of this witness and still not be as substantive evidence against all of the defendants on trial.
Let's make sure exactly what it is we're talking about. So when we talked about it before, we talked in particular about item number 8 in the factual assertions, which was the defendant personally knows that one or more associates of YSL killed Nutt on behalf of YSL. I think that's probably what we're talking about, although he makes a number of factual assertions, which could potentially, if he doesn't testify to what he said he was acknowledging, come in as prior inconsistent statements. Now, that's not the plea itself. That's a factual assertion he made at the time he was pleading.
I understand that. And I think my recollection is that this issue has already been litigated and you've already ruled that that can come in and it's subject to cross-examination.
Correct.
So I'm not trying to replow those grounds. I do want a 105 instruction that says,
what you provided on the paper,
yes.
Which is, I'm just trying to get clear. I think that would be appropriate, but I think that is his plea of guilty,
Yeah.
not any factual assertions he might have made during it that might come in only as a prior inconsistent statement. But if they come in as a prior inconsistent statement, would come in as substantive evidence.
And we've argued that before. I've said, I don't necessarily agree with that. I understand that there is a chasm, a wide chasm apparently between the federal rule and the state rule. We have argued that. I'm not going to replow that.
Okay.
You've ruled on that.
Okay, just so we're all on the same page about what this limiting instruction is going to be. Now, Ms. Lev, do you have an issue with the propriety of the limiting instruction itself?
Yes, Your Honor.
Okay, what's that?
So if we were talking about a 803.22 circumstance where we were impeaching the witness.
I have seen on X, Twitter, if you please, that this morning on this trial has started out interesting. So here are our options. I continue the recap and try to catch up, or we go directly to today's trial and I do the rest of the recap tomorrow. Press 1 in the chat for go live on today's trial, or press 2 for continue with the recap. So let's see what, it's all up to you. And one. Okay, I got it. Thank you, Wim. Yeah, all right. Let's go live, and I will continue the recap tomorrow.
The photo.
Let's see here when they started.
To
There.
tender,
Okay. Dun, dun, dun. 1.25, we are about an hour behind. All right, here we go.
do we need to circle back to the issue from when we broke yesterday?
So the issue when we broke yesterday dealt with my line of question that had to do with a preliminary hearing for Mr. Sledge.
Bad sound.
And the relevance of that particular one. At the time that we broke, I believe that he was referencing the hearing shortly after his July arrest. We will move on past that particular one because the hearing and the phone call that has pertinent information that I am attempting to elicit testimony regarding happened in November of 2015, so I can address that because the issue will still be there. So the issue is whether or not testimony regarding what happened at the preliminary hearing, whether it's July or November, is relevant. The reason that the testimony regarding what happened at the November hearing is relevant is that in a conversation that Mr. Sledge had on November 19th, 2015, that was served, and that the court said he could not introduce unless he testified inconsistently. Mr. Sledge said specifically, after talking about getting money for a bond, which is not what we want to get into, at 3 minutes and 18 seconds into the phone call, he says, them folks threw Shannon under the bus, man. That ends Summer D ain't right either, boy. And the girl said, you're lying. And Sledge says, man, he told on that boy, man. The young person with whom he is speaking says, he said, 2 people wrote a statement on you. She's talking about the detective, I believe. And the girl says, Woody. And Mr. Sledge says, nobody wrote a statement on me. One dude wrote a number. And the girl says, one witness saw you there. He says, he being Mr. Sledge says, it's a number 2 witness, and Woody and Lil D never said nothing about me. They said it about Shannon. That's why they dismissed it. We're not trying to get that part in. The girl says, whoever they came forward October 19th, Sledge says, them folks, he references why it took 9.5 months to come forward, whatever, and the judge, Judge Atkinson, he talks a little about him. We're not getting into that. Mr. Sledge then says the first case got switched, but the body didn't. Basically, he's saying that the judge found no probable cause for him on the murder of Mr. Thomas. The girl references the fact that they can indict it. They talk about him being able to dismiss it. The young woman asked, what did they say about Shannon and 30 Deep? 30 Deep, meaning Mr. Garlington. Mr. Sledge says, man, 30 Deep brought his name up. Booty brought his name up. I knew YSL Deep. And I put 2 and 2 together. He references something about Shannon's lawyer. And the girl said, someone from YSL said, Mounk, he said that. I was telling OG, he said either D or DK. He then says, I'm looking for the literal quote, but I'm going to summarize it, the part that's relevant. He says that Lil D's not right. He knows that it's Lil D. They didn't call his name. They called him witness number 2. He knows it's Lil D because that witness told them about all of us meeting up at the condo after, not his words, but he said after Donovan Thomas's murder. He told them about all of us meeting there. The only person that could have done that was Lil D. On the stand, while Mr. Sledge is talking, he says, well, the court remembers that he referenced going to Mr. Williams' condo and only seeing Mr. Williams and Bielby, and all that was happening was working on the song Da Vinci. Then they left to go to another condo so Mr. Williams could grab some jewelry. And then maybe while he was there, he got a call from Mr. Copeland. Mr. Copeland came over, he can't remember, but he doesn't remember who all was there or what, who all might have been there. But there really wasn't a meeting up there. And on the phone call, the reason that he surmises that it was Quindarius Zachary who told police the information they were able to share at his preliminary hearing is because the details that Quindarius Zachary gave were details that only Quindarius Zachary would have known, because drawing the inference from what he is saying, Quindarius Zachary was there, he was there, the rest of them were there. Nobody else would have known, they were all there, but Quindarius Zachary. So him hearing what he heard at his preliminary hearing is what led him to surmise that it was Quindarius Zachary who had told. And Quindarius Zachary had not told him, Antonio Sledge, anything about what he told the police. He just told the police. And then the police, trying to protect Quindarius Zachary, uses witness number 2. So those links are necessary in order for me to be able to put before the jury the fact that, one, Mr. Sledge and other people that they will later hear about were in fact meeting up. They did meet up at the condo, just like Mr. Sledge said in his factual acknowledgments. And what he is saying on the stand now is totally different than what he said when he took his plea back in 2022. So it's relevant. I mean, obviously the bar for relevance is low. This is very relevant. It took a few steps to get to why, but that is why I was saying I was laying the foundation for more evidence that was going to come in.
Okay, well, I think that it might be relevant if you can find me like his actual statements where he is saying essentially that had to be Lil G because he told about us meeting up at the condo, as if, he is saying, I know from my own knowledge being there that this could only have been him because he would be the only other person who knows about it. That part might be relevant because it is inconsistent with what he said on the stand about the only people I knew at the condo were maybe Jeffrey and the people who came with me, which was my baby's mother and my baby. But all of getting it to that,
I don't need all of it. When I said what happened at the prelim, I did not want, and it was an inartful way to elicit that, and I can be more precise. I asked the court for permission so the court knows exactly what I'm talking about, to just play that snippet. We have the jail call pulled up, and we have a timestamp as well, that we can play for the court, if the court will allow us to play for the court.
I'll listen.
Okay, they want evidence in because of prior inconsistent prior inconsistent statements.
And, as well, Mr. Sledge denied having any knowledge of any members of YSL speaking to the police. That is something else that he talked about yesterday. That was a question I think that I asked him, not as specific as the stuff that I just said, but.
So Tommy will.
And also, in this part that the court is gonna hear, he says he put it together because that witness that they did not name was buying guns for people within YSL. Quindarius Zachary, we all know, is the one who was straw purchasing for them. And in fact, he was sentenced federally for straw purchasing. He was the one that purchased the gun. I think one of the guns that the witness had in the video that the jury has already seen. And Mr. Sledge in this jail call says he knew it was Quindarius Zachary because they referenced that witness was buying guns for YSL. So we're going to start at 3 minutes.
Your Honor.
And 12. We're going to
We
start.
Before you
are
play it, I'll hear what he has to say.
we are an hour behind. So, but it is from today.
Finish what you're saying.
We're going to start the first segment of this jail call from November 19th, 2015. And we're going to play is 3 minutes and 12 seconds in. And then we're going to stop it and play other questions. And I'll cede the floor to Mr. Sharp before we start that process.
Okay, and do I have a transcript of these calls somewhere? I do, right? Or no?
No.
Okay, all right, yes, sir.
Respectfully, I'm lost. The putting things together from what was said at a prelim, that was said about my client at a prelim, all of that is it's preposterous to me that the state would be attempting to get into any of this. And this seems to be becoming very complicated for something that should be very simple. There's no putting it together. There's no, I realize little D told. There's none of that, because I'm going to tell, I'm putting everyone on notice right now. I don't know what Mr. Zachary is going to do, but if there is elicited testimony about my client, stuff about what Mr. Zachary said about my client or to the police or at my client's prelim or at a prelim in general, I am moving for a mistrial. I'm of the opinion that the state will have goaded me. I'm putting them on notice. Don't do that. And they're trying to backdoor testimony because they don't know if Mr. Zachary is going to testify or not. Now, if it's just a matter, Mr. Sledge, you said you don't remember who was at the condo. Didn't you say to your girlfriend or whatever she was, wife, fiance, that Mr. Zachary was at the condo on the night of January 10th, 2015? Didn't you tell her that on a jail call? And then if he denies it, then we played a little snippet where he says that one thing, then I guess that makes sense. But I don't know why we're getting into, I figured out he was the witness. This is what he said. You know, this is what he said about me. This is what he said about Shannon. He must have known these details. Why are we doing this?
Yeah, I agree.
Your Honor. Two things. One, this notion of goading into a mistrial and don't do something is not anything that I can respond to, because that is wholly wrong. The fact is, every defendant knows that the state has a good faith basis for putting forth the knowledge that Mr. Sledge had regarding what Mr. Zachary said. Mr. Sharp's words to the court seem to suggest that for some reason he believes Mr. Zachary, we won't be able to procure him. He's under subpoena. They know that he is, and we have served him, and we have every intention that he will be here. He's not, he's out of the hospital, I'll put it that way. We have the statement that Mr. Zachary has given to the police. We have served it. They know what he said. Mr. Sharp is well aware what Mr. Zachary said about his client. The reason that what Mr. Sledge tells his girlfriend is relevant, and the reason that there are those steps that have to be taken, is that Mr. Sledge, as I stated earlier, surmises, he realizes who it is because of the facts that Mr. Zachary shared with police, that police then told about under the label of witness number 2 at the preliminary hearing. Mr. Sledge doesn't say Zachary lied. Mr. Sledge was there. Mr. Sledge has actually said he was there. Mr. Sledge is the one that gave the state, and unfortunately we may have to impeach him on that with other evidence. He's the one that gave us the statement, we met up and Thug gave us money to lay low. All of that aside, I have no words for the whole voting stuff, because that's not what we're doing. We would object if Mr. Sharp even makes
Okay, let's just get to what it is that and I don't know why the part about guns is relevant. If you are telling me that he essentially says, I know that's little D because of what he said about us meeting up that only he could have said. That's the part I'd like to hear. And that's the part that might be admissible as a prior inconsistent statement. So let's hear that part.
right.
Yeah.
And I guess the guns part, I mean, I guess he did say he never sold. He doesn't know if Zachary's selling anybody guns. So, I guess that could be a second prior inconsistent statement. Yes.
I don't know. I'm not in Mr. Sledge's mind. I don't know his reasons for it, but that was an inartful question from the state, because I don't think the truth is that Mr. Zachary has sold guns to different alleged members of YSL. I think the allegation is that Mr. Zachary was a straw purchaser. I wouldn't call that selling a gun.
Yeah. So, I mean, it may be that if you want to get that in, you need to ask different, more specific questions. But let me hear the part about the meeting up, whatever he says about that.
We're going to start at 1321.
Yeah, but we do know that Sledge, his plea deal is damning. Luckily, the prosecution are idiots
We're starting a little bit before.
and don't know how to
About
handle
the
it.
whole situation, they told them, they said no, it was there. You know,
He doing clear, you know what's going on.
Yeah, you know what I'm saying? The whole situation, whoever witness number one is, they thought know it. Cause he say, you remember when we talked on the phone, he's like, well, you didn't know nothing about it, you was in the blind.
Mm-hmm.
They told them folks this. After Lud got killed, all of them met up together and went down Old Boy house. Them made that work. That's how you know it's deep.
Mm-hmm. Which I told my wish Shannon said.
But that, cause they sent me that before Shannon, cause Shannon was still up. So
So the old boy's house that we believe he is talking about is Jeffrey Williams' house. That is the only house that he has testified that he went to. We have Mr. Zachary saying they met up at Jeffrey Williams' house. We have other people. It's not like we do not have a good faith basis for knowing and realizing that's who they're talking about, because Mr. Copeland, my apologies.
Why is my client's name coming up in that conversation? There's no inconsistent statement that would lead to admissibility.
Why is that in the courtroom anyway? Is that somebody, what? Is that somebody who has a Rule 22?
Go back.
So
The second part, Judge, just to orient the court, there is at 5, we wanted to play the part that the court asked about what he said about the witness, but to orient the court as to
the judge asked you very specifically, play this for me, and you didn't. You played some guesswork about what a witness who might be. Mr. Stilwell wasn't named in this part.
to the question posed just now, we would need to go to 557, where Mr. Sledge references it being Lil D. So if we could
References
Hang on just a minute.
or say
We
out
gotta deal
loud?
with this one first. So I think it sounds to me like they're saying, here's what happened and we know X, Y, and Z because we were there. And so I guess the reference to Shannon is because he knows Shannon was there and he has said on the stand, I didn't know anybody other than Jeffrey and, okay, what?
I think, I don't have a transcript, but what I heard that little snippet to say is little D, and of course we have two little Ds. I'm going to assume for the purposes of this statement that he's talking about Mr. Zachary, was saying things at the condo and putting Shannon there, meaning, and he also references Nard, who's Demise McMullen, there being the murder scene.
There being the murder scene?
Yes.
Honest to God, a transcript would really help because it's hard to tell what everybody's saying.
our transcript is of the quality.
Okay, but y'all can retranscribe little snippets. Somebody who knows what the content is, like what is being talked about.
Yeah, exactly. The prosecution isn't prepared for one bit. They have had 2 years or more to get this done. And here they are mumbling like morons about, oh, this and that, references, we think, we believe. No. Oh, this is so stupid.
It's not that hard to do.
We have not a formal transcript. We have what is being talked about in timestamp form that we can give to the court.
Okay, so is it your understanding that they're talking about the murder scene or they're talking about the condo right there, what we just heard?
They were talking about the condo when he said that they met up at Old Boy's house.
How do you
we
know?
don't even know what's being said. Then
We
I
do
don't
know
what's
what's
being
being said, Your Honor. It is not.
This is a mistrial waiting to happen.
Your Honor, if I may.
Particularly. Go ahead.
Let's play that in normal speed. What was just said?
All right, if we don't even know what's being said, then
We
I
do
don't
know
know.
what is being said, Your Honor. It is
Well,
not.
This is a mistrial waiting to happen.
Your Honor, if I may.
Particularly.
Well, the judge didn't disagree. Let's do this. Sorry, because this will be loud. Let's go back and see if we can find it.
Yeah.
All right, if we don't even
We
know
st-
what's
we-
being said, then
We
I don't
do know
how-
what's
Trial
being
waiting to
said,
happen.
Your Honor. It is
Well,
not a
This is a mistrial waiting to happen.
Your Honor, if I may.
Potentially. Go ahead.
Yeah, I can't make out what she is saying, but I don't see that she's disagreeing just by looking at her. Let's get this back to some normal sound.
Judge, we were playing the clip. We put a portion in about Nard. We're not trying to get in anything about the murder scene or Nard. We are not going to cause a mistrial. We are giving to the court the portions of the call that we wish to play. I'm being specific about the portion because we started the clip a second before where someone was able to pick up Nard and make a whole separate argument about the murder scene does not take away the importance of the portion we are presenting to the court that we need to play.
So they are cutting out a part to get things out of context to make it sound like they are talking about meeting up after the hearing, but in context it might be about the actual murder scene. Yeah.
Which is that I know it's Lil D because he told the police about us all meeting up at old boy's house after Nut got killed. So nobody is trying to put in anything about the murder scene. Nobody is trying to put in anything about that.
So let me hear the part you actually want to play. Just the part you want to play.
So, Your Honor, is it at this time that we're allowed to play the portion I told you that gave some context to we had a specific part the court just asked us to play that we played. There is a part before that we have said.
I don't want the part before it. I want to hear what it exactly and only what you want to play before the jury, because that's what I need to rule.
Yes, Your Honor.
Yeah, this is the prosecution, folks. They are unethical, trying to backdoor things in, trying to elicit information that isn't in a recording by claiming, oh, it's almost there. So stupid.
Nobody can hear it. Okay, they're just trying to figure out where to start.
Going up to 1.25, so we catch up again.
Why do we have food in court again? I didn't change that rule.
Oops, somebody is snacking.
No food in court. Somebody please retrieve the banana and take it back to the back. Well, you can't have food in court either. We're in court right now. We're not on a recess. We're not at lunch. Put it back in your briefcase. That's fine. I don't care about a covered drink. That's fine. It's food.
This number one is this I know it deep. Cause he say, you remember when we talked on the phone, he's like, well, you know nothing about it, you was in the blind.
Mm-hmm.
They told them folks deep. After Nut got killed, all of us met up together and went down all wild. Them made that work. That's how you know it's deep.
Yes, Yvette, everything in this trial is a mess, and it's all because of the prosecution.
Okay. If there is an inconsistent statement, this is where we're at, as far as I can tell. Mr. Sledge testified that he couldn't exactly remember who was at the condo. Okay. If there is an inconsistent statement that says D, which is of course complicated because there's 2 Ds, is at the condo that night, then it seems to me it would be easier and cleaner if we just had him refresh his recollection. But that's how I know he told. That is, why is that coming
Right,
in?
I'm not sure why that's relevant.
Judge, the reason that that is relevant, it's 2 things I want to respond to. The notion about we don't know which one it is. He makes a distinction.
Let's
in the
not worry
call.
about, we don't know which one it is.
Okay, so the reason that it is relevant is because we know, Mr. Sharp knows, everyone knows, that what Quindarius Zachary told the police is specific information that will be
Let's
presented.
get to, how about if you ask Mr. Sledge specifically on the stand, you said the only people you remembered were blah, blah. Didn't you tell whoever this is, your girlfriend, didn't y'all discuss the fact that he was also there or something to that effect? And then if he says no, then you confront him with this prior inconsistent statement, which he needs to listen to first without the jury hearing. And then he can say, oh yeah, actually I did. And if he still says, I don't know, then you can play that little part.
Also, Your Honor, we feel it is important that the jury hear what he says, because he said Lil D told on them folks. He told them folks. Earlier in the call, the portion we've not played, there's a distinction. I know I'll get there. The reason that that is important is because he starts out talking about people telling. Yesterday, the court heard him say.
Yes, I don't want to go through all of that again. I can follow the argument, but he does not say told on us.
No, he says,
He
told
says
them folks.
told.
Them folks.
Yeah,
Yes.
which doesn't mean, Lord have mercy. We heard Kenneth Copeland say, I told 100 different versions of things. Telling somebody something doesn't mean you're telling on them or you're ratting them out or anything. And I know the state want it to be that, but you don't necessarily get that from, if you have something that says XYZ told on us, then yeah.
Your Honor, if Ms. Hilton and I were the only 2 people in a room where I ate someone's crackers, and Ms. Hilton comes out and she tells my boss, Ms. Love ate those crackers. And then my boss announces to the world, Ms. Love, you are dismissed because you ate so-and-so's crackers. And I say, well, I know it was Ms. Hilton who told, because
yes, that is one version of how something like that could go down. But Ms. Hilton could also walk out and say, Ms. Love ate those crackers, and there weren't even any crackers in there to begin with, in which case she is not telling on you. So it is an argument, but it is not established just because you think that's what he means when he says that.
Your Honor, I understand the court's position, and I would just say that if the argument has no relevance, the very fact that we're here at the place where there is an argument that the court sees on either side makes it, to me, very apparent.
I said that you can get in the part about what I just, that little snippet you just played, if you confront him with it and he says, yeah, I totally still cannot remember him being there.
And just for the record, Your Honor, the evidence rules do not require that I play it for him before I impeach him with it. So in other words, he does not have to hear it. The rules, I will find it for the court. It's very specific.
Well, if you can recall it to his attention specifically enough without him hearing it, fine. But he has to be confronted with the prior allegedly inconsistent statement and given an opportunity to explain it or deny it or whatever, and then it can come in.
And so telling him what he told her at this time on this call.
But you need to be careful about what you say when you are recalling that to his attention, because we do not need to get into this happened at a preliminary hearing, or you heard it from a police officer who was giving probable cause or anything like that. This is just, he somehow knows that this person has said that, and he's saying, oh yeah, it had to be him because he was there or whatever. Okay.
Your Honor, I want to make sure I stay within what the court is requiring that I do. So, Your Honor, the fact that
it's not hard. Now you're just plain stupid, Ms. Love. You know exactly what to ask. Mr. Sledge, didn't you at this point in time talk to your girlfriend about this? Does this refresh your recollection? No? Okay. Can I play something for you and see if that refreshes your recollection? And then play it only to him. Now, I understand, Ms. Love, you don't want this because you want all of it in as an inconsistent statement because vague and don't remember, because you want all of it in because it's the only way for you to get in something that may or may not be damaging. But you don't have to. You don't have to be an asshole. It's really easy to not be an asshole in court. Just go up there and do a good job. It's not that hard, unless you are Miss Love, who only knows how to be unethical.
Mr. Sledge hears a rendition of an account from a witness one that Mr. Sledge recognizes, in his opinion, came from Lil D. Does not the rendition?
What you claim to be trying to get in is that he said something to his girlfriend that makes it clear that he knew that Lil D was there.
When you say you're talking about Mr. Sledge saying something to me. What I'm trying to get in, Your Honor, is the fact that Mr. Sledge, in telling his girlfriend he knows Lil D was the one that told, knows it because he said he told police that we all met up at Old Boy's house after Nut was killed. That part, we all met up at Old Boy's house after Nut was killed, is the part that I'm talking about. And earlier in the call, and we don't even have to, I won't even touch the call before whatever break the court has, if it is not resolved, obviously. But earlier, he is talking about defendant Stillwell, and he is talking about at 5 minutes and.
This is the part we haven't gotten to yet.
Because
I'm willing to listen to that also. I'm just trying to resolve this one first.
Your Honor.
Yes, Your Honor.
The state began this whole discussion saying that they want to impeach Mr. Sledge with a prior statement because he said that he didn't recall who was there. So that's what this whole thing was about. Now we're talking about he told. And I'm going to go back to the same thing because I don't understand what's confusing about this. He was at the whole part about yesterday where Mr. Sledge said, no one told me what they told the police.
Right.
Mr. Sledge was at a prelim.
I know, which is why I'm saying she can't get into that part.
But it's not the prelim itself. It's also clear that he got this information from the officer testifying at a prelim.
Right, which is not inconsistent with him saying, nobody talked to me about what they said to the police. I said that yesterday.
Okay, I got you.
I got you too. I mean, I understand what the issues are.
Well,
all right, so let's listen to the second one.
We're starting at 5 minutes and 58 seconds. There's a portion where if we don't clip it out, he's saying that they threw out his charges. We will not play that. We will not get into any of that. We will not get into what did they say about Shannon and 30D. We're not getting into that.
Go to the part you are
It's about 3 seconds.
Okay.
Go ahead. Can we jump? Can we be allowed in Zoom? Here we go.
Because I put 2 and 2 together. Because Shannon lawyer. So then when he said somebody from YSL they should have. I mean he said they saved Moon. He said they had another person they saved Moon. He said that, and I was telling OG. He said either D or DK. I was like, I don't think it's D. It's D, man. Because they said Shannon got a play lawyer. So Shannon lawyer So Shannon lawyer how could a person that they saying is buying guns from the YSL make a statement on? See, they were trying to hide these names, but he said that, and that's how I know it.
No. Okay, we don't have a problem with that.
Okay, so I guess next issue real fast is the portions of the plea presentation that,
And the judge says plain no. So Miss Love has to do it properly. This must be infuriating to her. She's so used to Judge Glanville being up there and doing her bidding. She is so used to it that she cannot fathom that she's wrong. And she has to abide by the court rules. And she cannot, for the life of her, stop arguing about it.
Ms. Love forwarded and Mr. Atkins forwarded this morning.
And there's one more as well.
All right, any issue with the parts that she intends to play? All right, well, she gives a description kind of, I don't know that we, as long as it's just walking through those factual assertions, I don't know that you need, I think you can probably tell from just the description of where she's picking up, what she's talking about, but what's the other portion?
No, not another portion
Oh,
of the video.
another
Issue.
thing to raise, okay.
Correct. So State's Exhibit 425Y, when we presented them on our, I think, admin day, I believe that the request was made to remove commentary, and there was a phone number on State's Exhibit 425Y that the court said the court did not find relevance, I think, in the post until it became apparent how it was relevant and so forth. Yesterday, when presented with State's 425Y with just the phone number and none of the context, the witness testified, I don't know what that was, but I'd like the court to see the full exhibit with all of it. So the first portion of this post, to make the record clear, this is a post with Mr. Sledge taking a selfie, literally looking up at the camera, holding his apparently recently born child in his arms. The first post by the real Tounk, which the witness has said was his name, says, "I woke up like this." And then the real Tounk tags AK2 Success and says, "My baby." Then the real Tounk says to AK2 Success, "Thank you, sis." And then Katini says, "Such a good father. Keep up the good work, brother," at YSL Tounk.
Okay.
Then the real, you can publish it, I need the record to reflect it. The real Tounk then says, at Kahenti, "Thanks, sis." And then he thanks someone else.
Okay.
After another person congratulates at YSL Tounk, Pizzle Dope says, "Say Slime, what's your math?" Then the real Tounk says, at Pizzle effing baby, "What the move, Slime?" And Pizzle Dope then says, "Trying to see now, send your number." And then the real Tounk tags Pixel effing baby and gives his phone number.
Okay,
So the context is key.
okay.
So
Because he said, "I have no idea what any of my phone
Yes.
numbers were," and you need to establish that this phone number is clearly his phone number because he's the one sending it.
yes,
All right, there shouldn't be an issue with that now now he said he doesn't know his phone number. Anybody have an issue with that whole thing coming in?
When did he remember? But when was this? This is from fucking 2014. Him remember his phone number 10 years ago, and now he doesn't, and this proves inconsistent state. What the fuck?
Or you could just try to refresh his recollection with it first.
That's what I was going to suggest, Your Honor.
I'll try again.
Okay, and
I
then
know
if
I
that
did. I
still
did.
doesn't work,
And to be clear, we obviously did try to refresh his recollection with the phone number, but we'll see
Right.
if the context
okay.
further
Okay,
refreshed.
that should be fine. All right, have you had a chance to look at the portions of the,
They have the original, but I can
Mhm.
pass it over.
okay. Coming back to the factual assertions, plea colloquy.
I have not. I didn't even realize there was an email sent until
Okay,
just
well,
now. So if I could.
how far into, how much longer do you think you have with Mr. Sledge?
I expect it to be through probably within no under 2 hours, probably an hour
Okay,
and change.
so by lunchtime.
Yes,
So this 3-hour witness is on day 3, and now they claim before lunch.
Yes. All right, so maybe you'd be doing all of this before we break again, so we need to go ahead and sort it out now. Do y'all need, what, 5 minutes?
And I can,
Okay. All right. Yeah, we'll recess and let y'all watch it.
Yeah, this is infuriating because the judge has clearly stated at most 30 more weeks of trial. The state has 99 more witnesses. And this 3-hour witness is now on day 3. And the prosecution comes unprepared. I agree with, I do believe it was Mr. Weinstein who asked the judge to put a time limit on the prosecution. That way, because that is perfectly fine, to put a time limit on the prosecution. That way, they don't regulate how they present a trial, just that they do it in a timely manner. And putting a time limit, just saying, okay, this is the end date. What is, well, 29 weeks from now. Is March 26. That is 29 weeks from now. Jesus Christ. But I think that's the entire trial. And so she could easily tell the prosecution, you have up until Christmas. Your case in chief is done before we go on Christmas break. I don't care how you lay it up, but by then you are done. She has the authority to do that, and I don't understand why she doesn't. Let's skip ahead until they come back here. That's more than a 5-minute break. Here they are. That took longer than expected.
Quick.
so we have, Your Honor, the state has now sent to counsel for the defendants and to the court, I believe you just, the edited version so that there's no starting, stopping, or muting. It has the portions we referenced that we intended to tender as either a prior inconsistent statement, contradiction. It has what we referenced.
Okay, well, I wasn't able to access it because I don't have the permissions, but I mean, I can tell what
Did you see that?
parts, I think. Is there an objection to that?
So, Your Honor, we have not reviewed the edited version, so, because we
All
were,
right, well, I'm going to assume that what Ms. Love says is in there and out is what's in there and what's out. So let's just take her at her word as an officer of the court.
Okay.
And
we, as I understand it, the state's attempting to introduce this as prior inconsistent statements. My response would be twofold. First of all, I don't believe that they're inconsistent with the testimony. Secondly, to the extent they are inconsistent with the testimony, Ms. Love has already read the factual acknowledgments and confronted him with them during her direct, is my recollection.
he actually hasn't. She's gone through, I think, some of number 1, but the ones that like 7, 8, 9, and 16, she hasn't read those out.
Okay, well, that, my recollection is, and I'm not.
Have you,
saying I'm
Ms.
right.
Love?
No, I intentionally not.
Yeah, she hasn't.
Okay. Is the edited version, has the law and crime
Yes.
been taken out? Okay.
So this is just essentially going to be him swearing to tell the truth, identifying himself, and then it's going to be the factual acknowledgments that he says, no, these aren't true. And then the sentencing understandings or whatever that he says, I didn't understand any of that at the time. And then the bottom that's where he says, I have read and carefully considered all of this and I've made any changes I want to, and this is all true.
What it has is, in addition to that, so it has the very beginning where he raises his hand and swears to tell the truth.
Right, I said that.
And then from there, I asked him if he understands the charges. It's basically from there, I'm reading and asking whether he understands his charges, the sentence, and the special conditions of his sentence. And then I asked him whether his attorney has explained to him the maximum and minimum for these charges. I stopped right there so as not to put in the maximum and minimum for the charges. Then I pick up at
Why is this necessary? The jury already heard all of this.
Your Honor,
asking,
Yeah.
well,
I mean, it's essentially what you sent and described in the first email of this morning, right?
yes,
Okay.
that is.
in Your Honor, I just want to be clear, to the extent, and you haven't ruled yet, and to the extent that this is allowed in on cross-examination, the state is keeping out the maximum minimums. Gets a little complicated because we need to, through cross, talk about what he has over his head, his bias, his motivation to work with the state.
Okay, well, I don't think he's working with the state from his testimony,
Well,
but
he,
sure, you
on
can.
December
yeah.
28th of 2022.
Yep,
And at one point, and the state drafted this document, not us,
yep.
they said the state will be asking for the maximum. So at that point, the maximum, at least for the gun charge, is going to be revealed. I know that sometimes we don't like to say what charges carry that our clients are
Right.
facing, but the state said that they're going to ask for the maximum, and we need to articulate what the maximum is. I just want to be
All right,
clear.
that's y'all's choice.
Okay.
Okay. All right, so is there objection to the portions that Ms. Love is proposing to play?
We just have an objection to the extent that we don't feel that they are prior inconsistent
All right.
statements, but we're going to.
All right, well, I'm ruling that they are prior inconsistent statements, so this is in when tendered.
Your Honor, I do want to make clear so that there is no confusion for any record later on. The special conditions of his sentence are not portions that were asked about, but they are portions that give context to what he is saying he understands. So when I read the charges, for instance, his current charges, his negotiated sentence, and the special conditions that he shall abide by, all of that, it gives context to the fact that he said he didn't understand it. So I did not ask him, hey, is this a special condition? Is this a special condition? But I included that in there for context for the rest. So I need to be abundantly clear. What I am saying, I am playing is exactly what I have indicated in my email to the court and counsel. And the reasons for it have not changed, but I needed the court to hear that part.
All right, well, I mean, part of what he said yesterday that he didn't understand at the time he signed it was any violation of these provisions or any special condition will result in him being sentenced on count 30, and the DA will recommend serve the maximum. So he's. Thank you for clarifying the record on that. All right. Okay, are we anything else before we get the jury in an hour after I told them to be here?
And good morning, Your Honor. Good morning, everyone.
Morning.
Your Honor, is the court stop the questioning of the interrogation by Detective Gaither of Mr. Sledge that we objected to when we left yesterday? I didn't understand the relevance, and then
I don't expect her to
Okay.
go back into that
Thank
because I ruled that to be irrelevant.
I don't have an additional part of that I'm trying to get into at this
Okay.
time. And if before I ventured into that, I would bring it to the court's attention, but I don't foresee it at this point.
Okay. All right, let's get the witness in and then we'll get the jury in.
And Your Honor, I believe that Mr. Wright may have apprised the court. He is in Coweta County.
He did not apprise the court of anything. And
Well, he
in
did.
fact, I told him and he assured me that he would be here
There's
through
a good part.
duration.
There's a good part. There's a good part. He has standing
Oh,
counsel
okay.
that he has, I should have started with
Hello,
that.
you should have.
That he has, I apologize, that he has, and Mr. Sledge has agreed and
Okay.
okayed.
All right. All right, and tell me your name.
Last time in this trial, when a stand-in lawyer was in place, everything went to shambles. Let's hope this doesn't happen today. Or who knows?
Amen. Thank you for being here.
Thank you, Judge.
And I shouldn't say he hasn't apprised the court because he probably apprised one of my staff. I just haven't had anything forwarded to me. So, okay, but as long as Mr. Sledge has somebody here to represent him, that's fine.
All right, let's see what happens now on this 3-hour witness on his third day on the stand.
Thank you. Good morning, ladies and gentlemen. Thank you for your patience this morning. We started before y'all again, but we weren't able to get through everything. So that's just, how it happens in trials sometimes is we have to deal with issues that require y'all to be patient. So thank you for continuing to be patient. And we're ready to continue now with Mr. Sledge's testimony. Ms. Love, go ahead.
Thank you, Your Honor. And good morning, Mr. Sledge.
Good morning.
Mr. Sledge, yesterday I showed you an exhibit, 425Y, to see if it refreshed your recollection. I'm going to show you what I will label as 425 Yankee Alpha and see if this exhibit refreshes your recollection regarding your phone number back in December of 2014 and in 2015. Okay?
How in the flaming manure could you ask of anybody to remember their phone number they had 10 years ago? I don't remember my phone number because I got myself an easier phone number to remember. What phone number I had prior to that, I have no clue. No clue whatsoever.
Yes.
May I approach?
You may.
And don't read it out loud, but is the photograph depicted in 425 Yankee Alpha the same photograph that was depicted in the exhibit you saw yesterday?
Yes.
And is that you and your child in that photograph?
Yes.
Do you recall how old your child was in that photograph, approximately?
No, I believe he was just born. I don't know.
He was just born?
Yes, I don't exactly know how old he was on the photo.
That's fair. When was that baby born?
Ms. Love, if what you want is the phone number, let's cut to the phone number, okay?
I'm asking for
Let's get him on it.
Oh, George isn't happy.
Are you able to read this?
Yes.
And based on what you are reading,
Try that other mic, maybe. Which I know has also got its own problems, but
do you recall making the posts that you see in the sidelines of this photograph?
They say my name right there, whatever the Instagram name was at that time.
Is this a post that was on your Instagram page?
Yes.
Does this post refresh your memory about what your phone number was?
Yeah, it looked like something I wrote.
Does it look like a fair and accurate copy of what you wrote and posted on your Instagram page?
Yes.
Are you able to now tell the jury what your phone number was?
It say 446628935.
404
Yes,
662
8935.
8935. And was
Yeah.
that your phone number?
I guess I don't remember the look, but I see it on the photo. It said I gave it to somebody. But for my personal knowledge, I don't remember. But from the photo, it's saying it's my number because I sent it to whoever that was.
Your Honor, given that, and thank you, Mr. Sledge. Given that Mr. Sledge does not recall the state tenders State's Exhibit 425 Yankee Alpha as a past recollection recorded.
All right, it's admitted.
Thank you. Your Honor, permission to, and Your Honor, there is also the, thank you, Judge. Could you zoom in? All right. Mr. Sledge, would you read the first post that you made?
It said I woke up like this.
And then what's the next one?
My baby.
And are you responding to someone, tagging someone, saying that?
Yeah, I said, it said thank you, sis.
And is that at K2 Success that you're telling that it's your baby?
Yeah, it do. It said thank you, sis.
All right. And what's the next line?
Such a good father, keep up the good work, bro.
And then who is that person talking?
It said thank you, sis.
Is that person writing to at YSL_Tounk?
Yes,
And is that Kahenti, Kahenti, that made that post?
yes,
In response, do you then tell A at Kahenti, thanks, sis?
yes,
And then do you tell someone else, thank you?
yes,
Does MDBNELL congratulate at YSL_Tounk?
yes,
After that, does Pizzle.dope ask, say slime, what's your math?
that's a number thing. I don't know. I see the pound sign number for a number
Do
on
you
my
see
side. If you pay,
right here? Do you see say slime, what's your math?
oh, okay. I see it on now, but it don't show right here.
You don't see say slime, what's your math?
Okay, right there. Okay.
Okay,
I was looking right there.
that's okay. And then do you respond to at Pixel effing baby, what's the move, slime?
Yes,
And then does Pixel.dope respond, trying to see now, send your number? They
Yes.
use a hashtag.
yes,
And then do you respond to at Pixel effing baby 404-662-8935?
yes, but that's, yes, go ahead. Yes, I responded to that.
You're able to say
No,
whatever you
go,
need to
go.
explain.
I responded to that.
Okay. And was this post made around the time that your child was born?
Yes.
All right. Now, can you tell us when your child was born?
I just remember December, around December or something.
December, what year?
2014, I want to say.
Thank you.
Okay, so what? Is that because they have wiretaps on that phone number or something?
Yesterday, we talked about what happened on January the 10th of 2015. Has any part of what you told the jury yesterday changed regarding what you recall happening January 10th, 2015, after you learned about the murder of Donovan Thomas?
You gotta refresh my memory. I don't remember. Yeah.
Do you remember what happened after you learned about the murder of Donovan Thomas?
No, could you refresh my memory?
So is it your testimony you do not remember what you told the jury yesterday?
I'm not saying that. I'm just saying I don't remember right now. If you could show me, then I can. I don't remember right now.
Did you testify yesterday that you got a call around 10-something PM, or you got a DM
Yes,
that indicated you and someone else were responsible for the murder of Donovan Thomas?
yes.
Do you now remember what you did after you got that DM?
No, I don't think I said. I remember saying that I went to Mr. Jeffrey's house.
And do you remember, what you said or who you said was at Mr. Jeffrey's house?
Yeah, whoever, I don't know if he's the cameraman or he just do the videos. I'm not for sure about that.
And is it still your recollection that only Mr. Bean, you, your child's mother, your child are the people that you recall being at that house on 10th Street?
I told you it was other people there, but I don't know the other people.
Did you also testify that none of the defendants in this courtroom were there?
I said, I don't remember seeing none of them. That's what I said.
And
That-
thank you for clarifying.
That's not the question you were supposed to ask, Miss Love.
You said that yesterday. Is that still your memory today?
If you have anything to refresh my memory, Ms. Love, you can show me and then.
I appreciate that.
But I don't remember.
Okay, so that's still your memory today.
Yeah, that's my memory too. I don't remember.
And what about when you went to Mr. Williams' second residence? Today, do you have any further memory about who all was at that residence?
No, if you have anything that can refresh my memory, you can show it to me, but I don't remember.
And do you not remember any of the defendants in the courtroom here being at that residence?
I don't remember.
Objection asked and answered.
Okay.
This is not how
Do you
you.
remember having, do you remember being at Rice Street in November of 2015?
November, yeah.
And while you were at Rice Street in November of 2015, do you remember calling and speaking with your child's mother at various times?
I talked to her a lot of times, so you have to refresh my memory.
Would showing you a rough transcript of that call refresh your memory about what was said during, or let me ask you this, do you recall talking to your child's mother on November 19th, 2015 at 8:03 p.m.?
I don't remember the dates, Ms. Love. I talk to her almost every day, so I don't remember the exact dates.
Would showing you a rough transcript of a call refresh your memory?
Maybe if you show it to me, yeah.
Your Honor, we will label this states 448 Yankee, and it will not be for the purposes of admitting for the jury, just to refresh his recollection. And Your Honor, yes, I was going to ask if the defense could look at it first. Do we have more? You got it? Yes. You want to go, Mrs. Frost?
Okay. Not a proper sidebar. Is it? Oh, battery time. Time. What? Oh, it is a sidebar. Does this count? Folks, does this count as a sidebar? Or is no, it's just battery change. I can't count this as a sidebar. Oh, now it is a sidebar. Now it is a sidebar. We will go through day 122 and day 123 tomorrow as a recap. But for now, this is Sidebar Counter 240.
Just be safe.
Just a second, they say. Just a second.
All right. You said you can, but I doubt if it's going to be that much longer. And by the time you get back there, I'll be calling you back out again.
Jesus.
Remember the defense about a correlated matter.
Sure.
All right. Here. All right. Here we go again. Sidebar counter 231.
Trying to do I start here?
Yeah.
Trying to be pro.
I think it's because I have this back here. Go ahead.
Trying to be proactive, Your Honor, based on our outside of the jury conference earlier this morning regarding that jail call. We went ahead and clipped the portion that the court determined could be relevant and had that sent over to the court and to counsel in the event that it became necessary to play simply that snippet.
Yeah.
We sent that so that if there was any disagreement that that was the portion the court acknowledged may be relevant, counsel could let us know. So we weren't offering it at this time. I don't know whether the transcript we've provided is going to refresh Mr. Sledge's memory or not. He's having a conversation with his attorney.
Okay.
I was under the impression that we litigated this morning and that the state, and then you asked the state to play it, and the clip they played was talking about what Shannon's paid lawyer said.
Right. I don't think that's this. I think what she has just sent us is that first part we talked about. That is the transcript that he's looking at now.
Okay, I don't know how that could be 28 seconds, but
I mean,
listen.
I don't think it should be 28 seconds either. So I'd like for us to.
Can we play it for the
Yeah.
court?
Jesus Christ. Yar is here. Everybody, Yar is here. So they still outside.
The whole situation, whoever witness number one is, they thought know it deep. How he say, you remember when we talked on the phone, he's like, well, you ain't know nothing about it. You was in the blind. They told them folks deep. After Lud got killed, all of them met up together and went down over house. Them man, that's how you know it's deep.
Them folks, after Nut got killed, again, we're backdooring the fact that D said something to the police that's problematic. If Mr. Zachary takes a stand, I will deal with it and I will cross-examine him and it won't be a problem anymore. But I don't want there to be any insinuations, any references, any reference to D telling on people until he takes a stand. And so I don't know why we have to get into what Lil D told them folks to get the fact that he was at a condo.
Do you have the transcript or does Yeah, Mr. Sledge have it.
Mr. Sledge has one copy, I have one. Written on that.
I agree with Mr.
And
Mr.
if
Shaw.
Mr. Sledge needs to hear that outside of the presence of the jury to get context to understand what he said previously, I don't have a problem with that. I just don't want the jury to be hearing Mr. Sledge's phone calls to his girlfriend about what other people told the police. Right.
I mean, what you're asserting that you want to get in is, I heard that he said these things, and we know it's him because of exactly what he's saying. So we don't need the witness one part for that, so.
So, we will have Mr. Makins take out witness one.
Because, and just start with he say,
Yes, Your Honor.
and
I don't have the transcript in front of me. I don't have the call memorized, but I did hear.
we can
he's-
play it again.
He's telling them folk what he told them folks.
Yeah,
The whole point of this is just, was Mr. Zachary at the condo that night or not? And I really don't care what the answer is. What I don't want is a bunch of references to what was said at a prelim, and D is telling these folks this and that.
nobody's gonna know who them folks is from this.
Well, them folks is,
Them folks could be anybody.
Your
Them
Honor,
folks could be
respectfully,
anybody.
respectfully, Your Honor, them folks in the street is police. That's slang for the police, and I believe the jurors are
Yeah.
gonna be able to put that together.
Well, I don't know whether they will or not, but that's what he said.
I understand that's what he said, but I don't believe that just because he said it, it's admissible. Him talking about what Lil D did, respectfully. If Lil D takes a stand, we'll deal with it.
Okay, well, maybe he'll just remember that Zachary was there after all.
And Your Honor, again, we gave that to him to refresh his memory about who all was there. What I started the questioning with today was, do you have any different?
I understand, I was here. All right, I'm gonna hand this back to you. But if he's presented with it, the transcript, and he claims to still have no memory, then I'm gonna permit this in as a prior inconsistent statement. Yes,
This once, but I'm going to say it again. I would suggest someone just play Mr. Sledge's recording and then see if that refreshes his recollection outside the presence of the jury.
I asked him, did he want to, I asked him, do you want me to play it for you? You want to take the transcript? He said, I just like to read it. I just need more time. That's what just happened back there in the presence of his lawyer and chief investigator, Mounk. Anybody want that?
Okay, can
can you what?
I go talk to the witness and ask if he wants to hear the
I
recording?
appreciate it. The witness would be allowed to talk to his own attorneys.
Oh, I guess only the state gets to talk.
Well, you are the one, Mr. Shard, in fairness, that asked for a bench conference
You're right.
and suggested that Mr. Sledge be apprised and that his lawyer be apprised as to maybe what should and shouldn't be said from that transcript. And that is why Ms. Love went out and gave them that transcript.
And Your Honor, I was under the impression that this whole thing about the call had been settled. Apparently, I was wrong about that. But if he needs to listen to the call to refresh his recollection, I don't have a problem. I'm
But
just
you
trying
know
to.
what? If he comes in and he says, yeah, that still doesn't help me, but if I could hear myself say it, then maybe that would, then we'll take it from there.
Okay, thank you.
Do we think maybe he's ready, or is somebody gonna let us know, or?
I told him to come back in, but I'll send someone out to see.
Or, I mean, his co-counsel could do it. She's still here. That way there's no kind of, one side gets to see Mr. Wright more often than the other side. You can go ahead and take that screen share down for now, since we might not get to that. Yes. 5 more minutes. Anybody else need to use the bathroom? Okay, can you do it quickly? Because I don't want it to turn into another 20-minute recess.
And there was not any.
We've had about, what, 5 minutes of actual trial time today so far?
There was no objection to the plea video, right?
Hmm?
There was not an objection to the plea video, right?
No one has voiced one. I mean, other than they don't think it's a prior inconsistent statement, and I ruled on that.
Yeah, you heard it, folks. If you don't remember word by word what you said on a certain date and time 10 years ago, and you say, honestly, I don't remember what, that is a prior inconsistent statement. Can bet money if you ask the judge what color her socks were yesterday, she couldn't remember. And
You can do it right now while we're.
Mr. Sledge, have you had enough?
Hang on, we're waiting on a juror.
I'm sorry.
That's why we're all
Y'all
still
were waiting
standing.
on me. I'm so sorry.
All right. Even Ms.
My
Love wants to
apologies.
move the case a little bit now.
I thought they were waiting on me. I'm sorry. I feel a little self-conscious. Mr. Sledge, have you had enough time to speak with your attorney and to review the exhibit labeled States 448 Yankee that I gave to you to refresh your memory?
Yes,
And is the attorney with whom you reviewed that document the same one that you had on December 28, 2022?
yes,
Were you able to ask questions and gain answers to every question that you had regarding this document?
yes,
All right. Does reviewing States Exhibit 448 Yankee refresh your memory about a phone call that you had with your girlfriend, with your child's mom, on November 19, 2015?
yes.
All right. Your Honor, I'm going to place this here as not admitted for the purposes of the record.
All right.
Mr. Sledge, having read States 448, do you have any more memory about who all was at Mr. Williams' condo, or with whom you might have met at the condo after Donovan Thomas was killed?
Could you repeat that, Ms. Love? Repeat it one more time.
Yes, sir. Having refreshed your memory about the phone call that you had with your child's mother,
Yes,
do you have any more memories about who all you met up with after Donovan Thomas was killed?
yes, I think.
All right. When you say you think, who is it that you think you remember you met up with after Donovan Thomas was killed?
I think who I met up with, who I was at the condo. You losing me right there.
Let's go with the way you first said it, or the last said it. Who all was at the condo?
I still don't remember who I was there with. I'm trying to think. I seen the paper, but I didn't see any name really that was on the docket saying who was all there.
Do you remember whether Quindaria Zachary was there?
I think Quindara Zachary was there when I got there.
Do you remember whether Shannon Stillwell was there?
I still don't remember if Shannon Stillwell was there because I didn't see him personally with my eyes, so I still don't remember if he was there or not.
Do you remember whether Diamante Kendrick was there?
No, I think Mr. Kendrick was not there when I got there.
And when you say you did not see Shannon Stillwell with your eyes, is your testimony today, you know for a fact that you didn't see Shannon Stillwell, or that you don't recall?
I don't recall. When I got there, I didn't see Shannon Stillwell there. When I first got there. That's what I'm saying.
At any point, were you, Shannon Stillwell, Diamante Kendrick, Quindarius Zachary, Defendant Williams, in a room at one of his condos the night Donovan Thomas got murdered?
I think
Hey, Megan Fox. Not that Megan Fox. Megan Fox, the writer, says Vices and Fox Den raid on the way. Thank you so much. Thank you, thank you, thank you. These Legal Vices is Jeff. You've seen him on my channel and you've seen me on his. Megan Fox, occasionally I am on her channel. I think she's been at one of my drinking streams a few months ago. Hey, welcome, Legal Vices and Megan Fox raid. Yo, you are witnessing grass grow or a tooth pulled. This is day number 3 of Mr. Sledge on the stand. The prosecution claimed he was a 3-hour witness 3 days ago. So she lied. Raiders are here. Hey. Legal Fox raid. Yeah, welcome to the Young Thug RICO-Trial. This is from today. It is day 124. It's trial day 124. On the stand is Mr. Sledge. He has taken a plea deal for 15 years probation or something in exchange for testifying in this trial. It's not going so well for the prosecution. But if you go back an hour and play it in 1.5, you get caught up really fast on the shenanigans from the state.
I think, yes.
Which one? Which condo?
Not the first one.
The second condo?
Yes.
All right. What were y'all doing?
Nothing. Mr. Williams getting himself together.
At what point and let me back up and ask you this. Would you characterize your being there as y'all all meeting up?
Megan Fox, thank you for a $10 super chat. Lots of love to Santa Claus. You make watching grass grow fun. Thank you. Yeah, I mean, it's just a few months until it's Santa Claus. That is when my channel changes a bit because it's starting to get close to Christmas and I go from the Viking lawyer or Best Buy Gandalf to Santa Claus. And folks, we are 3 hours in and this is the first super chat of today. Just saying. I'm not grifting. I'm just saying. All right, let's continue.
At that house.
I don't think we all arrived at the same time.
That's not what I asked. Would you characterize you all being there as y'all all meeting up at the house?
Yes.
All right. And what purpose did you all meet up at the house for?
They was going to the show and the video shoot with him. From my understanding.
Were you working as head of security for Defendant Williams at that time?
No, I don't think so.
And Kenneth Copeland, was he also one of the persons that met up with you, Shannon Stillwell, Diamante Kendrick, Quindarius Zachary, and Defendant Williams at Defendant Williams' condo?
Yes, he was there.
Okay.
Here comes Legal Vices. Hey, Jeff with Korean Monopoly money. Saying, that's lame. Here's another. Give Nick your Starbucks money. Oh. As I always say, only give what you can afford to give. I do not expect to be given anything, but it is greatly appreciated. For instance, Becoming a member here is $3 per month, and you get access to more than 100 members-only videos. You get access to members-only emojis here on the YouTubes, and you get access to my Discord. So you get a lot for $3 a month. All right, let's continue. Thank you, Jeff.
He was there and he was one of the ones y'all met up with. Is that what you're saying?
Yeah, he came down to the condo.
All right. Now, what did y'all talk about at the condo when y'all all met up?
I don't basically remember the conversation that we was having, but I don't remember the conversation. I'm gonna say that.
Is it still your testimony that you went to Defendant Williams' condo solely because you got a DM accusing you of Donovan Thomas's murder?
Yes, that's one of the reasons. That's the reason, yes.
Was there any other reason?
I don't remember. If you have anything?
For you who don't know, Mr. Sledge was on Rice Street for months before he took this plea deal. Months! And then he got the option of you can get probation and get home to your family, or you will sign this plea deal where you acknowledge what the state wants. And he chose the plea deal. Sebastian Miller for 200 Danish krona. Thank you. Remember you wanted this, so there is no point in saying no. All right. Thank you. Thank you. Thank you. Woody went off the stand Tuesday morning, I think.
Refresh my memory, you could show me, but I don't remember no other reason why.
That's the only reason that you remember today? Okay.
Yes.
Given that that is the only reason you can think of that you went to Defendant Williams' condo, did you talk about the fact that you were, one, that Donovan Thomas had been murdered, and two, you were one of the ones accused of Donovan Thomas's murder?
Sustained.
Thank you. Did you talk about with the people you met up with the fact that Donovan Thomas had been murdered?
Yes.
All right. Now, about what time did you all meet up at Defendant Williams' second location, his other condo?
I don't remember the time.
Do you recall whether it was before or after midnight?
No, I don't remember.
Based on what you said yesterday, is it safe to say it was definitely after 10 o'clock p.m.?
Yeah, it was after 10 o'clock, if I'm not mistaken.
All right. Do you remember how long you talked about Donovan Thomas's murder with the people that you met up with?
It couldn't have been too long because I ended up dropping Copeland off, so I don't remember how long it exactly was.
What was the atmosphere in the room while you all talked about Donovan Thomas's murder?
What you mean atmosphere? Could you explain that to me?
I can. How did you bring up Donovan Thomas? Well, who brought up Donovan Thomas's murder when you all met up?
I already had spoke about it to Mr. Williams.
Right.
So I don't know who started the conversation at the second location.
Do you remember what the conversation was?
I just know the conversation with me and Kenneth Copeland was the one responsible for it.
So him and Kenneth Copeland, aka Woody, was the first people accused of the murder of Donovan Thomas. If you watch the cross-examination of Woody, Mr. Shard, one of the defense attorneys, led in good questioning more or less everybody to believe that, yeah, it's probably Woody. It's probably Woody. Woody and this guy was the first people charged with the murder of Donovan Thomas. It was later dismissed. And now he has pled out for probation. Woody isn't even in this indictment. But they claim the 6 defendants had a few of the defendants had something to do with it. People who has never, well, Mr. Stillwell was charged and it was dismissed 10 years ago. But still here we are because it's a RICO.
And was there anything said by anybody else that you remember?
Not really. I just remember Mr. Williams telling me that we ain't had nothing to do with it. Go down now.
Who is the we?
Me and Kenny Copeland.
And do you know how it is that Mr. Williams is able to tell you that you all don't have anything to do with it?
He wasn't directly like trying to tell us what to do. He just was basically saying, don't go to the show and go down there and clear our name.
Okay. Now, to your knowledge, did Kenneth Copeland go to Miami?
I don't know. I think he called me and told me he was in Miami, but I don't personally know, was he in Miami?
And is it your testimony that you didn't go to the show because, well, you wanted to stay and make sure your family was safe?
Yes.
But is it also fair to say that you weren't trying to clear your name? You did not go to the, did you, I'll rephrase. Did you stay back from the show in order to clear your name?
Sustained.
Did you make any efforts to clear your name?
Sustained.
Your Honor, I'm not suggesting the answer. I'm just asking one that's yes or no.
Ask it a different way.
Yes, Your Honor. Did you take Mr. Williams' advice that you say he gave?
Sustained.
What did you do after you were told to not go to the show and clear your name?
I dropped Copeland off and I went on about my business.
Do you make or recall anything else anyone else in that room said about the murder of Donovan Thomas?
Objection asked and answered.
I'm asking if he recalls anything else. He seemed to remember something.
Go ahead.
Do you recall anything else anyone else in that room said about the murder of Donovan Thomas?
No.
After you dropped Mr. Copeland off, did you ever go back to the condo that night?
We talked about this yesterday, Miss Love. I told you I went to the hotel room.
I understand. Did you leave the hotel at any time, go back to the condo?
No.
Did you see either Defendant Williams? We'll start with him. Did you see Defendant Williams anymore before he left for Miami?
You said that night?
Between the time you said you left his condo and the time that he left for Miami, did you see him at any other time?
No.
Did you see Defendant Stillwell at any time after you left Defendant Williams' condo?
No, Miss Love.
Do you know whether Defendant Stillwell went to Miami?
No, I don't know that either.
Do you know whether Defendant Kendrick went to Miami?
Well, I think Mr. Kendrick was going because he's supposed to be in the video or something like that, if I'm not mistaken. He was going to help perform that night.
Do you know whether he went?
I don't know personally because I didn't see it, so I can't say personally that he went.
Do you know whether Mr. Zachary went to Miami?
No.
Did you speak with Mr. Williams at any time that he was purportedly in Miami?
I think he called and checked on me. I'm not for sure. I don't remember that. I think he called and checked on me, but I don't remember.
Did you speak with Kenneth Copeland at any time that he was in Miami?
Well, he told me him, his daughter, and himself or something went down there, if I'm mistaken.
Is that a yes?
Yes, I guess yes.
Did you speak with Defendant Stillwell at any time during a point where he was in Miami?
No.
Did you speak with Defendant Kendrick at any time while he was purportedly in Miami?
No.
Now, when you spoke with these gentlemen that you love that are YSL members, did you always talk with them either in person or on a telephone line, or did you have any other ways that you communicated with them?
We never really talked on the phone that much. Me and Mr. Stillwell probably talked on the phone more than anybody.
And do you count FaceTime as talking on the phone?
Yes.
All right. How often would you say that you FaceTimed with Kenneth Copeland?
I can't answer. I don't know.
Did you FaceTime with Kenneth Copeland before he met with you at Defendant Williams' condo?
I don't recall.
Did you FaceTime with Defendant Williams before you went to his condo?
I don't recall. If you have anything to refresh my memory, you can refresh my memory, but I don't recall. I was talking to Mr. William before I went down to his condo.
What about defendant Stillwell? Did you FaceTime with him before y'all met up at the condo?
No,
Did you FaceTime with defendant Kendrick before y'all met up at the condo?
no.
Are you able to give us just a rough estimation of how frequently you spoke with defendant Williams on FaceTime?
I can't give you that. I don't recall.
Did you, between the time that photograph in 425 Yankee was posted, so around December 2014, and January 10th, 2015, was that the same number that you would?
I have no idea what she's after here. Absolutely no idea. But this is not unusual for Ms. Love, the prosecutor, because when she doesn't know where she's headed next, she just keep asking irrelevant questions until somebody stops her.
Would have used and FaceTimed with?
I don't know, Ms. Love. I can't answer that question. I don't know. I don't recall that. I don't know.
Okay. Are you able to say with any degree of certainty about how often you FaceTime with defendant Stillwell, since you said that's who you talk with the most?
We used to FaceTime a lot, so.
And the jury, and I don't know what a lot means for you, so could you please tell them what that means?
I can't give you a number of how much we FaceTime. I can't give you that number.
And thank you. I don't need a specific number. Was it every day?
I say yes, probably yes.
Was it multiple times a day or just once a day?
We talked like big brothers, little brothers, so I don't know how many times a day that me and him talked on the phone, but we talked a lot on the phone every day.
Defendant Williams and you, how often did y'all talk on FaceTime?
And then Mr. Williams didn't talk on the phone as much as me and Mr. Stillwell did.
All right. Your Honor, at this time, I believe that the instruction that the court has that should precede what will be marked as State's Exhibit 442Y that we have sent would be appropriately read.
All right, so this is going to be about his plea in this case. Okay.
Yes, in this case.
All right. So I'm going to again instruct y'all, and this time everything I'm going to say is going to be applicable to this plea in this 2022 case. All right. So you are about to hear, and you actually have heard evidence that this witness, who was a co-defendant in this case, has pled guilty to some of the charges in this indictment. I caution you that the co-defendant's guilty plea conviction itself is only admitted for a limited purpose. That guilty plea is an admission by this witness only that he committed the criminal acts to which he pled. You are not to consider this co-defendant witness's guilty plea as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him, and not on whether another person has been convicted of the same charges with which the defendant is accused. If you find that the co-defendant witness provided testimony on the stand that is inconsistent with his guilty plea admissions, and they are going to be admissions in this case, this wasn't an Alfred plea, this was a regular guilty plea, you may consider the witness's prior inconsistent statement, that is his guilty plea admissions, including to the allegations in the charges to which he pled guilty, as substantive evidence, which you may consider against any defendant currently on trial for whatever bearing it may have to the issues on trial.
Thank you, Judge. And we are going to play that. I wanted to ask Mr. Sledge a few more questions. Mr. Sledge, yesterday, am I correct that you testified that you know of an Antonio Sumlin?
Yeah, I know of him.
Okay. And did you testify that that's the person that you called Obama?
You never asked me, did I call him Obama? Not.
Okay. Did you call him Obama?
Yes.
All right. And how well would you say you know him? You said you know of him. How
Yeah,
well?
I just see him around, but me and him never really hung out together.
To your knowledge, did he ever claim YSL?
Yes, I heard, yes.
Okay. And when is the last time that you talked with Obama?
I don't know, Ms. Love.
Did you talk with him in 2022?
Yes, probably. Yeah, I probably talked to him in 2022.
Do you know how often? Generally speaking, I don't need a
No,
exact number.
when I seen him, I talked to him.
Okay. Did you ever FaceTime with him?
No, I never been on the phone with him.
All right. Was the last time that you saw him in 2022?
Yeah, in person.
Okay. And do you recall if you ever spoke with him around April 2022?
April 2022?
Yes, sir.
No, I don't recall that.
Do you recall speaking with him around the time that this indictment came out?
I don't remember talking to him when the indictment came out.
Okay. Did you ever share any bills with Obama?
What bills? What kind of bills?
Any bills? I don't even care what kind. Any kind of bills with Antonio Sumlin.
What you mean by bills? Could you be more
Understand
specific?
what
I'm asking you to be more specific.
money that you owe to somebody else?
No, I don't recall that.
Did you ever have to pay any rent with Mr. Sumlin in 2022?
Mr. Sumlin never paid any rent with me.
Did you ever have to pay any with him?
No.
Do you know of anyone else within YSL who is referred to as Mounk Tounk?
No.
Have you ever had any reason to charge money at a door for a light bill?
Not that I know. He never gave me no money for no light bill.
That's not what I asked. Have you?
So they were allowed to live in an apartment, okay, or house.
You, Mr. Sledge, ever had any reason to charge money at a door for a light bill?
No, overruled. Go ahead.
Could you repeat it?
Have you, Mr. Sledge, ever had any reason to charge money at a door for a light bill?
I don't recall. I don't remember, Ms. Love, but I know if you came to my house and stayed for weeks and months, eventually I want some money for you staying there.
I imagine so. Have you ever had any, I take it back. Have you ever had any reason to charge money at a door along with Mr. Sumlin for a light bill?
You already asked that question, Ms. Love.
I'm gonna object to relevance at this point.
Your Honor, I have a very good faith basis for asking this question.
Okay, well, you're asking him, basically, has he ever charged money at a door for a light bill? Charged anybody money at a door for a light bill, right? Just maybe ask
Yes.
that and then,
Yes. Yes.
because if he has no recollection, then he has no recollection whether he was with himself or somebody else. So
Yes.
if you want to make sure that he understands the entire universe of people, have you ever charged them? Go ahead and ask that. But then if he doesn't recall, let's move on.
Thank you. Have you ever been upset that people were hanging out with you or at you and a spot you may have shared with Mr. Sumlin and not paid bills?
I didn't share with him. He probably stayed a couple of nights, and when the bill came, I told him to give me money on the bill. That ain't.
Okay. And when you say stayed a couple of nights, where would it have been that he stayed?
He probably stayed in my room because I went home
Okay. And was that your room on Boulevard or somewhere else?
somewhere else.
Was it a house that you lived at?
I stayed there when I wanted to.
What street was that house on?
I think it was all Brown Mill. I'm not for sure. I think it was all Brown Mill, though. I'm not for sure.
Did you have a nickname for that house?
No, I didn't have a nickname for no house.
To your knowledge, did anyone ever call that house the Web?
I never hung it. I never been there when they called it the Web.
Do you know of a place called the Web?
I heard of it.
Do you know where it is?
It was off Brown Mill somewhere, but I never been to it. I just knew it was off Brown Mill.
Have you ever seen it?
I didn't know exactly what house it was whenever they was calling the Web, but I never been to it at that time, so I don't know.
Who is the they that you're referring to that called it the Web?
The streets. I heard people like at the gas station, I'm about to go to the Web. So I don't know.
Were those people YSL?
I guess.
Did you ever hear anybody other than YSL members talk about going to the Web?
Yes, I don't hear a female say they was going to the wedding.
Do you know or have any idea how far the web was from the place you said that you were at off Browns Mill Road?
No, I don't know exactly.
Do you know the last time that you talked to Kenneth Copeland?
I can't tell you the last time I talked to Kenny Copeland.
Do you recall whether you talked to him in 2022?
I don't recall.
Do you remember talking to Kenneth Copeland at all while Kenneth Copeland was in prison around that time? That time being 2022.
I don't know if I talked to Kenny Copeland in that time. I'm not for sure, my lord. I don't want to say the wrong thing, so I'm not for sure.
Right today, you don't remember?
Yeah, I don't remember. Right.
Okay.
So,
Do you remember whether you talked to Demekion Garlington?
when?
When was the last time you recall talking to Demekion Garlington?
Again, I have no clue what she's after.
I'll probably say 2022.
Okay. Did you ever talk to Kenneth Copeland or Demekion Garlington, either of them, about a RICO indictment?
You saying if I ever talked to them about it?
Yes, sir.
I don't remember. So if you have anything, you can refresh my memory.
Do you have any memory of having conversations about a potential RICO indictment before this indictment or its predecessor was ever brought forward?
I don't remember, Ms. Love. I'm being honest with you. I don't remember.
Thank you. I appreciate that. Your Honor, at this time, the state asks permission to publish 442 Yankee. I'm sorry. We tender 442 Yankee as evidence.
All right, that is admitted and you may publish.
Thank you, Judge.
Yeah, I agree.
We're on the record in the matter of the state of Georgia versus Antonio Sledge in 22.
Yeah. For you, if you recognize that voice, that is Judge Glanville. He was the presiding judge over this plea deal. And knowing what we know now, yeah, in my personal opinion, the way these plea deals are written, where this witness in this plea deal cannot assert innocence of the defendants. He is not allowed to, by his plea agreement, to say these guys had nothing to do with it. If he does, he is risking the plea deal revoked and is risking in the region of 25 years in prison.
2 SC 183572. Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge.
Good afternoon, Your Honor.
And good afternoon, counsels Love and Hilton. Okay, counsels, I understand this is supposed to be a negotiated plea. Is that correct?
That's correct, Your
Yes, Judge.
All right, Mr. Sledge, can I get you to raise your right hand as best you're able?
Yes.
Do you solemnly swear or affirm that the evidence you shall give in the matter now in hearing shall be the truth, the whole truth, nothing but the truth, so help you God or so firm?
Yes, I do.
All right, you put your hand down, sir.
Mr. Sledge, please state your true, correct, and legal name.
Antonio Sledge.
And are you the same Antonio Sledge, also known as Mounk Tounk, who is listed in indictment 22 SC 183572?
Yes, ma'am.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 41, 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes,
as
ma'am.
listed in count 30 of this indictment.
Yes, ma'am.
Do you understand that you have the
Yes. And well, oh wait, there's more. Under the RICO charge, there's 196 underlying or overt acts. And they are litigating all of them.
right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes,
today?
ma'am. Yes, ma'am.
Do you understand that this is a negotiated plea of guilty,
Yes, ma'am.
which means that the state will recommend to the court the following sentence?
Yes, ma'am.
As to count 1, 15 years to serve on probation, subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3, special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Do you understand that the court?
And this is why there are some things in the US justice system I can never agree with. Plea deals are one of these. For me, it is, I just don't understand it. If you have a criminal, you have a case, you prosecute that case against that criminal. When you're facing 25 to life and the prosecutor says, oh, we can get you probation just as long as you agree to testify and answer the way we want to those questions. No, you prosecute crimes. That I don't see how I ever can divert from this opinion that plea deals are no good, especially when the condition is testifying against another person, because then you have every incentive to lie, speak untrue or true. I don't care. Because I will give you an example. I covered a case in December. The Texas v. Dyke case, where the prosecution offered a plea deal to, in my opinion, the actual murderer. And because of the testimony of the actual murderer, the co-defendant got life in prison. In my opinion, that person, the plea dealer, may be a serial killer. Because in that case, where the victim was found, they found other remains on the exact same spot. And now we will never know, because the prosecution offered him that deal. The, in my opinion, probable killer. But let's move on with this trial.
Does not have to accept that recommendation, and we will read into the record the terms of the plea agreement in a moment. Do you understand that?
Yes, ma'am.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Yes, ma'am.
I'm showing you what has been marked as State's Exhibit 1AS. Do you recognize the document in State's Exhibit 1AS?
Yes, ma'am.
And is that your signature on page 7 of 7 of State's Exhibit 1AS?
Yes, ma'am.
Yes, Yvette, that's the crap rapper and his sugar mama case.
Your Honor, at this time, actually, and Mr. Sledge, have you had an opportunity to review each and every provision within State's Exhibit 1AS?
Yes, ma'am.
As reflected on State's Exhibit 1AS, the current charges that you face are count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, and count 30, possession of a firearm by a convicted felon previously.
Yeah, blah, 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 blah. Let's get back to the trial.
The agreement is not captured. I'm going to object to skipping forward. You know, I'll see.
Let's see.
Your Honor,
I'm not saying to skip anything substantially. I'm trying to
Right.
see if they can skip over the part where it's just repeating
skipping,
itself.
yes.
Yeah, but I can skip. Because for me, this isn't really necessary.
Presented to him. What was it? Is that the statement session as 1AS? If anyone wants to see it, if not, I'll go ahead and approach the witness.
All right.
Mr. Sledge, would you please take a look at 1AS and tell me if 1AS, which was admitted for the purposes of your plea, and the document we have been referring to, yes, thank you, as states 444 Yankee, and I will now add back the first 2 sheets. Would you please look at those 2 documents and tell me if states 444 Yankee is an exact copy of State's Exhibit 1AS that you signed on December 28th, 2022?
Look at the whole thing, or just the.
Yes,
Right,
sir.
sir.
Please look at the entire thing.
Yes, I remember this one.
And is State's Exhibit 444 Yankee an exact duplicate of the document labeled State's Exhibit 1AS?
Yes.
Right. Thank you, Your Honor. One moment. state has to.
All right, is there a cross-examination of Mr. Sludge?
Hey, cross-examination.
All right, go ahead, Mr. Sharp. Yes.
Mr. Kokomo is in need of the Zoom link.
It's the same it's been all week. Can you look at maybe a prior day's email? Or the state will forward it. Thank you.
Okay, for you who wonder, will there be a panel show today? Yes, it will. At 6 p.m. Eastern Time, as per usual. I have gotten yes from Kayla, Sylvia, and Kat. I'm awaiting answers from Steady, from Phil, from Doug, and so I'm awaiting more answers so I can publish, the thumbnail and blah, 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 blah. Hey, assistant, member for 10 months. Have you made it home yet, Nick? Yes, I came home last Sunday, so I've been home almost 2 weeks now. For you who don't know, I was in United States, and I was in that courtroom on August 14. I talked to some of the lawyers, with Sylvia, of course, the security personnel, and other people. I spoke with Woody as well, so that was interesting. I will return for closing arguments, I hope, if I can plan that far ahead to see if it gets to closing arguments at all, that I can be in that courtroom when it happens. So, roughly speaking, we are talking maybe March, April, May. I have no idea. But I hope to be there. And how you can support that is through my PayPal. Because the PayPal is where whatever comes in there is money I can use for these kind of extravagant stuff that I actually haven't planned for. But if we can time it good and I can get myself some vacation days, I will go there. And I'm posting my PayPal there. So if you want to support that journey, go right ahead. But as I always say, do not ever give what you don't have. Don't you dare. Don't you dare give something you're not absolutely sure you can be without. All right, let's get back to the trial.
He's in.
Mr. Sledge, good morning.
Good morning.
My name is Max Shard. I represent Shannon Stillwell, okay?
Yes.
All right. I'm going to be asking you some questions about that document that you were just reviewing. Do you have that up there with you?
No, she took it.
Okay. If I ask you specific questions about that document, do you think it might be helpful for you to have it in front of you to refresh your recollection?
Yes.
Okay. Your Honor, may I?
Yeah, I think it's right up with the court reporter.
Okay, putting my logo in the bottom right corner because we all want to see Mr. Sharp.
Okay.
Okay.
I'm not.
Okay.
We'll get there.
Okay.
And just please listen to my questions and then answer truthfully, okay?
Yes.
All right. Mr. Sledge, I'm going to ask you to go back to December 28th of 2022, okay?
Yes.
Now, that is the day that you pled guilty, correct?
Yes.
And that's also the day, as I understand it, that you initialed that document. Is that correct?
Yes,
Initialed the factual acknowledgements within the document, correct?
yes.
All right. Let me ask you one question before I get there, though. What day were you arrested on this case?
I want to say May 27, 2022.
May 27th, 2022. Well, that works out well for my limited math here. Okay.
Sustained.
So May 27th of 2022 to December 28th of 2022. That seems to me 7 months. Is that correct?
Yes, 7 or 8.
Okay. So on December 28th of 2022, when you initialed those documents, you had been locked up for 7 months.
Yes,
You had previously moved for a bond in this case, correct?
yes.
You moved for a bond on October 13th, I believe, 2022.
I don't remember the date, but yes, I know.
It was in October,
Yes,
and the state opposed your release on bond, correct?
yes,
And Judge Glanville denied bond, correct?
yes,
Okay. So on December 28th, 2022, you had been locked up for 7 months and 1 day, and you did not have a bond.
Objection, asked, answered, and compound.
Sustained.
On December 28th, 2022, you did not have a bond, correct?
Objection, asked,
Sustained.
Let me ask you, when you were locked up, we're saying locked up, where were you living? Where were you held?
at the Forest County Rice Street.
Okay, that's Fulton County Jail?
Yeah, jail.
Okay, and we're not, generally speaking, is that a nice place to be?
Objection, roll.
Overruled.
No.
Is that a dangerous place?
Yes,
Is that a filthy place?
yes.
Okay. On December,
For you who don't know, recently, just a few days ago, the extra guards the Fulton County Jail had hired because of overcrowding walked out of Fulton County Jail because they weren't paid. So they walked out. So Fulton County Jail per capita has more death than Rikers. Much more. I believe in the Shane Kendall case, which I also cover, the stats are, I believe it is Rikers with capacity of 30,000 people had 18 deaths in 2021 or 2022, I don't remember. Fulton County Jail, same year, 13. And they have a capacity of 2,300, but there are often more than 3,000 inmates there. So yeah, it's a dangerous place. And that is just the death. Then you have the injuries, the illnesses, the beatings, the filth. Yeah, saying it's not a nice place is an understatement. And it's still better than Rice Street.
December 28th, 2022, there were some things going on in your life, correct?
Yes,
Okay, you've already shared with us that your mother was ill.
yes,
Certainly, on that date, you wanted to get home to your ill mother. Isn't that correct?
yes,
You are also a father, right, Mr. Sledge?
Yes.
NYC.
You have 8 children, is that correct?
yes.
On December 28th, 2022, I don't need to know the age of every child, but what was the age ranges?
23,
kids.
the youngest 9.
8 kids.
The youngest was 9.
He 9 now.
Okay, so about 7.
Yeah, about 7 then.
And do your children live in Atlanta?
Yes, all of them.
Okay, do you spend time with your children?
Yes,
Objection, roll.
Sustained.
Do you attend?
After all of Miss Love's completely worthless, irrelevant questions, she has the nerve to object for relevance.
To your children's daily needs?
Objection, roll.
Sustained.
Your Honor, may I be heard?
You may.
It goes to his need to get out of jail.
All right, we'll get to it.
Okay. Do you attend to your children's daily needs?
yes,
Do you drive your children to school?
Objection, Your Honor,
Let's move along a little bit.
Okay. Did you have a significant other at the time?
Yes,
Evelyn.
yes,
And I don't even need to say her name. Her initials are DB.
yes,
Okay. On December 28th, 2022, did you miss DB?
yes,
Did you miss your children?
yes,
You indicated that Derek Wright is your attorney,
yes,
and he's represented you in the past,
yes,
and you hired him on this case.
yes,
When you testified, I want to make sure I'm correct on this, you paid him a certain amount of money, and I don't need to know the amount.
Objection, relevance.
He's testified that he did not, his understanding was he did not pay his attorney. You didn't, the money that you paid your attorney, you knew it wasn't enough for him to go to trial on this long case, correct?
yes,
That was your understanding.
yes,
That was his understanding.
yes,
You did not have an attorney to take this case to
All
trial.
right, no, now that we all know that that's not true, that anybody who can't afford an attorney is entitled to get an
Well, I'm
attorney
gonna get
without
there.
cost to them.
I'm going to get there. There were people in this case that couldn't afford an attorney, correct?
Objection, Your Honor, speculation, relevance.
People were,
Your Honor,
people.
This is highly relevant because for you who don't know, again, up until just before trial, there were people in jail without bond because there was not enough public defenders to go around in one case, in this case, because of, yeah.
Still don't have
Hang on,
attorneys.
hang on, don't talk over each other. That is not relevant to the question that you're asking him, nor to this trial going on right now.
Your Honor, may I be heard?
Yes,
If he knows he's going to
you
sit,
may, yes. You know what? Let's break for lunch, because I know that this is going to take more than 30 minutes for you to do your cross, so let's just break for lunch right now.
Okay, breaking for lunch so they can talk about what these people actually knew.
Oh, right, well, I've got some,
To my recollection, in December of 2022, around 10 of the 28 defendants did not have an attorney. First, you have the, what you call it, well, the public defender's office didn't have enough defense attorneys that could take on these people because there are other cases going on. And then you have that they simply can't take the case because of they have represented somebody else or some relative or whatever's. So what the state did, or the court did, they offered to private practitioners to go in as extra public defenders, more or less. They were offered first $7,000 for the entire case. Now that didn't bring many in, so they raised that to $15,000. After many months, years, well, at least 1 year, you have one person in this trial that is a public defender, Mrs. or Mr. Williams, Miss D. Williams. She's being paid $5,000 a month. Now, $5,000, I mean, that's not chump change. But for an attorney who only can have this case going on, that's not much. Because she has to pay for everything herself. Driving there, from, research, everything. So it's highly relevant that the people in lockup, in jail, knew that if they can't afford a lawyer, they have to wait for a public defender or one of these private practitioners. And many people didn't, up until quite recently. After spending over a year in jail, some of them, a year and a half in jail. That's when they got their public defenders and got themselves a bond hearing. A year and a half in jail without representation because the state didn't want to pay properly for public defenders.
We have to deal with some other matters. Let's say 1:30.
The other attorneys, except Miss D. Williams, is paid by the defendants.
Is that?
Yeah, now she's hurrying the defense. Yeah. She allowed the prosecution to take 3 days with this witness, which they claimed to her was a 3-hour witness.
Let's take up this objection.
So, Your Honor, and I say this not in a pointed fashion. You weren't here in the beginning of this case.
Yeah.
And I know that you're not presiding on a case with the other individuals. The reality is, people were severed off this case because our public defender system did not provide people attorneys. People were sitting in jail for up to 2 years. I'm not even sure everyone has an attorney to this date. These gentlemen that are not sitting here, that are sitting in 901 Rice Street 2 years later, I don't even know if they have attorneys now, but I do know when we started this trial, people were severed because the public defender's system had not provided attorneys. Mr. Sledge knew that. Mr. Sledge, and this is the reality, and I don't think we should hide it from the jurors. The reality is Mr. Sledge had 2 options: plead guilty or wait for an appointed attorney to try this case, and he would have been sitting in jail and he'd still be in jail today.
All right, all of those cases are ready to be tried right now. Everybody who's been severed out other than for that reason is ready. And
Okay, well,
Yeah, more than 2 years later. Now is not the issue. It is how was it in December of 2022?
right, and they're still in jail. And
well, so are all of these defendants.
Well,
So we're not going to get into that, are we?
Well, at this point, I really probably wouldn't mind, but I'm not going to speak for everyone else. But it goes to his mind state. He had 2 options: either take this plea or end up in the same bucket that Demekion Garlington and Demise McMullen and other people were in, which was be unrepresented, sit in Rice Street until the state gets about. So when we say we know people are appointed attorneys, yes, I know theoretically under the Supreme Court precedents and under our Constitution, appointed indigent individuals are supposed to be appointed attorneys, but in reality, that did not happen here.
That may not have happened immediately, but
It
it just
didn't happen.
happened. And
It didn't happen until very recently.
I mean, that does not need to be what is I mean, there are so many collateral issues in this case. So if you want to ask him much more pointedly what his understanding was, but we don't need to go through every co-defendant who may or may not have had.
Oh, I wasn't going to do that.
To be going down
No,
that
I was
road.
just asking if he knew. I was saying he was aware that attorneys were not being appointed to represent the other people he was with, and he didn't want to be in that situation. And Ms. Love was objecting, and I never got a chance to get to
Well,
it.
I mean, for all I know, Ms. Love's now going to want to cross-examine him on his actual financial affairs, but I think would be fair because I'm not sure,
don't have a
that
problem with
wouldn't be fodder for redirect at this point.
I mean, I don't really have a problem with her cross-examining him with his financial affairs. Mr. Wright might.
Well, I mean, why don't you propose a couple of questions that you think will get to the heart of the matter?
Well, I've already established that he didn't hire Mr. Wright to try the case. He was aware that other people that had been arrested that could not afford attorneys were remained unrepresented 7 months later. And he didn't want to be in a situation where he was sitting in 901 Rice Street without an attorney to represent him.
You are not going to be able to ask him about well, I see what you mean. Okay, well, let's not give it the impression that it's indefinite and still going on right now, because we all know that's not accurate.
Well,
That's not accurate. I can pull up all 19 of the co-defendants, I
Well,
guess, and look and
all
see, but
and
they're all represented. They
They're
have
all-
been for quite a while, right?
Yes, ma'am.
a few
Gone to
months.
several hearings with them and their
They're
attorneys.
at like final plea stage, aren't
But-
they?
Yes,
at
they're
the-
actually pushing for trial. in the middle of the
Except
trial.
that, yes, which needs to happen, but that's a whole other issue. Okay, so you get about one more question on that and then
I
move
proposed
on.
to.
Okay, what are the 2?
That he was aware that on December 28, 2022, there were people on this case that could not afford attorneys. They had not been appointed attorneys by that date, and he didn't want to be in their situation. I guess that's 3. not going to make compound.
May I respond?
Gimme.
Judge, I would object to Mr. Sharp's assertion, number one, that he's established that Mr. Sledge did not have the ability to secure Mr. Wright for trial.
So he said on direct that he didn't. He said, I couldn't afford Mr. Wright for trial, and that's why I pled.
Okay, we'll get into that. Also, I object to the speculation regarding, as speculation, his question regarding whether or not anyone else could afford or had an attorney or would be appointed an attorney or might have to wait for an attorney.
I wasn't asking for
It's not-
speculation. I said on December 28th, you
What-
knew that other people didn't have attorneys yet. We were all in court.
I
We were all
mean-
in court. We were all talking about it openly in court.
Yeah.
There were people there that did not have attorneys.
Yeah.
They all sat right there and looked sad, and we all
Okay,
openly
yes, Ms.
discussed
Love.
it.
Thank you.
I mean, that is
It is
true,
an
right?
improper-
That on December 28th of 2022, there were at least some co-defendants without an attorney yet because there are so many conflicts.
There were still on December 28th.
All right.
We would object that Mr. Sharp's line of questioning is an improper attempt to elicit sympathy from the jury. He has already asked and established that Rice Street is just the worst place in the world.
I know,
And
he's
he
not
wanted
going
to
into
get
that
out.
anymore.
Also,
He may be trying to establish sympathy, but I think what he's legally trying to do is establish motivations for testifying, and that he's allowed to do.
motivations for you
For
entering
whatever
court.
he's doing, for whatever this witness is doing.
Okay.
That's a legitimate.
Would the court indulge and ask Mr. Sharp just to repeat so that I can write it down exactly what those questions are that he intends to ask and that the court is about to rule on?
Did you mind repeating those?
I'm going to try to do it
Hi,
as quickly as
Kels.
possible. I was kind of making them up.
Hi, Nick. Good day. You always have the best sound. Hey, I do my best. I do my best. I have currently 2 sound boosters on. So even if the court from the pool from court is, I try. And sometimes it works. Thank you for your support of this channel. And also, she has some nerve to ask the specifics of the questions when almost every time she has been told you need to ask a question in a certain way, she tries to wiggle herself out of it. I hope if the judge agreed with it, that it will be returned right back at them.
Off the cuff. I
Off the
know.
cuff. You were aware that other people arrested on this case had not hired attorneys on by December 28, 2022. On December 28, 2022, you were aware that other people arrested on this case had not hired attorneys.
Okay.
On December 28, 2022, you were aware that some people that had not hired attorneys had not been appointed counsel and remained unrepresented,
Okay.
and you did not want to be
One of those people.
one of those people at Rice Street without an attorney.
Okay. And Ms. Love, if you want to voice what your objection is, if any, to those questions for the record, you may.
I'm getting that last compound one down. Remains unrepresented. And
Had not been appointed counsel and remained unrepresented.
So I have, you were aware that other people arrested on this case had not hired attorneys on December 28, 2022. And the second one is you were aware that some people who had not been appointed attorneys remained unrepresented on December 28, 2022. And you did not want to be one of those people. Did I get it
Well,
right?
that was my phrasing of it. His phrasing
You did not
was
want to be
unrepresented and in Rice Street.
correct.
So, Your Honor, I believe that the second question, in as much as he did not want to be unrepresented and in Rice Street, is fair to establish that point. But I believe that Mr. Sledge's awareness of other people or lack thereof or speculation about whatever their status was, it would amount to speculation, number one. It would amount to
Wasn't
hearsay.
Mr. Sledge a defendant in this
He
case?
was.
up
He
until
was.
the
I don't know if
time?
Ms.
So
Love-
that's not speculation.
I don't know if Ms. Love was here, but we had court hearings where
I'm
Unrepresented
going to
people,
permit,
also-
so is that a relevance objection or?
It is
something else?
there is a relevance objection to it. Yes, there is a relevance objection as well.
All right, I'm going to permit all of those over objection.
Thank you.
Anything else you think we're going to need to hash out outside of the presence of the jury?
It suggests impermissibly in my mind that the plea that Mr. Sledge gave was, and I mean, this may be something that we just argue, wasn't given knowingly, voluntarily, and willingly, when Mr. Sledge has already said that he pled guilty knowingly, willingly, and voluntarily.
You've got the video in evidence where he says that and
Right.
acknowledges it, so.
That is up to that's a
All
jury
right, so
question.
are there any other issues we think are going to need to be taken up outside the presence of the jury while we're doing this?
Mr. Steele just sent over a Dropbox link and we don't know what's in it yet, so we have to review it and we don't know yet whether
All
there's
right,
something
Ms.
else.
Steele, is that your potential cross? Okay. All right.
In Your Honor,
Yes, sir.
I plan on I'm sorry. In Your Honor, I just handed the state a one proposed exhibit that I'll be using, DS-36. It's actually from Discovery, but I've taken out all the commentary. It's ironically something that they're seeking to admit.
Okay, well, then they should not have. an-
Yeah, you would think that would be the case, but it's pictures of Kelvin Watts, Miss Intrevia Smith, and Mr. Sledge. And I'm going to ask him if he knows who those people are.
Any issue with that?
No,
Okay.
not to this. I haven't seen the rest of what's
Okay,
new in the
I
Dropbox.
know, everybody, nobody's seen Mr. Steele's stuff in the context of its use. Obviously, they've seen it in Discovery, but yes, sir.
Yes, Your Honor, I do have a document.
Okay.
I have a document that's provided in Discovery
Okay.
that I intend to use in a short statement.
All right, thank you.
And, see where we are.
Great, thank you. You want to go ahead and do that right now?
Yes, Your Honor.
Okay. Yeah, yeah. Mhm. Yeah.
And they come.
There's none of the pictures, there's only 4 in here. And it should be 4 wide, 410, 424 for the photos. None of the photos are up here that were submitted. And also I have not gotten a copy of the video, it's just that on the jump drive. Okay?
The video that we played today, that we edited.
This is 435 wide video.
Okay, we will provide that to you on a jump drive and via email.
On photos.
Yes, ma'am, we have the photos. We have another copy. I don't know why they're on there. I thought they were in there yesterday.
Okay.
I mean, if y'all want to,
Skipping ahead a bit.
so, I mean, if y'all want to maybe do that offline, I don't know if y'all have any dog in the Rule 22 or not, but. I don't know. Is there a Jason Whitaker here? He was one of the people that, if not, then we won't bother with that part of it. If he can't show up for it, then. Okay. They're what?
In the hallway.
Okay. Well, they can come in here beforehand. Are you Jason Whitaker? All right. Hello. How are you? Come on up to the podium. So I know you have just very recently filed a Rule 22, and I think we were going to have a hearing on Monday, but you maybe didn't get notice, so we had to move it to another day, because obviously you need notice in order to be here for
I
it.
was actually sitting right back there
Oh.
when your assistant called me. I was sitting there.
Okay, well, anyway, we tried to reach you, and that's why it wasn't earlier, is because
I
we
will.
thought that you didn't have notice, so sorry, maybe. I thought I even asked out loud, but anyway,
It's perfect.
here we are now.
We're here.
And I know that you want to film in some way. Here's the thing, is that we have already got a whole lot of people filming, and I'm gonna have Sylvia Parks in just a minute. I don't know if she's here right now. What I am gonna propose is.
Oh, Sylvia is there? Okay. This will be interesting.
It's essentially the same thing that I proposed with regard to Ms. Bumpus, is that you all kind of be pooled media.
Okay.
Because we just already have so much going on.
Not a
So,
problem.
That work for you?
Can I express what I was seeking to do? I actually didn't want to. Well, first of all, my name is Jason Whitaker.
Okay.
I'm a member of the community. I'm a Morris graduate and actually a former classroom teacher at Cleveland Avenue Elementary School, one of the schools that we've been
Thank you
talking
for
about.
that.
I do a podcast and
Okay.
we've been live streaming and discussing this case. And I did not want to actually record anything. I
Oh,
wanted to
okay.
just be able to, if possible, because I had the Rule 22, be able to use my phone and just update on things that have happened in court. That's it. Nothing more, nothing less. No filming, no picture taking, just being able to keep up with the community that's watching this. Actually, I stream it from home, so they're watching it out from my house. And they just be able to say, hey, this is what happened. Or if the audio goes out, say, hey, this is what you might not have heard, or anything of that nature.
We
So
don't
it's
say
not,
anything exciting when the audio goes
no,
out.
nothing exciting happens.
No,
when
I
the audio's
know.
out. So that's actually it. Just
Okay, well then you'll sit in the media row?
Yeah, absolutely.
Okay, because there are kind of different rules for the media phones and
I
other
will follow
people's
all the
phones.
rules that are
Okay.
given to me.
That's fine.
Yes,
You
sir.
may do that,
Okay.
yes.
Do I need to give you back this to get it signed, or does the
Had I known this, that this was an option, I would have done this when I was in the courtroom. That I could have joined you, or I could have started a stream or have someone start a stream for me, and then I could have been in chat with you all, giving updates on what was going on. I had no idea I could do that. Darn it.
deputy just need to know?
We do it all electronically, so I'll just, but my understanding then is that you just want to be able to use your phone to
And my laptop. This
post
is
essentially, but not to record in any way.
nothing's recorded,
Okay.
nothing's pictured.
All right, we'll get one filed that gives you that permission.
I appreciate it. Thank you so
All
much.
right,
Emily.
thank you.
Thank you.
Okay, Miss, is it Parks? Will that work or just Miss? Okay, come on up.
Here's Sylvia.
All right, so I know that you have been live streaming pretty much this entire trial, and I'm sure probably the pretrial proceedings as well. And it came to both the court's attention and defense counsel's attention recently that you had been on your, what do you call those things that you do? It's not a podcast, or is it? Do you still call it that?
It is a podcast,
Okay.
but it's
A video podcast. Okay, anyway, we'll call it a podcast. That you had been, and I know that you say in your letter that you didn't reveal any personal identifying information. And I think that you did not reveal enough to actually identify any of the jurors, but you were referring to where different people sat and their race and gender. And that is personally identifying information. And then you were giving them derogatory names. And you say in the letter that you provided to me this morning that you have always operated with great integrity, that the content you share represents factual reporting, and that you do your reporting with the, and these are all quotes from your letter, the utmost respect and integrity for all involved. Do you believe that any of those three statements that you made to me this morning is actually true about the names you were given those jurors?
I just want to give you the names or movies that I like. And, you know, SpongeBob is my daughter's favorite cartoon.
Do you think that those showed respect and integrity to the jurors?
Well, I didn't think it were bad names at all. Glasses, nose. No, I didn't think it was bad names. I showed you all the names.
The utmost respect and integrity?
I think it's depend on the individual. Well, to me, I felt it was utmost respect.
Well, I do not feel that. That seems like the kind of thing that a kind of mean person does on the playground in grade school.
You think so?
I do. I don't think that.
Are you fucking retarded, Judge? Are you a retard? Are you a fucking retard? That's derogatory. Giving somebody a name like SpongeBob, Nose, whatever's. Judge, how about Egg Lady? How about that one? There has been, in almost every trial I've ever covered, I have seen legacy media going full-blown with real bad, good and bad nicknames. I have seen this done in this very Fulton County court with other judges. where reporting has been with nicknames. So this derogatory? No, Judge, they are not. They, at best, at absolute best, you can say, I do not believe it is proper. But when you say it's something a bully says in a courtyard, you, Judge, have never been bullied. Not a day in your life. If you think that is bullying. No. The bully here is you, Judge Whitaker. You take your thin-skinned, easily offended opinion and apply that. Now, you are the judge. You can do that. But it doesn't make it right.
That shows the least bit of respect or integrity to the jurors or to the court system. So if you are going to, and let me ask you this, you talked in your letter about being media and freedom of the press. Do you consider yourself to be press and media and journalism?
I consider myself being a content creator. I create content.
Oh, no. You, Judge, has no authority, have zero authority to determine who is a member of the press or not. Absolute zero. Freedom of the press literally means freedom of the printing press, the medium through which you do your reporting. Not, oh, are you a journalist? Do you consider yourself? Oh, hell no. That is a complete and utter misunderstanding about the meaning of freedom of press. That freedom of press is freedom of the printing press, freedom of the medium of which you report through. I don't have a journalism degree. I report on this trial. Friday panel. Have you all seen panel shows on legacy media? Of course you have. No, Judge Whitaker. You do not have the authority to determine if somebody is a reporter or not. You do not.
For the community
Okay.
and give information. As far as journalism, I didn't go to school. I've taken
Well, and I
some
mean, you don't
classes
have
and
to,
things like
but-
that. But the information I believe is very vital for the community.
I don't disagree. I mean, this is court. It's one of the most important things we do in our country. But you say my role is to deliver news and information. So, I mean, do you, to that extent, consider, and you say you want to represent factual reporting. So do you, to that extent, consider yourself to be media, even if it's non-traditional media?
Yeah, I would think I would, because I've taken courses of like etiquette and things like that. But as far as and then the other thing too with my channel, it's more like some sort of like easygoing, friendly type of thing where people don't feel like it's just.
I'd love for you to keep it friendly.
Okay,
that would be great.
Okay, and I will never use the names anymore if it offend anybody, because that was never my intention to offend anyone.
Okay.
I was just using names of movies that I like, Twister, SpongeBob,
Right. Well,
and Ghost, things like that.
I mean, I realize that if you're trying to create content that fills, the entirety of every day, that sometimes you probably have to reach out somewhere to whatever pops in your mind at the time. But I would ask that before you do that you actually do keep in mind that this is a court proceeding. And I know a whole lot of people seem to be watching this as entertainment, but this is not entertainment for any of the people involved here. This is very serious. And it does a disservice, I think, to.
Yeah, I just had somebody over at Rumble trying to get me completely yeeted by referring to actual World War II German ideology. What that person didn't realize is that username actually has an email attached to it that I have now found other commentary on other platforms. Oh, I'm going to find you. Oh, I'm going to find you, and I'm going to ruin you. And I'm going to feel so bad. No, I'm not going to feel bad. I'm going to feel so good about it. And then I will completely forget about you because you have no worth at all. But I found you.
Everybody, when the coverage is flippant in the way that I think that was, okay? And I know you've got every right to do that if you want to. I would just prefer that you not.
I won't.
And I am gonna give you this, it's a code of ethics that the Society of Professional Journalists follows as a guideline.
Okay.
And I mean, you're not required to abide by it. It's not the law, but it might be helpful for you to take a look at it
I
and
definitely
just,
will.
you know, use it as a guideline.
I definitely will.
Okay,
I
so
definitely
if
will.
you can do that for me and try to be respectful and treat this with integrity, then you may come back in and continue to live stream.
Definitely.
All right.
This is the judge. Here's the thing. Having a camera, Rule 22 is about being able to record and the manner of recording. It does not regulate out of court statements. This judge applies out of court statements in order for somebody to be allowed to have a camera. Those are two different rules. And I do not believe Rule 22 goes this far. Now, does she have the authority to make rulings like this? Sure. But I still say this, making out of court statements a part of, are you allowed to have a silent live stream? Just the live stream of, then we are in big trouble if that, because have you seen some of the absolute shit that some of the actual journalists in law and crime puts out? Absolutely horrifyingly bad. With absolute disrespect for due process, for court, for defendants, for witnesses, for jurors. Absolute disrespect. Nothing happens. And that is the way everybody should be treated, because the size of your media should not be a part on if you're allowed to film or not. In my personal opinion.
I appreciate it. Thank
I'm
you.
gonna
I'm
honor.
gonna hand this up to you. Okay.
But Ms. Sylvia
All right, I don't know
are
if y'all
allowed
have had
in,
an opportunity now. We
and
can
that's
get
the
back
most
to
important thing
our
for now.
issues with, or potential issues with some of the exhibits that may be used during the cross.
Yes, Your Honor.
All
With
right.
the court's permission, may I maintain my seat bit because I'm looking at.
You may.
So in the Dropbox that we received from Defendant Williams, included are what appear to be, and I'll just take them in turn, exhibit number 15 alpha for Defendant Williams appears to be a video of LeBron James dabbing up someone and wiping his nose and saying slime.
Okay.
We object to that.
On what basis?
Relevance grounds.
I suspect the relevance is gonna, well, I don't want to speak for you, Mr. Steele. What's the relevance?
It just shows that this is not unique to YSL,
Okay, well, I
or
mean,
in a gang. Also, Your Honor, it's already in evidence.
it's already in evidence anyway. It's already in evidence.
That's possible.
It's
Probably,
already
it may
in
have gotten,
evidence.
that may have been the
All
case,
right,
and if
yeah,
that's the
if
case.
it's not, I
I'm-
can see,
Okay.
I'm gonna overrule the relevance
Okay.
objection to the extent it's not in evidence.
All right.
Any other?
And yes, there are apparently, so I'll name them again. 16 alpha from Defendant Williams is a person unknown to the state, a random person in what appears to be a TikTok video. And this person is They're singing.
Okay.
Apparently, they're singing Defendant Williams' song,
Okay.
and they're saying, and he's saying slat, 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 slat. They're lip syncing to it. It's a young female wearing a skull cap, lip syncing to Defendant Williams' song.
Which number is this?
Okay, in the beginning, there's no skull cap. She's
Oh,
just got
okay,
her
and she
hair
puts
straight
one
down.
on.
And then later on, there's a young lady in a skull
Okay.
cap. We object on 2 grounds: relevance, and in as much as it is Defendant Williams' statements, his statements, we would object as
So the prosecution is allowed to play and show cut and paste pictures and cut and paste edited video clips, but the defense aren't.
self quotations.
I don't understand
You
the
know,
self.
there is no
Right.
objection
Or-
that is, evidentiary objection that is self-quotation.
Self-serving hearsay. It's hearsay, Your Honor, and there's no exception for it. So I'll leave it at that.
It's non-hearsay. I'm not using for the truth. I'm just
Mhm.
showing what exactly now Mr. Sledge said that slime is just used. Slat is just used. He said it's used by people all over the world. He said people can say YSL, they're YSL. There's no initiation. I don't know though, Your Honor, if he
All right.
has seen these before. So
The
I just,
what? You don't know what?
I don't know if I could lay a foundation. I don't know if he's seen these before. So I would show it to him beforehand.
So, I mean, if this is an exhibit that's showing somebody lip syncing to one of your client's videos where he uses whatever this terminology is, that doesn't establish anything other than he put these things in a song and people sing his songs. That doesn't establish that she or anybody else would have used that terminology otherwise. So I'm going to exclude that. That does not show what you allege it to show.
I think that goes to potentially weight, but I understand the court's ruling.
Additionally, Your Honor, 16 Bravo from Defendant Williams is a video that I think it's safe to say has not been tendered previously. And it is, as it's loading, it's a young man whom we don't know the identity of, who is, I think, either singing or lip syncing.
Hey, Rose. Yeah, I started with recapping the entire week, but it got interesting. So I let the chat vote, and they voted go live, and I will continue the recapping tomorrow. So that is what's going on. Thank you for being here.
He's lip syncing Defendant song.
All right, let me say that anybody who is just some random person lip syncing or singing a song that Mr. Williams put out does not establish anything other than once he puts out these songs, people like the lyrics and sing the lyrics, and that.
Just fine. Yeah, I mean, this was expected because this has been the ruling all along. Maybe they should have found videos of random people outside of Georgia saying these words who are not in any way, shape, or form indicted, like other artists or something like that.
Doesn't establish anything other than that. That it is now in common parlance in the music business is probably not even an issue.
So I think that is the case for 16 Alpha, 16 Beta, 16 Charlie, 16 Delta, 17 Alpha, 17 Beta, 17 Charlie, 17 Delta.
No, that's wrong. So it
So
would
we're
be
still
under
going through
16 A through F would be
Okay.
consistent with this honorable court's
All right.
ruling. I will not attempt to introduce it.
All right.
17 A through E, some of them have already been admitted. Other ones are similar. It's just people who are using the nose wipe, if you know what I'm talking about, the finger across the nose.
Okay.
And that's what those are.
And those are already in or no?
No, not all of them,
All
but
right.
some
And
of
do
them.
we
What they are what they are talking about is this or this. I have always been under the impression that means you're missing your woman. But apparently it's a gang sign.
You know when these came into existence?
Yes, Mr. Trontavious Stevens and Jeffrey Williams exhibit, or JW exhibit number 17A
Uh-huh.
is already in evidence, and it's already marked 7 through E.
Judge, can we confirm that? Because I don't have that same memory of 17 Alpha.
Sure, and I guess
and-
at some point we really do need to sit down and sort out the evidence that came before me, but yes.
All right, so we do not have that same memory, and to the extent that it is not, if it is not, we would object on relevance grounds. It is an unknown person.
All right, do you know when it came into existence
Yes.
roughly?
We have the exact date. It's also 15. I think I said 17.
You did.
15A.
15A is LeBron James, right?
30 in, and Mr. Kumo is getting the date, if that's okay.
So you already talked about 15, if it's,
So 15A is not LeBron James lip syncing, is it?
it's LeBron
January
James.
2nd, 22nd, 2024 was admitted into evidence.
Yeah, so-
January 22.
Is he
2000.
also lip syncing one of Mr. Williams' songs?
Mr. LeBron James is coming into a locker room.
Uh-huh.
He has teammates. He's a basketball player.
Yeah.
I know you know that. but,
I know, you're setting up for the record.
um,
He's one of the most famous people in the world. Yes.
is greeting his teammates.
Okay.
And as he's greeting, he's doing different type of greetings. And one of them is the wiping of the nose.
Okay.
That's what it is.
Okay.
Other people in there, and I have to look to get the exact numbers, but is a baseball player on the Padres. Last name is Musgrove, Musgrove. He throws a pitch on the diamond. He strikes out the batter. It's a New York Mets, and he wipes his nose. Another one is Stephon Diggs. He's a football player on the Buffalo Bills. At that time, he's now on the Texans in Texas. And their quarterback, whose name I can't remember, Josh Allen, they both greet. It's the same type of thing. They greet in the huddle, and Josh Allen's going around other people. They wipe the nose.
And these are all in 15A?
No.
They should be 17A, then 17B, then 17C. I separated them all.
Okay.
So Your Honor, what we'd like to,
17D and 17E, and they just go consecutive. And the next one is CD Lamb. He's a football player on the Dallas
Okay, well,
Cowboys.
we're
It's the
probably
same-
getting cumulative at this point, but so are these all from like the 2023, 2024 era?
I'd say so. 20, maybe a little earlier, but yes.
Judge, so our objection is that, one, as we look at starting at 17A, these videos.
Folks, if you have pictures of yourself and are prepared to share, then contact the lawyers in this case, where you do that with photos that are from 2014, 15, 16, 17, 18, something of that sort. Because the nose wipe has been done for decades. I did it as a teenager, and that's a damn long time ago.
That Mr. Steele or Defendant Williams is seeking to have admitted are nothing more than people imitating a hand motion or lip syncing words that Defendant Williams appears to have made popular through his music and his songs. Defendant Williams has SLAT tattooed on his index finger as he wipes his nose, and is photographed in pictures and publications with that index finger, nose wipe, and word SLAT. The fact that his music that he has circulated has.
Oh, really? Are you going to take that? Judge, Mr. Williams is a very high regarded artist, and people like him. And so they started to do the nose wipe thing. What did that just mean when you were a teenager? Well, often it's, did I get lucky that weekend? Oh well, let's get back to the trial.
That people have taken to it and emulated it has absolutely no bearing whatsoever on whether or not either defendant in this case, and specifically Defendant Williams, committed any crime alleged in this indictment. It has no relevance whatsoever. It is a circular argument to bring about something that someone else is doing now because Defendant Williams did it. I don't believe anyone, and I can't speak for everybody who's going to get up there, but I don't believe that anyone is going to be able to say, unless they bring in the people who actually put these videos up, when these videos were created, when they were done.
You have put up videos that you had no idea when they were done.
There's no foundation, I think, that can be laid, and I don't think that any of them are relevant to any matter in this case.
Okay, well, I mean, the reason I asked about when they came into being is because the fact that something that a performer of the fame and magnitude of Mr. Williams has brought into more common parlance, if you will, within society doesn't really establish anything more than that. Why don't you pick 2 or 3 and let's just go with that, and that will, I think, establish your argument that this is just something that doesn't mean gangs at all. It just means, you know, this is what's cool in common culture right now. They'll let you do that. That will not prevent the state from arguing maybe what it is now, but that's not what it originated as. It's not what it means to the people in YSL. Y'all can argue that in front of the jury. But we certainly don't need, you know, 15 or 20 of these. So pick like 3, okay?
Hey, Iron Rabbit is here. Gifted 10 memberships. Oh, to T Migo, Chris A, Doublemint Twins, Des, Amy Ashbrook, Squinting Cat, The Queen Bee, Melissa Evans, Larry Ashton, Merchant Core. Yay. Thank you so much for your generosity, Iron Rabbit. And you who just gifted, first of all, say thank you. And then now you have access to all my members-only content on my YouTube channel. You also have access to members-only emojis, which are Nice Viking, Glad Viking, Love Viking, Boomer, Tractor, Female Viking, Three-Hole Wonder, Mr. Jingles, and Christmas Jingles. So, yeah, you have access to those. And you also have access to my Discord. Thank you so much, Iron Rabbit. Let's continue with this.
Also, I believe that I believe that 222 Alpha XX from Defendant Williams is a compilation that we've not yet. Okay, these are flyers of Defendant Williams that we object to.
Okay.
Based on relevance, they are self-serving. They are hearsay. So we object to 222 Alpha through XX. We have not yet looked at all of them because we didn't realize it has so many exhibits contained in the one. So I'm still sorting through them. They appear to be Defendant Williams flyers.
All right, and what would be the relevance of those?
So this, I couldn't get these. The state gave this to us in discovery. This is from Mr. Williams' Twitter account, and he advertises.
No, this is
From-
222
This is 220 Alpha through XX?
Yes.
Okay,
So he advertises his shows.
yeah.
And what I did was listening to Mr. Sledge. He may know about these shows.
Okay,
So-
in which case,
So then the state is saying that Mr. Williams is on Cleveland Avenue and Mr. Williams' notoriety has to be increased because of a drive-by shooting. And I'm saying the opposite. Mr. Williams is extremely busy. He is always in a studio. There's been testimony like that. There'll be more. And he's constantly performing around the time of 2014 going into 15, which is the relevant time period for Mr. Sledge's testimony.
and is that what all of these are from?
Yes, yes. So that's why I put them together. Now, it is extremely relevant because what the state is trying to show that Mr. Williams somehow is so interested in this gang that is on Cleveland Avenue and selling drugs from a convenience store. And I want to show the truth of what he's actually doing and how busy he is. So that's why these are here. They're not anything to do with hearsay. And this gentleman may not have personal knowledge of these events and shows because he was going with Mr. Williams as he testified to. And that's what I was going
And
to do.
are you going to hand them to him
Yes.
as like an exhibit that's a composite of a bunch of flyers?
I already did. I gave it, well, I didn't hand it to him. I gave it to the Honorable Mr. Wright, who I assume, because I know Mr. Wright, has gone through it with his client. And then I have a hard copy and I have the thumb drive, by the way. For
And they
the,
go from, it looks like they start in September 2014.
Oh, you did a little dirty. You handed it directly to Mr. Sledge's lawyer to see if he recognized any of these. Now, it's still up to the judge if they are admitted or not. But I think Miss Love was expecting to be handed over to her and the court. No. Good work, Mr. Steele.
And go through June of 2015. All right, you don't intend to display each one of these separately, do you? Because that's
I would try to get them into evidence and then use them at the appropriate time.
like a few, like a smattering,
That's right.
not 57 of them or however many there are, okay?
Well, I was
So I
going,
know, I mean, the jury will have a, a whatever inch thick
yes,
composite exhibit to look at.
but I will only, yes, I'm not going to go through
In
every one
terms
of them.
of court time, okay.
But I will be.
All right, I'm going to overrule that.
So, Your Honor, the response that Mr. Steele gave regarding it showing that Mr. Williams has a show or he's busy at shows and he can't be on the corner selling drugs. One, these are liars that he created. These are not photographs of Mr. Williams at the show. It doesn't even say
Yeah,
that
the
he went
point
to the
is,
show.
He should, okay, well, I mean, then I guess maybe you can make that argument, but he's got all of these things lined up on his schedule.
And then as to defendant Williams' exhibit, and of course that would be, I guess, as the court said, subject to a proper foundation being laid, assuming somebody, he can even talk about these, but exhibit 255 Bravo, Your Honor,
All right,
is a,
so we're going to a different exhibit now?
yes,
Okay.
it is. And would the court give us a number? Like, I know the court said a smattering, but is there a number? All of these
No,
flyers?
if you feel like he's getting beyond what's reasonable and that it's getting to be a waste of time, then you can make that objection and I will rule on it.
Yes, Your Honor.
Okay, let's look at 255. What's our issue with that?
So, Your Honor, 255 Bravo appears to be a collection of tweets from people that we do not know and have no knowledge of the identity of, saying and lie to their sister, baby, mama, and granny, and get on the stand and tell the God's honest truth. I just don't get it. These appear to be tweets from 2023,
Yeah.
which are after defendant Williams put his,
They looked at me like they're from 2013.
I'm looking, I don't see, okay, so. Okay, so as my team
Oh,
is telling me, as
I
we look
see.
through them, some,
Oh, it's way more than one page. Okay.
so 2013 to 2024.
All right, we don't need the ones past when Mr. Sledge himself used the term.
And so, Your Honor, we have never
And how did-
disputed that anybody else said that Mr. Sledge, in his testimony, he said it's a saying that people say. I didn't
Yeah.
argue with that because he said a lot of people say you lie to your mom, you lie to your sister. My question was, do they say you need to get killed?
Yeah.
So this is irrelevant, showing that somebody else says you lie to your mom, you lie to your sister.
Okay, but no, it goes beyond that though, because all of these also include, but tell the God on.
Yeah, and tell the God's
police.
honest truth, right?
So that, yes, you can use some of those to show that because you did ask him about all of that part and it will be clear that none of these say, but then you need to be killed. So, all right.
Yeah, Miss Love, you asked Mr. Sledge a whole lot of irrelevant questions that he answered to. And now the defense get the chance to cross based on your questions. Ta-da! Am I streaming to the end of today? Yeah.
So
We don't
are
need
all of
anything
them,
past that though.
is he going to be putting in 12 pages
I will-
of this?
I don't know how many pages there
I will barely be caught up after lunch.
are that are before 2015, but I think you can probably establish that point with a couple of pages worth. All right. else?
So the court is the court ruled earlier at the point that state believes is cumulative, make
he's
that
gonna-
objection then.
When I say a couple of pages, I mean one or two or three. Because they're like 7 or 8 on each page, so that'll make the point.
And that's all prior to
I
2015.
just expect this, I know we haven't defined a smattering, but I've defined a couple now. So I expect Mr. Steele to abide by that. And then what else? Yes, all before whenever he used it. When did he use it?
2015,
Okay. so
January
yes.
2015.
Mr. Steele has,
Huh?
when did he use it?
July 2015, Mr. Sledge.
That's what Mr. Sledge used.
Yeah, that's what I'm asking.
Okay.
So what you use to demonstrate that it's in common parlance needs to all be before that. What else?
255 Bravo is this, wait, that's the one we just.
That's what we just were looking at, I think.
So 255 Alpha is the same
Okay.
thing apparently.
That's the one with all of the flyers for, yeah, we've done that one.
So no, 255 Alpha literally is another 32 pages of tweets.
Oh, 255. Okay, I'm sorry.
Is a PDF, a 32-page PDF
We don't need that, right?
of
The same thing.
the same.
All right, Mr. Steele, we don't need 255 Alpha and Bravo, right? Okay,
I'm gonna go through July 2015. I got.
A couple of pages through there.
with 2 or 3 pages showing that. Okay. All right, what's next?
It's the same ruling in effect with respect to, and I think the court said smattering, I don't remember which one that applied to, with the wiping of the nose.
The smattering was the flyers showing his
Okay.
show.
Folks, I'm getting to get myself a sandwich. We'll be back in 5 minutes. We keep listening to this, and when I get back, if they are done, they are probably almost back from lunch by then.
Those.
Okay, so
He's gonna pick 2 or 3 from his exhibit A, I don't, or wherever they are, 15, whomever it is, I don't know whether you want to use famous people or non-famous people, but the ruling about singing the songs, those are just out. But people using the same kind of hand gestures, pick 3. I don't care what they are. Okay, so what else?
So Mr. Williams, for instance, on exhibit 34, if it's not already in, it's defendant Williams himself sitting there wiping his nose. And I think that might already be in. So I'm not sure if that's one that is being offered now, but for the ones that are not already in evidence, is the court's ruling that 2 or 3 other people that are not him who are wiping their nose are what will be allowed?
Wiping their nose, or if it's some other hand sign, just 2 or 3 things, 2 or 3 of these to demonstrate, whoever the other people in the world do this to.
And Your Honor,
I don't know that it's going to establish anything because this is 10 years after we have heard that YSL, which might be or might not be a gang, was created, but.
So, Your Honor, and we would ask as well, because I've seen, I'm not saying anyone in particular, but we would ask that reference to what is contained in the picture. For instance, do you recognize LeBron James wiping his nose? Not be made until it is established whether the witness on the stand, who is supposed to be the witness through whom it is entered, can establish whether they've seen it, know what
Yeah,
it
it's
is.
not, do you recognize LeBron James wiping his nose? It's, are you familiar with this? Have you seen this before in your life?
And given that Mr. Steele has already given Mr. Wright the exhibits, the answer will be, yeah, I've seen it.
Well, the fact that I think Mr. Steele probably knows how to handle a witness well enough to lay the foundation properly.
I'm just asking based on
If
what
you
has
want to
happened
then
so
get
far.
up and ask, never mind, I'm not even gonna suggest that. Okay, so are we clear on that? He can ask before today. What else?
I think that the videos of people lip syncing, the wiping of the nose, and the tweets about lying to your mama and telling the truth in court are the only 3 categories.
Okay.
And so since there are so many, I think we've covered
All right.
that. We'll look at it
All right,
closer.
and then we've got the proposed exhibit for Mr. Huey. Is there an issue with that? I haven't looked at that yet, but
So we don't object to the whole thing coming in, but I believe Mr. Matthews has indicated he wants to take the writing off. But if
I don't know what the writing says. And who are these people in this exhibit?
Yes, Your Honor, that would be Chanel drinks.
Okay.
Individuals that-
Yes, and
1 second, Your Honor.
it's talking to your mic. Okay, well, all right.
And to be
Hang on,
fair,
let's let them finish whatever and then get back on the same page all at the same time.
Let's skip ahead because we can. Yes, Rose. The defense needs to have Love clarify what she means by 3 hours. What kind of sandwich? It was hard bread with some mayonnaise and cheese. Now it is over 7 p.m. where I am, and it is Friday. And I think I will have myself a teeny tiny vodka tonic. Because it's Friday. It's been a long week. Just a tiny one. Oh, there's the sign. Let's see if the break is... Oh, it's not. Okay. What can we do meanwhile? I have an idea. I have an excellent idea. I hope I have an excellent idea. For you who are relatively new to my channel, sometimes you see in the chat people going, hi, and there's a history with that. And let's see if I, oh, yeah. This is from before I was monetized. This is from February of, it's St. Patrick's Day, 2023. And me and Jeff over at Legal Vices may have had a drink or two when we got into ancestry. So while we wait for the court to come back, here is the origin of Vikings saying hi.
That's what we've got on tap tonight over here. Because it is St. Patrick's Day, we've got a bottle of Bushmills. This was full about an hour ago, so that tells you what's going to happen tonight. And we haven't popped the seal on the Redbreast 12-year yet. We'll have to find a reason for doing that. All right, that takes care of the obligatory. Like I said, I'm 25% Irish. My father's family is Irish Scottish. Scottish English. My mother is, her mother is Lithuanian and her father is Irish. So I'm 25% Irish, but today is St. Patrick's Day, so I'm 100% Irish. And there we go. So we've got everything. We are full Irish tonight, and we're also pickled herring Swedish.
I managed to find the only thing green in my closet, and it's not the Hulk. It is simply what I wear when I'm driving the combined harvester. And yeah.
Why do you drive the combine harvester in like April? March?
Well, I use it when I do it. I'm not doing it now. This
Makes
is
sense.
the only green I have, and the only connection I have with the Irish is probably my ancestors went over there to say hi.
Rape and pillage. To say hi.
Yeah, but
the Vikings went over to Ireland to say hi.
yeah, hi, get down. No.
The Vikings went to Ireland to say hi. Hello.
That's a fancy religion you have there.
You're correct.
Let's destroy it.
And we're not doing a recap today because literally nothing happened yesterday, by the way, in case you were wondering.
Oh, yeah.
Nothing happened yesterday. It was a very normal day in court. The Vikings went to Ireland just to say hi. Hello. Hello, Irish people. That is the funniest shit I've ever heard in my life. The Vikings went to Ireland just to say hi.
I knew I couldn't say all the other words, and my mind blanked totally. Hi.
I'm trying to like flag some of these chats, and I can't because I'm laughing too hard. My hand won't stop shaking. Hello, Irish people. Hello. Hello.
Can we park here?
Christ.
Oh,
God, my rib. I'm doing an ab workout already. Oh, Christ. Oh, God. Hey, KB, I don't get this joke. Essentially, like right around 1000 AD, the Vikings just went and literally graped and pillaged everyone in England and Ireland. That's kind of the story. The end. In actuality, they just raped and pillaged the entire country, and we're just joking about them just stopping in to say hi. Oh my jeebus.
I saw the chat here. Hey, I'm Irish and DNA shows I'm Norwegian. Yeah, I wonder why.
I said like 3/4 of my ancestor are Irish, Scottish, and Irish, Scottish, and English, but my last name ends in son, so that tells you I'm Scandinavian by DNA.
Oh, yeah, that was the birthplace of Vikings saying hi. Oh, that was such a... Yeah, back then I had 700 subscribers. That was in March of 2023. And thanks to Jeff, I got to over 1,000 subscribers quite fast and all the watch hours I needed so I could get monetized. Now I am at 9,580 subscribers. I think I gained over 1,000 subscribers in August alone. And in September, I am at, well, first week, 73 more subscribers. So growth is there. Working on getting to 10K subscribers. And when I get there, we will celebrate. And with guests, with people you've seen here all the time and people you haven't seen in a while and all of that stuff. But when that will happen, I don't know. Hopefully I will be there mid-October, maybe. I don't know. But while we wait for that, they're back from lunch.
Have y'all had an opportunity to determine for the defense?
So now
what
we
that
are
exhibit's gonna look like?
really live. We are
Your Honor, that exhibit is kind of
a minute and a half behind.
Okay. All right, anything else before we get the jury in? Okay. So we good then to go ahead and get the jury back if they're ready? Okay.
Yeah, we are almost 5 hours in. And once this day ends, which I don't know when it does, then at 6 p.m. it is panel show, Friday panel show, where me and guests discuss what happened this week in the young Thug RICO-Trial.
So we're good then? Can we get Mr. Sledge back in? All right.
Oh, cross-examination time. And I want to see Mr. Shorts. There we go.
$395. Thank you.
Thank you, Kimmy G. Yeah. I don't have ads during my live streams. I have them for replay crew, but you do get an ad going in and out. But we are all different, all content creators, all streamers, but I prefer it this way. Would I make more money by allowing ads? Yes, but for me, I can only say how I would feel, and I would be a bit annoyed. Because, I mean, you have the option of membership, super chat, yada yada, and then replay crew. You can do that and give me some. I would put in one ad every 30 minutes or so. And if that's a big if, I'm not demonetized. And most of my streams are demonetized the first 24 hours after the stream is done. So I barely get any ad revenue. But I get some, a few bucks. Cadillac Law is good. I like Cadillac Law. I like AV to the 7th power as a person, but I also have the YouTube Premium, so I don't get the ads. And of course, Cat is always, when I'm not streaming, I'm listening to Cat, not Williams.
Your Honor, I was under the impression that this plea agreement, Mr. Sledge's plea agreement, had been admitted in evidence. But I think I was just basing on the fact that it had a exhibit sticker, which now
That says what, A1A? No, it's neither that or 444Y is in evidence. That has an exhibit sticker because that's the exhibit sticker from
previously
the actual plea
okay.
proceedings.
Okay, all right.
And it has the AS because it was for Antonio.
Right,
Sledge.
it hadn't been tendered, neither of those, neither it nor the 444Y has been tendered for admission here. Was it 444Y?
444Y, right?
That's
It
what
not
she was
tendered.
using before, and she had him compare the two.
Right.
But it's not in either.
Okay.
It's a copy.
What is the video?
The video is 442Y.
Thank you.
And that's the one that's just the portions.
Right, and that's
Yeah.
been admitted.
Yes. We're ready.
I'm catching up.
It's a lot of numbers.
Right, jurors are on the way in. And here we go, the rest of the cross-examination. YouTube, but I also on YouTube have put in limitations on what is allowed to be advertised on my channel. There's no gambling and no pharmaceuticals. That should be completely gone from my channel. Catnot Williams is doing great. I mean, she's on the regular 2,000-3,000 views at the same time. I'm extremely happy with 100, 150, 200, and the occasional 500-600. I'm very happy with that. I wouldn't mind more. And here's one of the things I like when my chat is, because I have no restrictions on my chat, but the more you grow as a channel, eventually you have to put in some limitations as only write every 30 seconds or something like that. But most of the time, I'm with you in chat and manage to read it, which I think is great with the interactions. Miss Love is mentally unable to not show her ass to the camera.
All right, go ahead, Mr. Short.
Thank you, Your Honor. May it please the court. Good afternoon, Mr. Sledge.
Good afternoon, Mr. Sharp.
All right. We had just, last thing I asked you was about your representation. Do you recall?
Yes.
Okay, and that you had not hired Mr. Wright for trial.
No.
On December 28th, 2022, okay, you were aware that, well, let me back up. Typically, have you ever had appointed counsel?
Objection relevant.
Just trying to educate on how it usually works. I'll move on. Okay. On December 28th, 2022, you were aware of co-defendants on this case who had been arrested.
Yes.
And there were some of those individuals who could not afford attorneys, correct?
Right.
And you were aware that some of those individuals were in Rice Street.
Yes.
Or they were in Rice Street.
Yes.
And those individuals that could not afford attorneys had not been appointed attorneys as of December 28th, 2022, correct?
Yes.
Okay. And isn't it true that you did not want to be in their position?
Yes.
Meaning you did not want to be in Rice Street without an attorney?
Yes.
Okay. You believed, for the purposes of having representation, it was in your best interest to resolve your case via plea on December 28, 2022.
Yes.
Okay. Do you know what coercion means?
No.
Okay. What about pressure?
Yes, I know what pressure means.
Okay. Being in, and this is your truth, I'm not asking for a legal definition, okay?
Yes.
Okay. Being in Rice Street for 7 months prior to your plea, did that put pressure on you to plead, to accept this deal?
Yes, a lot.
Okay. Being separated from your sick mother and your children.
This line of questioning is already been so asking.
Your Honor, he testified for 3 days already. I've been going for 10 minutes.
Yeah, but you did already ask him that.
Well, I'm just trying to conclude this line of questioning, then I'll move on.
Okay.
I haven't asked him about pressure yet.
No.
He wanted to go home, and now I'm asking about
Okay.
pressure. Being separated from your sick mother and your children, did that create pressure to plead guilty on December 28, 2015?
Yes.
Excuse me, December 28, 2022.
Yes.
And the fact that you did not have a lawyer for trial, did that create pressure on you?
Yes. Fact,
Asked and answered, relative of non.
how about facts not in evidence too?
The fact that you had not hired an attorney for trial, did that create pressure on you to plead guilty?
Object, that assumes fact not in evidence. And it also calls for speculation.
Overruled.
The fact that you had not hired an attorney for trial, did that create pressure on you to plead guilty on December 28, 2022?
Yes.
All right, I want to talk to you about the plea offer. And When you need to, you can refer to it, but I want you to listen to my questions, and if you can answer without, that's fine.
Yes.
Okay. At some point in late December 2022, you became aware that the state was making a plea offer in your case.
Yes.
Okay. And the state's plea offer was an offer for probation.
Yes.
Okay. And probation, I know we know what it is, but for the jury, probation is you don't have to be in custody, right? You're released.
Yes.
Okay. And you have to check in with a probation officer.
Yes.
In your mind, that's preferable to prison.
Yes.
That's preferable to sitting in Rice Street jail, correct?
Yes.
Okay. Probation would get you back to your family,
Yes.
get you back to your ill mother,
Yes.
and that would solve your issues as far as hiring an attorney to try the case.
Yes.
You were interested in a plea for probation.
Yes.
Okay. Now, as it turned out, there were factual acknowledgments that you would have to initial to receive that offer of probation, correct?
Yes.
Okay, when you first learned about probation, did you realize that there would be factual acknowledgments that you had to initial?
No.
Okay, but at some point your attorney told you to get this probation, you're going to have to agree to factual acknowledgments.
Yes.
Let's talk about the factual acknowledgments. Do you remember the first time you saw the factual acknowledgments on that plea form? Was it December 28th?
Yes, I want to say yes.
Okay. Could it have been earlier? To the best of your recollection.
Yes, I think if I'm not mistaken, yes.
Okay. Did you ever write a statement with your truth about what happened in 2015 and give it to Miss Love or any other prosecutor in this case?
Objection made as to your truth and what had happened in 2015, made overall.
Did you say 2015?
I did. About what this case is about. Did you ever write a statement?
Oh, about, not in 2015.
No, about 2015.
Overruled.
No.
Okay. Did you ever sit down with Miss Love before this plea?
No.
Okay. Did you write the factual acknowledgments?
No.
Okay. On that sheet of paper in front of you, I believe it has, do you know what letterhead is?
I think it's the stamp, something like that.
Okay, on the top of the paper.
Yes.
Is there letterhead that indicates whose office that paper is from?
It's a Fannie Williams. That what you talking about, right?
Yes.
Yes.
Okay, from the Fulton County District Attorney's Office?
Yes.
Okay. Do you know who wrote the factual acknowledgments?
No.
Okay. Who presented the factual acknowledgments to you? Was it Miss Love?
Yes.
Okay. Did you know Miss Love back in 2015?
No.
Was she hanging out with you in 2015?
No.
Okay. I'm not trying to embarrass you. You're a smart man, okay?
Right.
But you did indicate that you didn't know what the word notoriety means.
Yes.
And you've also just said you didn't know what the word coercion means.
Yes.
Okay. Could you look on that in that document with the factual acknowledgements should be page 3. I'm going to ask you to look at factual acknowledgement 1. On the last line, does it have the word notoriety?
Yes.
Okay. I'm going to look at factual acknowledgement 5 on the last line. Does it say notoriety?
You sound 5.
Yes.
Yes.
I'm going to ask you to look at number 16. On the third line down on 16, does that say notoriety?
Give me 1 second. You sound what line?
The third one down on number 16. That's page 5.
Yeah, I'm on page 5.
Okay.
Yes.
All right. Could you go to page 6 and look at the last word on page 6? Does it say coercion?
Yes.
And those are words to this day, I guess before this trial maybe, that you never knew the meaning of.
Still don't know the meaning of them.
Okay. Do you write sentences using words that you don't know the meaning of?
Objection, Your Honor. Relevance.
Sustained.
Now, in preparation of your plea, whether it was on December 28th or before that, you did speak to your attorney, Mr. Wright,
Yes.
about the acknowledgements,
Yes.
correct?
Yes.
And you brought certain acknowledgements that are on that sheet to the attention of Mr. Wright and told him you don't agree with those.
Yes.
Okay. And were you present for discussions that Mr. Wright had with Ms. Love or the state?
No.
Okay. But to your understanding, some of the acknowledgements that you did not agree with, the state refused to change, correct?
Yes.
Okay. And you wanted to go home.
Yes.
Did you let a disagreement with those acknowledgements stop you from getting home to your sick mother?
Objection, speculation, and.
I said, did you let?
Objection as to the form of the question, whether did you let that? Objection.
Can you rephrase your question?
Those disagreements with the acknowledgements, did you let those disagreements get in the way of you getting home to your sick mother?
No.
Objection, Your Honor.
I mean, you basically asked the same thing, the same way. You just moved the the phrasing around. I don't really know. Can you rephrase it again?
Okay. Can I break it up?
You
Okay.
can try.
You disagreed with some of the factual acknowledgements that Ms. Love presented to you, correct?
Yes.
Okay. And you brought that to your attorney's attention.
Yes.
And you were told that the state was not going to change those factual acknowledgements.
Yes.
Okay. On December 28th, 2022, did you let your disagreement with the factual acknowledgements stop you from entering that plea?
No.
Why not?
Because I wanted to go home to my sick mother.
You have, during direct testimony, when Ms. Love was asking you questions, you've stated that you disagree with several of the factual acknowledgements in this plea agreement that you
Yes.
signed, correct?
Yes.
Just for information, folks. None of the defense attorneys have any interest in Mr. Sledge remaining at home. They have zero interest if he violates his plea agreements or not. Their sole responsibility is zealously defending their clients. None of the defense attorneys have or should have anything against throwing Mr. Sledge under the bus. And yes, I agree with Sharon Alexander. Sounds like entrapment to me. Yeah, they keep folks in jail for a extended period of time in what is described as hell on earth conditions, and then they are offered, we can let you home. Just sign this. Hi, Bryce.
You watched the video of your plea earlier today, correct?
Yes.
Okay. Those acknowledgments on that video, who was reading those acknowledgments? Was it you or Miss Love?
Miss Love.
Okay. When you were saying yes, ma'am, do you remember that? To
Yes.
pretty much every question, is that fair?
Yes.
Weren't there times during that plea, during that video, where you were saying yes, ma'am, before Miss Love even asked the question?
Yes.
Why were you saying yes, ma'am, if you disagreed with the factual acknowledgments?
I was just trying to get home to my sick mother.
Okay. Did your attorney tell you, or you testified that your attorney told you that you could explain those disagreements later, correct?
If I was called in to the stand, yes.
Okay. And you were advised not to let those disagreements get in the way of going home, correct?
Objection, Your Honor. Objection as to attorney-client privilege, objection as to hearsay, objection as to an improper line of questioning, to an improper topic.
Okay, sustained on facts not in evidence.
Okay. When you came to testify in front of this jury, you were under the impression that you would be able to explain what you disagreed with, correct?
Yes.
Do you know the saying, you're between a rock and a hard place?
Yes, I heard of it.
Okay. Do you consider yourself in between a rock and a hard place right now?
Yeah. Yes.
Okay. The rock is that you know some of these things in this plea agreement aren't true, correct?
Yes.
The hard place is you don't want to go back to prison, do you?
Yes.
Yes, you do not want to go back.
I don't want to go back to prison.
Okay.
Thank you, Vicky Hatter, 82.
And the problem is your plea agreement, correct?
Yes.
Let's talk about this plea agreement. In this indictment, you were charged with 2 counts, correct?
Yes.
Count 1, RICO,
Yes.
or conspiracy to commit RICO, I should say.
Yes.
And count 30 was a gun charge, correct?
Yes.
Specifically, possession of a firearm by a convicted felon.
Yes.
For count 1, let's talk about that, what the plea agreement was, okay?
Yes.
The agreement if you initialed the factual acknowledgements and entered a plea, the agreement was that the state was going to recommend 15 years of probation.
Yes,
And that meant that you would get out of jail immediately.
yes,
I'm going to ask you to look at Part 5 of the plea agreement, number 2, under defendant's sentencing acknowledgements.
what page is that, Mr. Shaw?
That is page 5.
Okay. And what number?
It's number 2 under section 5.
Yes, I'm looking at it.
Your agreement states that defendant, that's you, right?
Yes,
Okay. Defendant understands fully that if he violates any provision or any special condition of the plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections. And in parentheses, it says prison. Is that accurate?
yes,
Okay, so let's break that down a little bit. You're aware that a condition of your plea is to testify consistently with the factual acknowledgements you signed
yes,
that you say are not true.
yes,
And according to this agreement, if you fail to testify consistently with those acknowledgements, the state can move to revoke your probation, correct?
yes.
Do you know what revoking probation is?
Yeah, I think take it back, send you to, however, take the probation back, revoke it and send you to prison.
Okay, so if you have 15 years remaining on probation,
Yes,
the state can bring a motion and ask the judge to send you to prison for those 15 years instead of being on probation, correct?
yes,
Okay. Let's talk about the agreement for count 30, possession of a firearm by a convicted felon. Okay. Your lawyer told you that count,
Sustained.
you are aware that count carries a mandatory 15 years in prison,
yes,
and that 15-year sentence needs to be consecutive to any other sentence that you have.
yes,
So it'd have to be 15 on top of the 15.
yes,
On page 1, under negotiated sentence, it says, where it says count 30,
you said page 1?
yes, page 1, sir.
Okay, yes,
It says for count 30, that was the possession of firearm by a convicted felon, correct?
yes,
Okay. It says sentencing withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant, that's you, right,
yes,
has complied with the special conditions outlined in sections B, C, D, F, and I of section 3, special conditions of sentence of this plea agreement, the state agrees the defendant shall be allowed to withdraw his plea on count 30, and the state shall agree to no pros count 30. That's what it says, right?
yes,
Okay, so let's talk about what your understanding of what this means. On December 28, 2022, you pled guilty to possession of a firearm by a convicted felon.
yes,
Okay. And under normal circumstances, that would be 15 years in prison consecutive.
yes,
Okay. But the state in this agreement allowed sentencing was withheld, correct?
Yes,
So you weren't, even though you pled guilty to count 30, you were not given a sentence.
yes,
You were not given 15 years to serve in prison.
yes,
And sentencing was withheld until after this trial.
yes,
Okay. And your understanding is if you testify in accordance with this plea agreement, the state will dismiss that case.
yes,
Even though you've already pled guilty to it, the state will go back, let you withdraw your guilty plea, and dismiss the case.
yes,
You've been in trouble before, right?
yes.
Okay, you ever have an agreement, a situation like this in any of your other cases?
Sustained.
I'm going to ask you to look at part 5, number 4. Okay, and that's under defendant's sentencing acknowledgments. You with me?
Yes, I'm with you.
It's on page 6, right?
Yeah, 6, 7, yeah, I'm with you.
Okay. Number 4 says, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in his plea agreement, such failure or refusal nullifies. Do you know what nullifies means?
No.
Okay. It says nullifies though, right?
Yes, it say that, but I don't know what it means.
Nullifies any promise made by the district attorney to null pros count 30 of this indictment. Right?
Yes,
And to your understanding, regardless of whether you know what nullifies means, if you don't testify consistently with the factual acknowledgments that the state wrote,
yes,
they will take back their promise to dismiss count 30 and you'll be sentenced.
yes,
And you have to get 15 years in prison,
yes,
consecutive to the probation that would be revoked.
yes.
Can you look at number 3 under section 5? So I'm on page 5 now, going into page 6.
I'm with you.
Says defendant understands fully that any violation or of any provision or any special condition of the plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law.
Yes,
Okay. All that on that video talking about he has to testify truthfully. In your mind, who gets to determine whether you testified truthfully or not?
Objection, relevance, and objection improper and vague. Who gets to determine?
He was about to answer. He knows what I'm asking.
It's a binary question whether it's true or not. Determining whether something is true is irrelevant.
It's
Rephrase your question.
who gets to revoke your who moves to revoke your probation if they're not happy with what you say here today?
Objection. Objection, Your Honor.
Unfair characterization. What is your objection?
One, yes, that.
I said who moves?
Relevance, it is not a fair characterization, and the terms of the agreement that Mr. Sledge entered into have already been put before the jury, and the characterization that is being made at this point is improper and not relevant.
Sustained on the improper part. You want to, if you want to try to rephrase it.
I mean, Remember when I said that nobody in this courtroom likes Miss Love? Yes, I know that Judge Whittaker sometimes aids the prosecution a bit too much. I don't think she likes her either. You know, Judge Glanville would have not let any of this in. She actually allows Mr. Shard to rephrase a question that is actually quite objectionable. So, yeah.
Have you, in your life, have you ever seen a defense attorney try to revoke someone's probation?
Sustained.
Can you go?
Oh, let me just, Amber, see. What is the benefit for the state to charge under RICO compared to just individually charging each defendant? In a RICO charge, each defendant are considered responsible for other people's crimes. The rules of evidence are much lighter. The rules of hearsay, much broader. For instance, in this case, there are 196 overt acts in one charge, the RICO charge. There are 40 more charges in this trial. If one sticks, they can all be pronounced guilty. All of them. And sentenced to 20 or more years in jail, in prison. So that is the short version.
What is section 5, number 5?
Which?
Okay, and that's on page 7?
Yes, 6, 7. Right.
Excuse me, you're right, 6. Thank you. Says, defendant understands fully that defendant's violation of the provision of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections / prison. So it says, right?
Yes.
Okay. We talked about 15 plus 15, that equals 30, right?
Right.
But in number 5, it's saying you're going to serve as much as 35 years.
Yes.
And even though that's an extra 5 years, you initialed it.
Yes.
Why did you initial it?
Because I wanted to get home to my mother.
Okay.
And I ain't understand whatever the words you've been using. I don't understand the words there.
That I'm using or that are in this document?
In this document, right.
I just want some clarity.
Yes.
You testified that you have a 9th grade education. You attended Southside High School, now Maynard Jackson High School, right?
Yes.
Okay. In the video, you said 10th grade. Is it 9th or 10th, or you?
I was actually trying to say I completed the 9th, but I was in the 10th grade.
Okay. You ever receive any legal training?
No.
Okay. I'm going to ask you some questions, and I'm not asking what the acknowledgements say at this point, okay?
Yes.
Well, let me take that back for a second, okay?
Yes.
Just to make sure we're on the same page.
Yes.
Okay. Let's talk about the acknowledgement. Now, number 3 on the factual acknowledgements, that's on page 3. You with me?
Yeah, I'm with you.
All right. Now, you testified that this acknowledgement is in fact false, correct?
Yes,
Okay. I'm going to read the acknowledgement with you, and then we're going to talk about the truth, okay?
yes,
The acknowledgement says, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demekion Garlington and Quindarius Zachary appeared in a video with another person, AS, wherein defendant brandished a weapon used to drive in a drive-by shooting, and wherein, on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-paramour, parentheses, girlfriend.
yes,
Okay, that's what it says.
yes,
And so you see where it says, and to support, in the first line, I'm just going to reiterate, and to support and express loyalty to YSL, it says that in there, right?
yes,
And it says, on behalf of YSL.
yes.
Okay. Let's talk about that. May I approach, Shonda?
You may.
Mr. Sledge, I'm showing you a document marked DS-36.
Yes,
Okay? Do you see that there's 3 pictures in that document?
yes,
Okay. Can you identify the 3 people in those pictures?
me, Antonio Sledge, and Trevius Smith, and what his name, Watson or Kevin Watson, whatever.
Kelvin Watts?
Yes.
Is that also Shell Kel?
Shell Cal, yes,
You also call him Kel?
yes,
Okay. Your Honor, at this point, I would ask to admit DS-36 into evidence.
Submitted.
Permission to publish, Your Honor.
May.
Mr. Kokomo, would you please publish DS-36? Okay. Now, Mr. Sledge,
yes,
we talked about how you're with a lady with the initials DB now, correct?
yes,
Okay. Before DB, back in 2015, was there a young lady that you were involved with?
yes.
Okay. And what was that young lady's name?
And Trevius Smith,
Okay. And what did you call her?
Treva,
Treva?
yeah, Treva,
Treva. Okay. Do you see Treva in DS-36?
she at the top of the photo,
Okay. And do you see yourself in DS-36?
right there to the left.
Okay. And who's the other gentleman in the bottom right on DS-36?
That's Kel,
Kelvin Watts?
yes,
Okay. Do you recall when you started, how would you describe in respectful terms your relationship with Miss Entrevia Smith?
how did I, at the time,
Yes.
it was great,
You cared about her.
right,
Would you call her your girlfriend?
yes.
Okay. When did you start dating, we'll say, Miss Smith?
I've been knowing her since probably like, I've been dating her since probably like 2009, but as the relationship, probably like 2013.
Okay. So by 2015, you'd been in a relationship with her for at least 2 years, maybe longer.
Yes,
And you've known her for 8 years at that point.
yes,
9 years. Okay.
yes.
At some point, did she start dating another man?
From my understanding, yes,
Okay. And who was that other man?
Kevin Watt,
Okay. And do you know, was she dating, and I'm not trying to embarrass you, Was she dating you first or Kelvin Watts first?
Me,
Okay. Do you know from your vantage point when she started dating Kelvin Watts?
I don't know at the time when she started dating.
Okay. And when you found out that she was dating Kelvin Watts, did you immediately break up with her and say, no, I don't have anything to do with you? Or did you keep having a relationship with her?
We kept conversing.
Okay. Did the fact that you and Mr. Watts were simultaneously dating Miss Smith, did that create problems between you and Mr. Watts?
Yes,
Okay. Did that lead to an internet back and forth between you and Mr. Watts?
yes,
At some point in 2015,
Yeah, this goes to the prosecution's case that he did this showing of gun and all the things for furtherance of the conspiracy. As it turns out, it was over a woman, not YSL.
did you hear that Mr. Watts was looking for you?
yes,
And was all that revolving around your rivalry over Antrevia Smith?
yes,
You remember when the state played a video of you and Mr. Zachary with guns?
yes,
Okay. You said it was childish, right?
yes,
And at this point, Your Honor, I would ask for the state to publish what's 441Y. It's either 441Y or 395Y. 441 Yankee, thank you. Could you publish that?
Little strip this ass nigga. When little strip this ass.
Okay, thank you.
Little strip this ass nigga. We ain't really going back and forth no nigga. We don't go. You little bitch ass nigga. I know who we hit. I'm everywhere. Yeah, fuck you nigga, Kel. Whoever else, nigga. Well, nigga. Pop, 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 nigga. Whoa. They said they ain't really going back.
Okay, thank you. All right. Back in 2015, were you a little bit emotional about the situation?
yes,
Okay. And in that video, that was posted on the internet, correct?
yes.
Did you post it on the internet?
I think me or Zachary posted, one of us posted.
Okay. You intended for Mr. Watts to see the video.
Yes,
And in the video, you said you heard that Mr. Watts was looking for you, right?
yes,
And you're in that video with guns,
yes,
and you're in that video with Mr. Zachary,
yes,
and that's Quindarius Zachary, right?
yes,
Little D from Cleveland.
yes.
Okay, and that is someone that you have known since he was little, right?
Yes,
You grew up.
Yeah, yeah. My today's stream has been yellow for quite some time, which means I don't get more or less any ad revenue. And now during live streams, it's marginal. You get an ad on your way in and an ad on your way out, maybe. But as of now, you get no ads.
Together in the Capitol Homes neighborhood in Atlanta.
yes,
Apartments.
yes.
How far did you grow up from him?
How far did I grow up?
That was a horrible question. You guys were both living in the same apartment complex, right?
Yes,
Now you're older than him,
yes,
and he was a little boy at that time, right?
yes.
Okay. Would you see him every day?
No, I wouldn't see him every day.
How often would you see him?
When I used to walk past his door to get to the basketball court, he'll be on the porch.
Okay, are you particularly close with him? Or were you back in
At that
2000?
time?
Yes.
No.
In 2015, you weren't?
Oh, 2015, we were very close.
Okay. And in that video, did you ever hear anyone say YSL?
No.
Did you ever hear anyone say gang?
No.
Did you hear anyone say on behalf of?
No.
Okay. Did anyone tell you to make that video?
No.
That was your decision.
Yes.
And you made that video because you were mad at Kelvin Watts because he was running his mouth.
Yes.
Because y'all were dating the same woman.
Yes.
Okay. So let's go back to factual acknowledgement 3, which deals with this video. Says, again, it says, while associated with YSL and to support and express loyalty to YSL, did anything about making that video and talking junk to Kelvin Watts, did any of that video have to do anything with supporting and expressing loyalty to YSL?
No.
Okay. And then later on in factual acknowledgement 3, it says, and wherein on behalf of YSL. Was there anything about that video that was done on behalf of YSL?
No.
Thank you. Okay. Let's talk about factual acknowledgement 5. It says, okay, let me back up. Factual acknowledgement 4, let's look at that, and that's on page 3. You with me?
Yes.
All right. It says, on or about April 28, 2015, as reflected in Fulton County Indictment 15 SC 138994, defendant, that's you, right?
Yes.
And fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video, referenced in part 3 of this section, targeting family members of a rival gang. Okay?
Yes.
All right. And then on number 5 of the factual acknowledgements, it says, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4. Okay? Above, on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. See where it says that?
Yes.
Okay. And I'm just reading that. I'm not saying it's true.
You okay?
Okay. Okay, let's talk about that case. And that was 15 SC 138994.
Yes.
You were charged in that case, correct?
Yes.
Mr. Demekion Garlington was charged in that case, correct?
Yes.
And Mr. Quindarius Zachary was charged in that case, correct?
Yes.
No one else was charged in that case.
No.
And that night, April 28th, 2015, I believe you testified you were at the Club Crucial.
Yes.
And Demekion Garlington was at Club Crucial.
Yes.
And you didn't go together, right?
No.
But you both happened to be there.
Yes.
And you're friends with Demekion Garlington, or you were at that time?
Yes.
Okay. And at some point, well, let me ask you one other thing. There were some young ladies at the club that you knew as well, correct?
Yes.
Alexis Bryant was at the club, right?
Yes.
And a young lady named Summer Good was at the club.
Yes.
And Summer Good is the girlfriend of Quindarius Zachary.
Yes.
Okay. Quindarius Zachary was not at the club.
No.
Okay. But his girlfriend was.
Yes.
Okay. And you indicated that Demekion Garlington was jumped by certain individuals.
Yes.
Okay. Did you observe the fight?
Not from the beginning, no.
Okay. On that date, did you know, while you were at the club, did you know who was jumping Demekion Garlington?
No.
Okay. Was this a major fight?
It was
Let me ask a better question, because
Okay.
that was vague.
Okay.
Was this the type of fight where people were punching and kicking Demekion Garlington?
Yes.
Okay, and there were a lot of people at Club Crucial, right?
Yes.
A lot of other people you knew.
Yes.
Okay. Demekion, you said you left the club without Demekion Garlington.
Yes.
Okay. But then you received a call from Demekion Garlington.
Yes.
And the reality is Demekion didn't have a car.
Yes.
Okay. You had a car.
Yes.
Right. So Demekion asked you to pick him up.
Yeah, he asked me to come back and pick him up. Yes.
Okay. Demekion was upset, correct?
Yes.
Was Demekion drinking that night?
I can't tell you if he was drinking that night. He probably wasn't even in the club that long. So I don't know if he was drinking or
You
not.
know if he was using drugs, popping pills, anything like that night?
Probably before he got there, but I didn't see him pop any pills.
Okay, were you drinking that night?
Yeah, I was drunk.
You said you were drunk?
Yeah, I was drunk. Yeah, drunk. Yeah.
Okay. So Demekion is upset after getting jumped in the club, and he calls you to come pick him up. And you're drunk and you think he might have been popping pills and don't know what else, right?
Yes.
Okay. Demekion had been publicly humiliated, right?
Yes.
When you guys were driving from the club, Summer Good and Alexis Bryant were following y'all's car, correct?
Yes.
They were leaving the club at the same time.
Yes.
And again, that Summer Good being Quindaria Zachary's girlfriend.
Yes.
Okay. And to your understanding, Summer Good was scared.
Yes.
Because people were following her car.
Objection, Judge, call for speculation.
Sustained.
Okay, well, it was your car and Summer's car. Was there another car following behind y'all?
Yes.
Okay. And Quindarius Zachary, who wasn't in the club, was called about the situation, correct?
Objection, calls for speculation. Or in hearsay.
Well, you went to pick up,
Sustained.
okay, you went to pick up Quindarius Zachary, right?
Yes.
Okay. And the purpose of you picking up Quindarius Zachary was to take him to the house where Summer Good was.
Yes.
To protect her.
Yes.
Your Honor, objection. Speculation.
It's going to be, she knows the discovery. It's going to be completely obvious.
It's background hearsay.
Well, I mean, it's happened at this point. Let's kind of get to whatever it is that you're trying to get to here.
Summer Good was at a house, at Alexis Bryant's house on Landrum Drive, correct?
Yes.
And you and Demekion Garlington, this is after the fight, picked up Quindarius Zachary and drove to that house on Landrum Drive.
Yes.
Where Summer Good was.
Yes.
Okay. And when you all arrived at that house, you saw someone shooting at that house.
Yes.
Shooting at the house that Summer Good and Alexis Bryant were in.
Yes.
That's strange. Why wouldn't the prosecution bring this up? Maybe because it's ruining their case. What weird. Aren't this prosecutor supposed to go after truth? Nah, not this prosecution.
You were driving the car, right?
Yes,
Not the car that was shooting. You saw a car shooting and you're driving in a car pulling up.
yes,
You chased those people off that were shooting at the house, correct?
yes.
Okay. At some point, and I think your testimony is that you don't know who they were, but one of the other individuals in the car, your car, determined who was shooting at the house that Summer Good was in, correct?
Yes,
And it was determined that you were to drive them to the house where those people stayed at.
could you repeat that? Cause I didn't understand.
I asked in a bad way. You're in the car and it was determined someone, not you, but someone felt they knew who was shooting at the house with Summer and Alexis, right?
Yes,
Okay. And then you ended up driving to a house.
I don't think I went to another house after that.
Sorry, folks. There is a very annoying fly buzzing around here, and this is my electronic fly swatter. So if you see me going berserk here, you know what's going on.
Mr. Shaw, I'm not for sure.
Well, let me back up. In your testimony, you said your testimony was you drove Quindarius Zachary and Demekion Garlington to a house, right?
Yeah,
and they had guns.
Yes,
And they got out and did whatever they did to that house.
yes.
Okay. That wasn't the house that Summer Good and Alexis Bryant were in on Landrum.
No,
Okay, so after you saw that house, the first house where Alexis Bryant and Summer Good were being shot at, you drove to another house where Demekion and Quindarius did whatever they did. Right?
yes,
Okay. And you pled guilty to that.
yes.
You don't know who jumped Demekion Garlington.
No,
Okay. You drove to the first house on Landrum where Summer Good was because Quindarius Zachary wanted to protect his girlfriend.
yes,
And once you saw people shooting at the house, Demekion Garlington and Quindarius Zachary wanted revenge, right?
yes,
Quindarius Zachary wanted to go back at the people that were shooting at his girlfriend.
yes,
And Demekion Garlington wanted to go back at the people who he felt jumped him in the club.
yes,
Okay? That was personal revenge, correct?
yes.
Mr. Shaw is a really good
In
at cross-examination. Just
You're
say.
43 years old.
Yes,
Okay? You know Quindarius Zachary since he was this big.
yes,
You know Demekion Garlington, I believe you knew him since he was a baby too, right?
yes,
Okay, in retrospect, you were the older person in the situation, correct?
yes,
You should have known better than to drive them anywhere, right?
yes,
Okay, but you did.
yes,
Okay, but the bottom line, and you pled guilty,
yes,
and you served your sentence.
yes,
The bottom line is Jeffrey Williams didn't instruct you to go drive to any houses at night.
no, Jeff wouldn't know nothing about it.
Okay.
Objection as to speculation about what someone else knew.
Sustained.
Ask that question be stricken from record.
Okay, you don't know what Jeffrey Williams knew on any given night, but he didn't order you to go to any house.
No, no,
Okay. And no one was out the window shooting guns, yelling YSL, YSL.
Objection, compound question.
Overruled.
No.
The reality, Mr. Sledge, is what happened on April 28, 2015 was done on behalf of Demekion Garlington, who got jumped in the club.
Yes.
Was done on behalf of Quindarius Zachary, whose girlfriend was getting shot at.
Yes.
It was not done on behalf of YSL.
No.
It was not done to increase the notoriety, reputation, or fear of YSL. Was it?
No.
While this is excellent for the defense, it's really damning for Mr. Sledge. Because he is now going back on more or less everything he stated in his plea deal. But as I said earlier, the defense attorneys have no obligations against Mr. Sledge. They only have obligations for their clients. And that's it.
Okay. The state asked you about, I'm on page 5, Mr. Sledge. Number 14 and 15. Okay. And I'm gonna read those in a second, but I just want to ask you some questions. Okay. We already established it. Did you grow up, Mr. Sledge?
Yes.
We'll get to that in a second.
Okay.
I want you to listen to my question. Okay.
Yes.
Thank you. You grew up. We've established that you lived in Capitol Homes. Did you grow up in Capitol Homes?
Yes.
Okay. And Capitol Homes, does that still exist, or has it been torn down by now?
They tore down, but they call something else now. Capitol Gateway or something like
Capitol
that.
Gateway.
Yeah.
Okay. Could you help me understand what area of town, what street is Capitol Homes on?
Memorial Drive.
Okay, it's on Memorial Drive, maybe 5 minutes from this courthouse, right?
Yes.
Okay. They made it nicer now,
Yes.
but back then it was rough neighborhood, right?
Yes.
Okay. And then, how long did you live at Capitol Homes? Till what age?
I don't remember exact how old I was, but whatever year they got tore down.
Were you a teenager or?
Yeah, I was a teenager.
Like,
I probably was grown.
so if you were a teenager, we're talking about 18, 19, not 13.
Yeah,
Okay.
yeah.
All right. And then eventually you ended up living off of Boulevard, correct?
Yes.
Okay, did you go straight from Capitol Homes
To Boulevard.
to Boulevard? And when we say Boulevard, we're talking like the Bedford Pines.
Yeah, Bedford Pine Apartments.
Okay, those are right by the intersection of Boulevard and like North Avenue, right?
Yes.
Okay, great. East side of Atlanta.
Yes.
Okay, both these places, Capitol Homes and Boulevard, are, well, you tell me, how long do you think it would take to drive to Cleveland Avenue?
I can't give you an exact how long, but if my mind regular, probably about 15. Probably 15 minutes from Capitol Home, probably about 19 from Boulevard, 20 somewhere in there.
Okay. Bottom line, it's not the same neighborhood,
No,
miles apart.
miles apart.
Okay. Have you ever lived off of Cleveland Avenue?
Stay off of Cleveland Avenue.
Or on Cleveland Avenue, or stayed off of Cleveland Avenue?
Yes.
When was that?
I want to say it was probably like 2008, 2009, somewhere in that era.
Okay. And for how long? Could you, I'm not asking for exact address. You live off of in the Boulevard area now, right?
Yes.
Okay. So How long did you stay on Cleveland Avenue?
Not long. Well, my kids stayed over there, but I actually moved to Boulevard.
Okay.
But my kids and their mother still stayed over there, so I used to go over there.
Okay, so you used to go over there.
Yes.
And I'm asking you, okay, correct me if I'm wrong. Did you ever formally live over there?
No.
Okay. Now, I hate to ask you this, but you've been a drug dealer before in your life, right?
Yes.
Okay, you have a history of, I mean, your criminal record reflects that, correct?
Yes.
Okay, you've been arrested for selling drugs downtown Atlanta.
Yes.
Okay, you've sold drugs in the past. We're talking about the past, off of Boulevard.
Yes.
Okay, you've sold drugs around many areas of Atlanta, correct?
Yes.
Okay. You talked about hanging out in these gas stations. And you said, your testimony, as I recall it, was that sometimes you would hang out in the gas station with your own personal bag.
Yes.
And if people wanted a little bit off of your personal bag, you would sell it to them.
Yes.
Okay. And you would hang out with Christian McMiller and Darius Ford.
Yes.
Okay. Personal bag, we're talking about bag of marijuana?
Yes.
Okay. And we're talking about if someone, for me, for instance, asked you, hey, can I buy some of that marijuana off of you? We're talking about $5, $10 type stuff, right?
Yeah.
Okay. Petty.
Petty, yeah, some petty.
Okay. Do a lot of people sell drugs out of gas stations in your experience? Has foot traffic, right?
Objection, relevance as to whether or not a lot of people.
Sustained.
Have you sold drugs in gas stations before?
Yes.
Okay, you sold drugs in gas stations downtown, right?
Yes.
It's relevant, Your Honor.
Overruled.
Yes.
You sold drugs at gas stations off of Boulevard before, right?
Yes.
Okay. And your testimony is that you would occasionally hang out at some gas stations on Cleveland Avenue with your personal bag of marijuana.
Yes.
With your friends, Big and Mac Miller.
Yes.
Okay. Would you be there 24/7?
No.
Okay. How many times would you say total that you hung out at these gas stations? Is it more than a dozen?
Yes.
More than 2 dozen?
Yes, probably more. Yeah. I pull up and just kick it and then leave.
Okay, when you say you would pull up and kick it and then leave, is it fair to say that you were not part of some complex drug distribution network in these gas stations?
No.
Okay, so when you would just kick it and leave, we're talking about you staying around for how many minutes?
Sometime an hour, less.
Okay. All right. And you say, you thought, I want to get this right. You thought maybe more than a couple dozen, more than 25 times total.
Yeah.
Sometimes stay for like an hour.
Yes.
Okay. You'd also hang out at the park.
Yes.
Hang out at other stores.
Yes.
That's where the mother of at least one of your children lived.
Yes.
Okay. That area, not the gas station.
Yes, that area.
All right. And from your observation, and I know you don't want to speak on the dead, so I'm going to keep it brief. Your two friends would sell drugs at those gas stations.
Yes.
They'd sell drugs other places too, right?
Yes.
Okay. Tell me about the time that you and Christian McMiller and Darius Ford pulled out AK-47s and chased everyone out of the parking lot to protect drug turf?
Never.
Okay. You just observed 2 people selling weed at a gas station before.
Yes.
Okay, let's go back to your factual acknowledgments that you signed on December 28, 2022. The gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. Okay, now it is true that in your mind, Darius Ford and Christian McMiller were YSL associates in your mind.
Yes.
And they would sell drugs at these 2 gas stations, 151 Cleveland Avenue and 221 Cleveland Avenue, and a bunch of other places, correct?
Yes.
Okay, but you haven't seen anyone do anything that would lead you to believe that they did not allow other gangs to operate in those gas stations, did you?
No.
No violence,
No.
no attacks.
No.
The factual acknowledgement that the video about Shell Kel had
Yes.
something to do with YSL, that was incorrect.
Yes.
The factual acknowledgement that the shootings on April 28th, 2015 were done on behalf of YSL, that was incorrect.
Yes.
The factual acknowledgements that YSL or YSL associates do not allow other gangs to operate at these 2 gas stations, those were incorrect.
Yes.
These money that you would make selling little $5, $10 bags, whatever, of marijuana, would you run to Jeffrey Williams and give him those $5 bills, $10 bills?
Never.
Okay, would you run to Shannon Stillwell and give him the $5 and $10 bills?
Never.
Mr. Sledge, I'm going to ask you to go to page 6 or 7 again. Okay, let me ask you, before you sign these documents on December 28th, you moved for bond on this case, correct?
Yes.
You moved for bond on October 13th, 2022, correct?
Yes.
And the state opposed your bond, right?
Yes.
They said that you were a danger to the community.
Yes.
They said you were a threat,
Yes.
and you were denied bond.
Yes.
That kept you away from your family.
Yes.
On the bottom of page 6, it says, the last sentence, I freely, knowingly, and voluntarily entered into this agreement without force, threat, or coercion. And we already said you didn't know what coercion meant.
Yes.
Let's just say pressure.
Yes.
That's not true, is it? You were pressured.
Yes, I was pressured.
In fact, you were pressured into signing a document that claims that you're entering the agreement without pressure.
Yes.
We talked about that bond hearing before December 28th, where the state called you dangerous, too dangerous to release.
Objection, Your Honor. One facts not in evidence, 2 improper,
He was
and
there.
3 irrelevant.
He was there. Did they call you? It's not for the truth of the matter asserted, it's for the state's stance.
Objection relevance. The state
It's
stands
very
regarding a bond matter for this witness has no relevance or bearing on the guilt or innocence of either of the defendants here.
No, it doesn't, but I don't think that's what he's offering it for.
I'm
I'll
not.
permit it.
They told you, they said to the judge that you were too dangerous to let go, right?
Yes,
Okay. When you initialed these acknowledgements that they wrote, they gave you probation, right?
yes,
And then something came up.
And Your
Because-
Honor, I'm sorry, I know that the objection needs to be at the same time, but as I thought about it, that was hearsay as well. What the state told him about his dangerousness or whatever.
Oh, come
I'm not saying
on.
it's dangerous.
Literally, the question was, did the state say that you were too dangerous to let go? That's hearsay. There is no, that's hearsay.
It's not for the truth of the matter asserted.
Overruled.
Again,
That squeak from her chair is so funny. It is the chair itself telling her to F off.
they said, not saying you're dangerous. They said you were too dangerous to let
Objection,
go.
already asked and answered.
Well, I'm trying to recap because I keep getting interrupted.
Well, she's entitled to interrupt you if she thinks she's got a legitimate evidentiary objection.
Okay. After you initialed these documents next to the statements that they wrote, they gave you probation on count 1, right?
yes,
Objection, asked and answered.
Okay, sustained.
And something came up in court because you pled guilty to count 30, but weren't being sentenced. You had to be given a bond on that in order to be released.
yes,
And all of a sudden, on December 28th, after you initialed these statements, the state recommended a signature bond. Isn't that correct?
Oh, this is going to be
The
good.
signature bond means you get released and you don't even have to pay any bond at all, right?
yes.
Yeah. All of a sudden, not a danger anymore.
Have you ever been able to figure out what made you so dangerous before December 28th?
Sustained.
I have no further questions. Thank you.
All right.
That, folks, is an excellent cross-examination. That was excellent. Now, I want to share with something for this cross-examination, but I'm going to give you the choice, folks. Should I share with a jug? Well, pour it from 100% straight corn whiskey, or from the jug of Pasung SMR tequila. Press 1 for whiskey, 2 for tequila. Or just say whiskey or tequila. Come on, folks. You can't choose both. you in the chat, yeah. No, not both. Yes, Yvette, I like yogs. Well, I'm doing a rough calculation, and it seems like no, not both. If I get no, damn, because it's so even. I'll make it into a Poll. Whiskey or tequila. I can't spell. So let's make it a poll. There you go. There you go. While we're waiting for the result of the poll, this is an excellent cross-examination where Mr. Shaw got Mr. Mounk Tounk, or whatever he calls himself, made him go back to more or less everything he signed, which will get him in trouble, probably. And how the damn can the poll be 50-50? Stop doing this. I don't want to have both. Oh, come on, more votes, more votes. Whiskey or tequila. Do I have my egg timer here somewhere? I should have it here somewhere. It is not here. Who stole my egg clock? So I can time this. It goes to every time there's an even vote, it's 50-50. No, no. Come on, stop doing 50-50. All right, I'm going. Here's the thing. I will have the poll up while we listen to this one.
Prison the line, they be strolling through Atlanta streets. Crimes unfolding, but here's the twist. They're just a myth, ghosts in the night, they don't exist. Streets are buzzing, stories flying, legends living without denying. But in the shadows, truths resist. Quez and Lil Mike, just a twist. They're just illusions, they're closing the mist. Crimes and tales, but they don't exist. Walking down, doing all the crimes, staring stars in our ruthless rhymes.
And I will close the vote in 5, 4, 3, 2, 1, and closed. Oh, wow. Whiskey or tequila with all the votes in whiskey by 52%. Oh, you guys were really aiming for a draw, weren't you? You were really aiming for a draw. All right. Jug time. As you can see, never opened. This is Platte Valley since 1856. 100% straight corn whiskey, distilled in Missouri. Ooh. And thank you, Cindy, for the $5 super chat. Thank you so much. Mr. Short, here's to you and your excellent cross-examination. Thank you. Cheers. Oh, this is good. I did not expect, because this, I mean, my thought with whiskey in a jug was it's novelty, but this is actually good. Nah, how about that? How about that? Ooh. Cindy, thank you for the super chat that says tequila. Thank you to the amateur iconoclast for gifting 5 memberships. Given to Legio Gemina, Yvette, Here Comes Drama, Wrestler's Mom, and Darlene. Now let's see here. I have to bump. We are actually at roughly $92 in super chats and gifted memberships. If I get $8 more to an even $100, I will I will pop open the tequila as well. Yeah, but let's continue with the next person.
Charity, I'll need a break before we move on to the next
a break.
cross. Okay, let's take a 10-minute or so break.
Why did I say $8 more? I should have said 50 more, but hey, I'm not going back on my word. I wonder what his lawyer is going to say to Mr. Sledge. Whiskey bottled in a jug is historically accurate. I would assume so. Okay, let's see if they have anything to say or if they... No, directly to break. Dun, dun, dun. And, ho, how about that? What good timing. Oh, crap. All right. All right. Thank you, Cindy. And yes, Slidey Pie over Rumble. Miss Love's squeaky chair is like a clown horn. Thank you so much, Cindy. Let's see, how do I open this as you can see, never been opened. And it's resisting. Why are you resisting? You should be easy. Come on. There you go. Let's see if it makes a pop. Let's see if this is good in a jug. I mean, generally I like jugs. Ta-ta. Never mix your liquor. No. I'm a big advocate for every other. And I guess every other now means whiskey or tequila. Cheers. Surprisingly smooth. What's going on here? I mean, recommendation. Now, of course, my experience of tequila is more often this one. You know, the red hat one, bottom shelf. And that jug was delicious. Thank you so much. Thank you so much, Cindy. And that's a very, very nice cat. I almost said the wrong word. Okay, let's get back to the trial. Slängte. Prost. Na zdrowie. Cheers. Skål.
State's attorney, sir. There they are. Yes. Yes. All right, can somebody get the jury for us? Thank you.
Okay.
Yeah. Looks like I made two good choices by pure accident. That both the whiskey and the tequila was good. Now, I have yet to test this wicked pickled, spicy pickled flavored whiskey, but I will save this for the panel show later today. A big reminder, it's 9 p.m. here, not 3 p.m., even though it's 3 p.m. at your place. Two individual good choices combined into one not so good decision. I have no idea what you're talking about, but it does remind me of my teenage years. Hey, Amber C. Cheers. Thank you. Thank you for your support. Thank you for your $10 super chat. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. And I mean, for those who have gifted memberships and super chatted today, thank you. Thank you. Thank you. Thank you. Thank you. All right, let's get back to the trial. I don't know where Mr. Jingles is today. He hasn't been inside all day. But it's September, it's harvest time somewhere on one of these fields. So it's probably chasing mice. Mr. Steele. Here. Now, of the cross-examinations I've seen so far, Mr. Steele and Mr. Shard has different approaches. Mr. Steele is good at winding witnesses down, but he tends to get a bit more technical. Mr. Shard is very approachable the first half of his cross-examination, and he's completely ruthless by the end of it. So, two different styles, and I enjoy them both.
I'd like to ask you, if you don't mind, to lock in on June 9th, Sunday, 2024, if you can. Do you remember being located at a Starbucks in Fayetteville, Georgia?
Yes.
And the gentleman who is seated in the first row here, the nice-looking young man in the who's now smiling, can you tell, ladies and gentlemen, Jerry, who that person is to you?
My attorney.
Okay, and he has a great reputation.
Yes.
And he's been with you, you said, approximately 15 years. And when I say with you, representing you, and he knows you and your family personally.
Yes.
He has become a lawyer for you, but also a friend to you. Is that fair to say?
Yes.
And his name is the Honorable Derek Wright. Is that right?
Yes.
All right. And he was kind enough to put us on a Zoom call at my request. Do you remember that?
Yes.
And that was shortly after, in fact, it was later on Sunday, June 9th, 2024. Is that fair to say?
Yes.
And during that call, I identified myself as Mr. Jeffrey Williams' lawyer. Is that fair to say?
Yes.
All right. And you told me, as well as your lawyer, that you met earlier that day with Prosecutor Love.
Yes.
An investigator who's a female with dark hair. Do you remember that?
Yes.
Do you remember her name as you sit here today?
I don't know her name, but I see her in the courtroom.
And is she the very, very kind young lady, third row back, smiling as well?
Yes.
Okay. And she identified herself as a coworker to District Attorney Love. Is that right?
Yes.
And you freely went there to meet on your own time in Fayette County, right?
Yes.
And you did that to be courteous. Is that fair to say?
Yes.
And you did that because it's also, you knew you were going to testify and you wanted to tell the district attorney's office any information that they wanted to hear, right?
Yes.
And you also want to learn from them what it's like to testify. Is that all fair to say?
Yes.
And you said earlier on your, it's called a direct examination. It doesn't matter what it's called. When you were being questioned by Ms. Love, you said that she had a cell phone with her. You remember that?
Yes.
Either a laptop, an iPad, or some sort of device.
Yes.
And was she taking notes? Do you remember?
I think she wrote some on her notepad. I don't know what she wrote, but I know she wrote some on her notepad.
And I want to go over with you a couple things that you tell the jurors, whether it's true. And then my second question is going to be whether you told District Attorney Love that, okay?
Yes.
And when I say that, I'm talking about Wednesday, June 9th, Sunday, June 9th, 2024 at Starbucks, okay?
Yes.
Do you remember telling with your lawyer there and the investigator at District Attorney's Office and District Attorney Love that shortly before, days before, the God forbid death of Donovan Thomas?
Yes.
You and a gentleman named Brian Williams, known as Birdman, do you know who I'm talking about?
Yes.
And others, including Jeffrey,
Yes.
were all together.
Yes.
and you were outside in the parking lot of TIG Studios.
If I'm mistaken, I want to say it was TI Studio, not TIG.
That's fine.
Yes,
And you were having a good time.
yes,
When you told District Attorney Love that you were with Donovan Thomas and Jeffrey, did you make it known that there was no animosity? That's a bad word. Let me change it. Let me ask a different question, okay? Did you make it known that everyone was having a good time?
yes,
Did you see any type of argument or spat or anger from Jeffrey towards Mr. Thomas?
no,
Did you see any anger or spat or argument from Mr. Thomas towards Jeffrey?
no,
In fact, you observed they were friendly, right?
yes,
You knew they were good friends, right?
yes,
You knew that Jeffrey really cared for Donovan Thomas. Is that fair to say?
yes.
Objection, Your Honor, as to this witness's ability to know, that would be speculation.
You can ask something foundational.
Okay. Did you observe, from your observations, did you observe that Jeffrey liked Donovan Thomas?
Yeah,
It's sustained.
Did you observe from your observations the demeanor is a bad word too. Did you observe that there was friendship between the two of them?
Objection, Your Honor, that's still speculation.
There, rephrase, please, sustained.
Let me ask you this. When you told that to District Attorney Love, was your lawyer right there at the same Starbucks?
yes,
Was he there at the same table?
yes,
Do you remember sitting outside the Starbucks?
yes,
Okay. Did you see District Attorney Love make any notes when you told her that?
no,
I noticed she didn't ask you about that. Do you remember her asking? Maybe I missed it. Did she ask you about that when her 3 days of questioning you?
no,
Let me ask you this. When you were at that Starbucks on that Sunday, June 9, 2024 in the afternoon hours, do you remember telling District Attorney Love that on the evening after Donovan Thomas was, God forbid, shot, so it's January 10th, 2015. That's the date I'm locking on, okay?
yes,
You remember telling her that you were at Jeffrey's home
yes,
and Kenneth Copeland was there,
yes,
among other people,
yes,
and Jeffrey was there.
yes,
And at some time, Kenneth Copeland was receiving calls or received a call from the police saying that he was a suspect in this murder or the shooting of Donovan Thomas. Is that fair to say?
yes,
And that Jeffrey or Mr. Copeland was asking, what do I do? Do you remember that?
yes,
And Jeffrey said to Mr. Copeland, if you had nothing to do with the killing, you should go and talk to the police.
yes,
And you told District Attorney Love that, right?
yes,
In front of the Honorable Derek Wright, your lawyer,
yes,
in front of, or I don't know if she's paying attention. I'm not saying she was, but the investigator was around.
she was there.
And do you remember District Attorney Love telling you that she would prefer if you don't state to the jury that Jeffrey told you to take Mr. Copeland to the police department if he was not involved in the murder?
Yes,
Did you ask why?
no, I never asked why.
Now, you also said, and it's the truth, and if
Yes.
it's not, you correct it, that you were very close with Donovan Thomas.
Yes,
In fact, your relative, I think cousin, but tell the jurors if I'm wrong, dated Donovan Thomas's relative.
yes,
And Donovan Thomas is close with your mother.
yes,
And you told District Attorney Love that.
yes,
Folks, just a reminder, the platform known as YouTube's looks at the chat and things you say. So please refrain yourself from cursive words. You can rephrase them. There is a site that translates, or where you get hints about Shakespearean insults. Use that. Be inventive. But please know, the bad cursive words, or at least rewrite them into something better. Because this is my channel. I'm perfectly capable of demonetizing myself. I do it all the time. But please, you in the chat, don't get me in trouble because you curse, please. So thank you, Casper, for realizing that. I know some people have issues with Casper, but Casper really looks out for me. Casper really wants to keep things civil in the chat, and I really if Casper could do this to me, you would hear a lot of bleeps. Luckily, yeah, you know. But please change your C's to B's. Okay, that's funny. That's actually funny. Okay, just a reminder, if you feel you have to really use the power words, rewrite them at least. Thank you.
Now, you were asked by District Attorney Love whether you remember anything else anyone said regarding the murder of Donovan Thomas on the night of January 10th, 2015, going into January 11th, 2015. Do you remember that question by any chance?
No.
Let me show you. This is, I will post the link. Am I muted? No, I'm not muted. This is Shakespearean insults generator. That's the link I just posted. And next insult, let's see. Thou cocked, ill-nurtured, scurvy knave. I have no idea what that means. Thou bootless, milk-livered ratsbane. Thou crusty flap mouth pump. I mean, get inspired by Shakespearean insults and use the words you find there instead of, the usual American. All right, let's get back to the trial.
I'm not actually, I don't remember that question.
Okay. Do you remember Jeffrey being distraught? That's a bad word. Being upset or sad at the shooting of Mr. Thomas?
Yes.
Do you remember?
I object. That calls for speculation.
Rephrase.
Williams.
Do you remember ever seeing Jeffrey put out a post, rest in peace, about Mr. Donovan Thomas's death?
Question about putting facts not in evidence. Mr. Steele knew that is putting facts not in evidence. And I would ask not only that the court strike the question, but admonish Mr. Steele to not put facts improperly not in evidence before this jury.
Okay, can you ask some foundational questions, please?
Sure.
And Your Honor, any post made by defendant Williams
So you're not talking about that evening, are you?
Yes, ma'am. I'm talking about the morning hours of January 11th, 2015.
All
The
right, we
gentleman,
may need to take this up outside the presence of the jury.
well, I'll come back to it then.
All right.
Let me ask you some questions. In front of you, is State's Exhibit number 444Y there by any chance? It is it's entitled, it's on the letterhead of the Office of the Fulton County District Attorney. It's dated December 27, 2022. Do you see that document?
Yes,
And it should be 7 pages long?
yes.
Okay. If you can turn to page 3 of 7, I want to ask you some questions about this document. And this is the same document that you've been asked about by Ms. Love, by the Honorable Attorney Sharp, right?
Yes.
Okay. Now, at the time of entering this guilty plea, December 28th, right before New Year's of 2022, right after Christmas, right?
Yes.
All right. I want to go through the factual acknowledgments. And I'm specifically focusing on Jeffrey, okay?
Yes.
Number 1, it's on page 3 of 7. Do you remember acknowledging and signing, and the jurors heard and watched your guilty plea before Judge Glanville?
Yes.
You saw that too, okay. Number 1, Young Slime Life, AKA YSL, is an organization made up of 3 or more members or associates who share common identifiers that include, but are not limited to, colors, hand signals, and terminology, who have committed crimes intended to increase notoriety, street credibility, and reputation of YSL. You see that?
Yes.
And that's, of course, your initial,
Yes.
the A and the S. Okay. Tell the ladies and gentlemen jury about Jeffrey. Focus on Jeffrey. What did Jeffrey benefit
Objection,
from
cross-respect.
any type?
Objection.
Let me hear the question. All right, don't answer the question yet, okay?
I got you.
What's the question?
From your personal knowledge, when you sign this, tell the jury what Jeffrey benefited
That's outside of the witness's knowledge.
from his personal observation. It's his acknowledgement that the state introduced.
Well, that actually did not introduce these parts.
They read this.
They did. Rephrase.
Yeah, they actually read out this. So
the question.
Okay. When you sign that, do you have any evidence to share with this jury
No.
that Jeffrey,
No. Rephrase your question.
did Jeffrey, when you signed that, were you talking about Jeffrey Williams?
No.
Okay. Number 1, I'm still on number 1, I just read, okay? When you were sworn before Judge Glanville, sworn means you take an oath to tell the truth, okay? Remember that?
Yes.
You were asked questions, right?
Yes.
Did Prosecutor Love ever ask you, tell us what Jeffrey Williams did?
No.
At that point in time, you wanted to go home, right?
Yes.
You would have answered all questions.
Objection.
Right.
1 calls for speculation.
Number 2, on page 3 of 7.
Yes.
States 444Y. It reads that you have been a member or, it says and/or associate of YSL since 2012, right?
Yes.
Now,
I am quite certain by, was it Sludge, who testified that the change from he left Rock Crew to YSL in 2013. So how did he assert to be there 2012? Now, this could all be cleared up by the testimony of Mondo, who claims to be one of the founders. But As you know, Mondo isn't even charged in this trial, in this everything, because Fani Willis was his lawyer back in the day. So her charge, if the DA's office was charging him, she could not control the narrative. She could not give orders because she has interest since she was his lawyer.
Told the jury that anyone can join YSL. Is that true?
Yes.
I mean, if I just today said I want to get a tattoo of YSL on my face, is that a problem?
No.
Objection made, whether or not it's a problem.
Is there any type that you know about, like beat-in or initiation to say I'm with YSL?
No.
Do you know personally from your travels, from going to shows and concerts and tours, are people from all over America and throughout the world having tattoos of YSL?
I've seen a couple of fans, yes.
Wearing shirts YSL?
Yes.
Hats?
Yes.
Tattoos of Jeffrey on their person?
Yes.
On issue 3 of that same document, it should read, while associated with YSL and to support and express loyalty to YSL, you, co-defendant Mr. Garlington and Mr. Zachary, appeared in a video, and then there's a parenthesis that says the video, with another person, AS, wherein you brandished a weapon used in a drive-by shooting, and wherein on behalf of YSL, you threatened to harm a person named Kel, a rival gang member who had begun a relationship with your ex-paramour or girlfriend. You see that?
Yes.
Were you asked any questions about what Jeffrey knew about that?
No.
He knew nothing to your knowledge, right?
Objection, Your Honor, speculation.
Sustained.
On your personal knowledge,
Objection, it was still proper speculation.
on your personal knowledge, did you ever speak with the prosecution? Did they ever want to know, what did Jeffrey Williams know about that?
Objection 1, that calls for speculation. 2, I can approach, Your Honor, because that.
Okay, I mean, it doesn't, that one does not call for speculation, but if you have some other issues. then
I don't
y'all
need to
go
approach,
ahead.
Your Honor. I'm going to continue.
I have an objection that I need to put on the record.
Okay.
I would rather not stop because that's all Ms. Love does. I'd rather continue. I'll waive that.
Well, we're gonna approach.
Oh, ho, ho, ho. Oh. Mr. Steele is not happy about this interruption. And that makes this sidebar counter 232. Oh, this is going to be interesting. This is going to be interesting. But we are a few minutes behind, so I can just skip ahead and see. Yep.
Sledge back in. Yes, ma'am.
Your Honor, I ask that the comment, that's what Ms. Love does, be stricken from the record.
We can strike that. All right, go ahead, Mr. Steele.
Mr. Sledge, on number 3 that we were just talking about,
Yes.
on the same document,
Yes.
during your time before Judge Glanville entering the plea and Ms. Love was asking you questions, you
Yes.
saw the video, audio of that as well?
Yes.
Did Ms. Love ever ask you anything about Jeffrey at that point?
No.
And you were under oath at that point?
Yes.
And you were going to answer questions if asked, right?
Yes,
I'd like to go to number 4, same page.
yes,
On or about April 28th, 2015, as reflected in Fulton County indictment number, and I'm not going to read it, but it ends in 8994. You know what you see what I did?
yes,
I just skipped the first bunch of numbers and letters. You and fellow YSL associates, Mr. Garlington and Mr. Zachary, committed a drive-by shooting using a firearm, the firearm that you wielded in the video referenced in part 3 of this section, targeting family members of a rival gang. You see that?
yes,
Okay, and you initialed that, obviously.
yes,
And again, did Miss Love ask you any questions on December 28, 2022, under oath in front of a court reporter on video, audio about Jeffrey?
no,
Number 5, same page, same document. You and your fellow YSL associates committed the drive-by shooting referenced in section 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL, okay?
yes,
Were you asked anything on December 28, 2022 about Jeffrey?
no,
You would have answered questions asked, right?
yes,
By this time, April 28, 2015, if you personally know, did Jeffrey launch a tour across the United States of America with Travis Scott?
I think it was around that time, if I'm not mistaken, I'm not for sure.
You went on part of that tour?
Did I go on board? Yes,
On part of the tour?
yes,
And you told the jurors what it's called. Do you remember what you called it?
the rodeo tour.
With the court's permission and your permission, I'd like to approach you with a document, okay?
Yes,
Your Honor, may I approach?
You may.
Ms. Winfrey, may I approach and get that document?
Are we allowed to know what document it is?
I'm sure he'll show you.
This has already been shown to the state has been previously marked, partially admitted as on 1/8/24, so it'll be January 8th, 2024. It's Mr. Williams, exhibit number 19.
All right, I'm not sure what you mean by partially admitted.
Parts of it were admitted.
Okay, are you
Not-
going to admit
yes.
to the admission of the rest of it?
Yes, I'm going to see if Mr. Sledge can identify it.
Right.
Thank you.
You may.
Approach you?
yes,
I'm going to show you an item, and I added that earlier. So that's just called an exhibit sticker.
Yeah.
But if you can look at that, you can open it up. Just tell me if you recognize it. And if it is accurate. If you don't recognize it, that's fine. And we will, we're going to put it aside, okay?
yeah, I remember this.
Oh, let me just. Via PayPal, I got a donation of $100 from K2. It says, keep up all your hard work. Thank you. 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 Wow. I'm going to pour myself a whiskey. Thank you so much, K2. I'm deeply humbled. I'm deeply humbled. And it's Friday, and this was supposed to wait for Friday panel show, but hey, cheers. Well, that's a good one. That's a really good one. Thank you again. Let's continue with the trial.
And what is that document, which I believe is number 19 of Jeffrey Williams?
This is the
Put
booklet.
it down until it's admitted.
Okay, I'm sorry.
No, that's
This,
okay.
this the booklet of the tour on what days and what areas that we was in.
Okay. And is it look to your memory to be accurate? Meaning, has it been changed in any way? Has it been altered, or does it look similar to the way that you saw it when you went on that tour?
It looked the same.
Your Honor, I move for the admission of Mr. Williams. It's number 19.
Your Honor, pursuant to 21-801. I object on the grounds of hearsay.
For what purpose is this being offered?
The purpose of showing the cities and the states for the certain tour.
And the dates?
That's what it is.
And
That's all it is.
that part, Your Honor, that he's describing is already just that portion.
It's there. That's the official tour guide to that tour.
Your Honor, and I object to the testifying, but there is a portion we can show the court.
Okay, well, I may need to see it myself then, because I don't know what
Okay,
might
approach.
be problematic, yes.
Yes.
Can you hand it to me?
Do I need to?
I think Mr. Steele should probably come up also.
Do I need to step out?
Yeah.
Yeah, but what's the fun in that? Is that? Ah, that counts. We have a sidebar. This gets us to sidebar counter 233. Oh, I'm having way too much fun with the sidebars. All right. I have no idea what the judge handled up.
May I approach, Your Honor?
You may. So the portion for the ruling is that it was already in, is in.
Yeah.
Yes.
See, Miss Love, be very careful with the evidence you introduce as evidence.
I'm turning to the third page. Full page of turn would be the 6th page, if you were counting both sides of Mr. Williams' number 19. Do you see any dates of that rodeo tour?
Yes.
And can you tell the ladies and gentlemen jury, just read it to them, if you don't mind, the date and the city of the tour?
I'll wait from the top to the bottom.
Entirety of the tour dates?
Sure.
Do you
It's
wanna
been
discuss
nowhere
that
near
page?
as many sidebars under
don't have
this
it on,
judge as under
Okay.
Granville.
Your Honor,
Yes.
also, this witnesses basis for knowledge of the specific dates, we would object unless there is a foundation laid for that.
Okay, well, he said he went on parts of this tour and was familiar with the tour.
Yeah.
Mr.
So
Slade,
overruled.
do you feel comfortable doing that? And if not, just
Yes, I can read you the dates and,
actually, Your Honor, may I approach?
You may.
May I approach you, sir?
yes,
Would you mind if I read along with you?
yes,
Okay, you just tell me if you can put it down. I don't have very good eyes.
me neither.
All right, I'm going to start here, okay?
Yes,
Saturday, February 28, 2015,
yes,
Santa Ana, California.
yes,
March
15,
Sunday, March 1, 2015. You see that?
yes,
Santa Ana, California show day.
yes,
Monday, March 2nd, Tucson, Arizona show day.
yes.
Yes.
I don't know if there's a question, and I would object to Mr. Smith.
Can we maybe give a summary of it?
Okay.
I found this from Thug Daily, and I think this is really interesting on it. Just listen here.
And do you remember District Attorney Love telling you that she would prefer if you don't state to the jury that Jeffrey told you to take Mr. Copeland to the police department if he was not involved in the murder?
Yes,
Isn't that interesting? Jeffrey's involvement in this was go to the damn cops if you, yeah. All right, back to the trial.
Then the next one is the next day. It's a travel day, right?
yes,
And then it's March 4th, 2015, Denver, Colorado show.
yes,
And then I'm skipping. March 6th, 2015, Milwaukee, Wisconsin show.
yes,
It's the same thing, and it's the same objection. Testifying is not a question, it's just stating.
So
This is
he's,
in evidence.
he's confirming the dates. I mean, Mr. Steele is not testifying, so that's overruled.
Saturday, March 7th, 2015.
Miss Love is getting scared because Mr. Steele has information Miss Love knows he has. But she's this deranged that she actually believes he won't use it.
Chicago, Illinois,
yes,
show day, and Rochester, New York as well.
yes,
Sunday, March 8th, 2015, Chicago, Illinois, a show day.
yes,
Monday, March 9th, 2015, Detroit, Michigan, a show day.
yes,
Tuesday, March 10th, 2015, Toronto, Ontario, Canada, a show day.
yes,
Wednesday, March 11th, 2015, Buffalo, New York, a show.
yes,
Thursday, March 12th, 2015, New York, a show
yes.
or a concert.
What month are you going to get to before the list is over with? I mean, is there, can we just say there were show dates pretty much constantly between X date and Y date?
Sure. It goes up to, is it fair to say, consistently through April 3, 2015. Is that true?
Yes,
And the cities that we left off at include Philadelphia, Pennsylvania,
yes,
Washington, D.C.,
yes,
Norfolk, Virginia,
yes,
Charlotte, North Carolina,
yes,
the great city of Atlanta, great state of Georgia,
yes,
New Orleans, Louisiana,
yes,
Austin, Texas,
yes,
San Marcos, Texas,
yes,
Houston, Texas,
yes,
Dallas, Texas,
yes,
Phoenix, Arizona,
yes,
San Diego, California,
yes,
Los Angeles, California,
yes,
San Francisco, California,
yes,
Seattle, Washington,
yes,
Portland, Oregon,
yes,
Boise, Idaho,
yes,
travel home.
yes.
Okay. Now, and if you need to see it, just let us know. Madam Court Reporter. knowing Jeffrey Williams since about 2009 when you were released from prison
Yes,
and seeing him on tour throughout our country, how much time did he spend committing crimes on
Objection.
Cleveland Avenue?
Objection. Wholly improper and speculation and speaking as to a legal conclusion committing crimes that this witness should not.
Sustained.
Did District Attorney Love, he was having you, or you agreed, sign that on April 28, 2015, it's number 5, that this drive-by shooting on April 28, 2015 was done on behalf of YSL to increase the notoriety, reputation, and fear of YSL. How many questions did she ever ask you at that time you were entering the plea, sworn under oath, about Jeffrey Williams?
The number of questions that were not asked about a specific defendant. It's irrelevant how many times he asked. The jury has seen what happened and what he asked.
Sustained.
By April of 2015, how wildly popular from your personal observation was Jeffrey Williams?
Objection, relevance.
Overruled.
very popular.
When you went to all of these cities throughout America with Jeffrey, how many fans would come?
Objection, speculation, and relevance.
I mean, if he can estimate it, overruled on relevance.
20s to 30s, 1,000, a lot of people. Okay.
Were these concerts held in arenas?
Yes.
Number 6, it's on page 3, it goes into page 4, okay? Same document.
Page 6.
Going into, it's number 6. It's on the bottom of page 3,
Okay, yeah.
same document. It's
Yes.
going to go into the next page, okay?
Yes.
You admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, and it goes on to the next page, for your participation in the drive-by shooting, and it says reference in 3, 4, and 5 above, meaning the April 28, 2015, right?
Yes.
Okay. Number 7, it says that you were told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia to discuss the murder, right?
Yes.
Anyone ever ask you any evidence that Jeffrey was at the McDonald's?
Objection, improper question as to evidence. Did anyone ever ask?
Sustained.
Did Miss Love on December 28th of 2022 ask you, was Jeffrey at the McDonald's?
Objection, again, one relevance. The jury has heard and seen what was asked, and it's not relevant, and an improper question.
Oh, that's overruled.
So-
Okay, so the entirety of the plea transcript is not actually in there. I don't know, what number are we on right now? 6? 7?
Yes.
So,
7 is in there.
Yeah,
okay,
so
but we don't
shut
have the
up,
entirety
Miss
of
Love.
it. Overruled.
Did District Attorney Love ask you on December 28th of 2002, was Jeffrey at the McDonald's?
No.
You have any evidence that Jeffrey was at this McDonald's?
Objection as to that question.
Sustained.
Do you know personally, or what you were told is reference in number 7, was Jeffrey at this McDonald's?
No.
Number 8, you personally know that one or more YSL associates committed the murder of Donovan Thomas on behalf of Jeffrey. That's what you signed, right?
Yes.
Okay. Do you have any personal knowledge that Jeffrey Williams committed the murder of Donovan Thomas Jr.
No,
in any fashion?
no,
You know what a party to a crime is? You know what that means?
Overruled.
yes,
Was Jeffrey,
Overruled.
do you have any information?
I mean, I'm sorry, sustained, sorry. You may not ask that question. Mr. Steele's like, yes. Sorry, my bad.
he said overruled.
Sorry.
All right, number 9. You see where I am, number 9?
Yes.
January 10th, 2015.
Not even the judge is paying enough attention. But this is good for the defense because they heard Miss Love all 3 days going on and on and on about irrelevant stuff. And now here is Mr. Steele with the relevant.
After the murder of Donovan Thomas Jr., you and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave you and other YSL associates cash money to lay low. You see that?
Yes,
You already told the jury, you made it clear that Jeffrey did give you $300. True?
yes,
Because you feared for the safety of yourself and your family, right?
yes,
Did anybody fire weapons, bullets into your home where you were living on June 10th, 2015, or the 11th, or the 12th, or the 13th?
no,
And then even after you received these, I think you called it anonymous statements that you and Mr. Copeland killed Donovan Thomas, you used some word. It was from an account on social media.
yes.
What was your word?
The DM,
Yeah. Was it from what'd you say?
a fake page.
Fake page. Okay. When you got that though, you made it clear that that bothered you because you didn't want anything to happen to your significant other or your child or anybody, right?
Yes,
Including yourself.
yes,
And you didn't have money at that time because you lost money gambling. Is that true?
yes,
And you asked Jeffrey and he gave you money for a hotel, right?
yes,
And the expression lay low, I know you said it was to get your family members out of harm's way. I think that's what you said.
yes,
But lay low could mean the same, doesn't it?
yes,
It wasn't any type of lay low from the police or anything, right?
no,
It was be safe.
yes,
Do you have any information, personal knowledge to share with the jury that Jeffrey gave any money to anyone as a reward for killing Donovan Thomas?
Objection, Your Honor, that would call for speculation and hearsay as to the reward part.
Overruled. And I actually mean overruled.
no,
I'm going to go to number 10, if you don't mind. Same document, page 4. That you have personal knowledge that on January 10, 2015, after the murder of Donovan Thomas, YSL associates traveled to Miami, Florida, with co-defendant and YSL founder Jeffrey Williams, aka Young Thug. I want to talk to you about that, okay?
yes,
Now, you made it clear that you knew that Jeffrey Williams was already going to Miami, Florida for a video music shoot. Is that, when I say shoot, filming it, is that true?
yes,
And you knew that this was already set up before January 10th, 2015, right?
yes,
And you knew other people were allowed to go if they wanted to,
yes,
that Jeffrey was generous. He would take people outside of that.
Objection, Your Honor, as to character evidence that is going to.
Sustained, rephrase.
Jeffrey Williams gave people the opportunity to leave Cleveland Avenue area and see other parts of America. Is that true?
Objection as to relevance of whether or not Mr. Williams gave anybody else an opportunity to do something. That's another
Sustained.
character.
Raslow's mom asks, Nick, how do you feel about this judge so far? She is a bit too much pro-prosecution for my taste, but she's eons better than Judge Glanville. She actually allows in evidence that speaks for the defense. But she does allow a complete garbage in from the prosecution.
Mr. Williams gave you opportunity to go, right?
Yes,
And others.
yes.
Objection, Your
Oh.
Honor.
Was there anything that on the 28th day of December 2022 that you were asked as to why this was somehow criminal, that Jeffrey had this meeting, this work in Miami, Florida?
Objection, Your Honor.
Sustained.
Were you asked? Were you asked any questions by District Attorney Love, Judge Glanville, or anyone, whether that going down to Miami, Florida, was not pre-planned?
No,
Number 11 says that you did not murder Donovan Thomas Jr. and you're not a party to that crime. That's true, right?
yes,
Number 12, that you did not murder Mr. Drinks and not party to a crime. True?
yes,
Okay. Number 13, on the bottom of that page, it says, you cannot truthfully assert that the persons charged in this indictment with the murder of Donovan Thomas Jr. are not guilty of murder, and you will make no attempt at trial, prior to trial or after trial, to exonerate the persons charged in this indictment with the murder of Donovan Thomas Jr. You see that?
That this is one of the items in this plea deal that, in my personal opinion, should make this plea deal void. Because if this person has actual personal knowledge about at least one or two or whatever of the defendants that says they had nothing to do about it, in my opinion, not a prosecutor or judge from here to kingdom come should disallow that to be testified to. But this prosecution and Judge Glanville allowed this language in, which is I have words for it that I really can't describe the vileness, the absolute. It's just evil, plain evil, to add that kind of language in. Because that tells me the strength of the prosecution's case. They are so scared. These spineless cowards, these evil people, are so scared of actual evidence being entered into this trial that they had to have that language in a plea deal. Let's continue.
yes,
Now, you've read this indictment. You've had it because you were charged in this case. Is that true?
yes,
Are you familiar still with this indictment?
yes.
Okay. Well, if you need it, with the court's permission, I have a copy if you need to see it. But you're not charged with the murder of Donovan Thomas in this indictment, are you?
Oh, it's not even.
No, not in
close
this
to that.
indictment.
Okay. And you're not, and Jeffrey's not charged with the murder of Donovan Thomas in this indictment, right?
No,
You're not charged with the murder of Mr. Drinks in this indictment, are you?
no,
And Jeffrey's not charged with the murder of Mr. Drinks.
no,
If you go to page 5, it's the top of page number 14. The gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. You see that?
Yes.
And then I'm just grouping it together because they look similar to me. So if they're not, you just correct me. Number 15, the gas station at 221 Cleveland Avenue, Atlanta, Georgia, is another location where YSL associates sell drugs and do not permit other gangs to operate, right?
Yes.
Were you ever asked any questions about Jeffrey selling drugs at either of these items?
I object on the grounds that Mr. Steele has no good faith basis for asking that question, given the fact that the entirety, he does have.
They've established on direct what it meant, what his duties were.
You would assist in any capacity needed to put on these shows.
Yes.
And you got paid by direct deposit, it's called. Is that what you, and if you don't know that term,
Yes.
you got a bank
Yeah.
deposit.
Transfer. Yeah. I am.
Okay. And to your knowledge, Jeffrey offered other people jobs too from your area. To his
Not if
knowledge.
he says to your knowledge. That makes it not speculation. Overruled. Overruled.
Could you repeat it, Mr. Steele?
Yes, sir. To your knowledge, Jeffrey would give other job opportunities to other people too, right?
Yeah. Yes.
So instead of giving money, you knew Jeffrey had money by 2014, right?
Yes.
He was flying on planes, right?
Yes.
He had cars, right?
Yes.
He had places to live.
Yes.
He had multiple places to live.
Yes.
He had jewelry.
I mean, I think you've made your point, so just move on to the next question.
But instead of giving just cash to people, he gave people opportunity to earn that money, right?
Yes. Oh.
Okay. Now, do you have any evidence to tell this jury that Jeffrey ever told you or anyone else to harm another person?
No.
To your knowledge, and I am not including drug use, and I am not including gambling, but to your knowledge, did Jeffrey ever
You know what?
encourage?
Apparently we need to take a restroom break, so let's break for a few minutes.
All right. And I can skip forward
Let's try to keep
because
this one to 10 minutes or so.
we are actually live. But these are a bunch of bathroom breaks that wasn't needed during the prosecution's case in chief. Isn't that odd? Isn't that weird? To me, it's quite weird. I don't know about you, but to me, it's weird. Now,
All right, y'all, we just took a fairly long recess an hour ago. I'm going to remind y'all to please, whether you have to right then or not, use the restroom during recesses so that we don't then have to take another bathroom break less than an hour later. Okay, I'm going to just start making y'all hold it if you can't do that, because we take plenty of breaks without interrupting the middle of somebody's testimony. Okay, so keep that in mind for the future, please. Go ahead and go if you need to.
okay, yeah, that is actually quite good from the prosecution. Now, I want to. You all remember when I went on my road trip? Started in Houston, ended in Michigan. Now, if you watched that stream, you also know that the first 28 hours were not good. My flight from Copenhagen to Amsterdam, no issues. My flight from Amsterdam to Detroit, a whole other issue. First, 2 hours late. So I only had 25 minutes to get from that gate to the connecting flight down to Houston. Now, what happened there? And I told you guys that this assistant I have kept yapping about tips. I tried to tell him, I just landed in the United States. I do not have cash. He then started yapping about, you have Cash App? No, I don't, and I feel really uncomfortable with this. And then the ass hat dropped me off at the wrong gate. So I had to find out where the correct gate was. Now I got answers from Delta Airlines that, and this is what they write. Let's see if I can get this. Oh, wrong. Case one. Let's see if, yeah. Oh, let me get this one up there instead. Thank you for contacting Delta Airlines regarding your travel on DL, blah, 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 Amsterdam to Detroit. Reviewed your email and was disheartened to learn about the wheelchair vendor. Yes, folks. I have arthritis in both knees. Running around in an airport? No. So I asked for assistance. The wheelchair vendor agent in Detroit who was assisting kept talking about tips, and you explained you did not have cash. He took you to the wrong gate, and you assume in retaliation for not tipping. Please accept my most sincere apology for this unacceptable behavior and how you were treated. We are able to conclude a violation of 14 CFR Part 302 did occur. So they actually checked in on if what I said was correct, that he actually dropped me off at the wrong gate. And they concluded, yes, he did. Now, if you work assisting disabled people, dropping off a person at the wrong gate is completely unacceptable. Completely. And this endeavor, when I got to Houston, finally got to the hotel room by other incidents, I could barely walk for 4 days because the stress and everything caused my arthritis to flare up. Please know I have shared your comments directly with the Detroit leadership to help us improve, blah, blah, blah. And here is where I can contact and put this forward if I need to. And $200 credit travel voucher, which is really, really great, because that means next time I go to United States, which hopefully is during closing arguments in this trial, I get a $200 discount. And I mean, that probably can get me from extra legroom to maybe even upper class. So yeah, that will really, really help. So thank you to Delta, even though I have plans, unless they actually reimbursed me in some way or form. I had a scathing video planned on my road trip channel, but now, yeah, with $200, yeah, okay, now that is dealt with, in my opinion. So thank you to Delta for doing this for me. And for you who, I mean, you know I do labor law, but I will never defend a person who does this to a disabled person, dropping them off at the wrong gate just because you were offended by not being tipped. by a person who just landed in the United States. If you have a work to do, there's a saying, really old saying over here that says, do the job, claim the rights, in that order. Not the other way around. Claim something and then maybe do your job. Okay. What can we do while we wait? I need a quick bathroom break, so let's see what I can play for you. Dun, dun, dun. Oh, yeah. For you who don't know about the Zachariah Anderson case, that is a case I've been following for a year and a half. In my opinion, he is wrongfully convicted. And he knows I fight for him as much as I can. And I got this message for him not that long ago. So let's listen to this.
Okay, let me see.
But let me at least say, because I know Nicholas, there might be some lag to this. I see you're kind of skipping around, but Nicholas in particular has been part of the group for a long time. Early in, recognized that it was bogus early in, you know, and I appreciate all the help. And he's still here, and it's super cool, and I really appreciate that kind of stuff. And I know anybody that actually bothers to look is going to know how bogus this is, and it's really hard to get people to take notice in the first place. But I know he's been out there, and I know he's been doing things, and I know he's been connected, and I want to go visit the guy, you know, and be on the show and go visit the guy and all sorts of stuff. I mean, I just think it's super cool. All the help, thank you. Super cool, and I appreciate it. And everybody else too, but yeah, he's in particular, I don't know, he jumps smart. When people talk about like other people's shows, I don't really know other people's shows, but I know his, because his was like one of the first ones that got mentioned. And I'm like, really? Somebody's actually doing something about the case? I'm like, oh, that's cool. So anyway, I don't know. Don't know the guy, but really appreciate it.
Ta-da! I'm back. Yeah, there are just some cases I just can't let go of. And the Zachariah Anderson case is one I really, really can't let go of. He is wrongfully convicted. For real. And it's infuriating to know that it will cost him up towards $150,000 just for the appeal. Just to have a good lawyer hired, investigators hired, and stuff like that. So I've been doing for a year and a half on occasions fundraisers to him. And once I get to 10,000 subscribers, you will learn more about the Zachariah Anderson case. So here and now, I will go for a new fundraiser for the Zachariah Anderson Appeals Fund. And that fundraiser will be, you finish the Wheel of Regrets, and the rules will be up there, but finishing the Wheel of Regrets will bring Zachariah Anderson's defense fund around $2,000. And it will get, you will see me drink disgusting things and eat disgusting things. Can they please be back from court anytime soon? I need to get something to drink that is not alcohol. I'll be right back. Let's see here. What can we? No, I will not play that one. This one, while I go get something to drink.
Gavel cracks, breaking backs, twist the facts, yeah. Rotten core, buried deep, justice cheap, hell. Crooked smile, snake and trial, deception, follow man. Power trip, crooked grip, lose your grip now. Symbol of grief, all from the steed. No more lies last. judge, watch him sway. Truth will rise, make him pay. Yank the judge from the bench today. No more lies, corrupt decay. Yank the judge, watch him sway. Truth will rise, make him pay.
And we are back. Just some good old-fashioned lemonade here. Come on, law and crime. Sound.
Mr. Sledge, when you were permitted to go on the Travis Scott rodeo tour
Yes,
for the dates that the jurors heard,
yes.
Objection, Your Honor, that is facts that are not in evidence. There was not testimony from the witness that he went on that tour on those dates that he heard, that he talked about. Matter of fact, he specifically said he didn't go on all of them.
Okay, on generally some of the dates, could you rephrase it?
do you remember on direct examination when questioned by Prosecutor Love, you explained that you went on the rodeo tour with Jeffrey Williams and others?
Yes,
And do you remember telling the jury that you actually were sent home before the tour ended? Do you remember that?
yes,
And you said for doing stupid stuff. Do you remember that?
yes.
And that stupid stuff was committed a crime, right?
Well, I didn't commit the crime, but
Okay.
it was to that occasion.
And Jeffrey said you and others are going home. True?
Speaking of words, it would be hearsay from the defendant that the witness is not, there's no rule that, there's no exception that would allow that hearsay.
Oh my God.
Sustained.
Why were you sent home?
Objection, ask and answer.
Who sent you home?
Jeffrey.
I'd like to show you, with the court's permission, I'd like to approach and show you what I've marked as Jeffrey William exhibit number 220A. And it's consecutive, meaning it goes in 220B.
Yeah.
But it goes up to JW exhibit 220XX.
Yes.
Your Honor, may I approach?
You may.
Yeah, these are the ones that the court, I think, can rule a smattering.
No, he's gonna, no, that's, yeah,
May I approach?
you may.
May I approach?
Yes.
Do you mind if I just move this? I'm going to give this to the court reporter, okay?
Yes.
So it says JW, Jeffrey Williams, EXH is exhibit, and then you'll see the numbers followed by a letter. Do me a favor, flip through these. If you've seen these before with your lawyer, and you recognize them, just tell us that as well. If you don't recognize some, put it to one side. If you recognize others, put it to a separate pile, okay?
Your Honor, and the question was if you've seen them before with your lawyer. That wasn't, I thought, the question that the court required.
If you've seen him before today.
If I seen before today,
Yeah, you may have seen them today. So if the only time you ever saw them was today, then put it aside as something you've never seen. What he means is if you saw it before today. Is that right, Mr. Steele?
Yeah, yesterday, Your Honor.
If you said before yesterday, that's when he gave it to him. He said-
Okay,
Yes, sir.
before yesterday. If you saw it before yesterday.
Mr. Sledge, I just want to ask you a question if I can. I'm not trying to interrupt you. Any of them that you saw put in one pile like you're doing? Any ones you didn't see put in another pile like you're doing? Okay, just keep them separate.
okay, thank you.
Okay, thank you.
And then I know where you might be confused. It's going to be a composite exhibit and he will publish, to the extent this witness says he recognizes any of them, a smattering of those, not the entirety of them.
Yeah. Oh, Miss Love can't quit and leave her job. She's only ever been a prosecutor. She can't do anything else. And even that, she cannot do her job without being unethical. Check the Shane Kendall case, which I covered. She's evil. She has no soul. She puts vulnerable people in jail knowing there's a high probability they won't survive. And she enjoys it. You have seen me before saying really, really bad words about Miss Love. They don't even come close to what I actually mean when I say she's evil. Okay, I skipped ahead as much as I could. And now we're live. It is 4:30 p.m. now, so they should not have more than half an hour or something left. Maybe 45 minutes. Or I don't know. They might go until 6 p.m., which might cause some issues. I will redirect you to... No, not that one. Not that one. There. Redirect from YouTube's is not doing great at the moment, but I will redirect you to the Friday panel show.
Are you done?
Yes,
Okay, Mr. Sledge.
Captain Williams
Make
will
two
be
piles
here.
or one pile?
one pile.
And do you recognize what has been marked as Jeffrey Williams exhibit number 222A through 220A through 220XX, or do not recognize them?
I recognize.
Your Honor, the question was whether or not he saw them before yesterday, and that was not asked, so I would ask that that be inquired.
Let's clarify, please.
Have you seen those items, all of them in that package, prior to seeing them with your lawyer yesterday?
I didn't see these with my lawyer yesterday, but I have seen these before.
In the past,
Yes,
before yesterday?
before yesterday, yes.
And are they true and accurate? That's just saying, do they look the way that you remember them when you first saw them?
Yes,
Did you see them, those items contemporaneously? That's a bad word. Did you see them at the time that these items were going on?
yes,
Okay. Your Honor, I move for the admission of Mr. Williams, and that would be, Your Honor, 2220A, as in Elisa, through 220, then double X.
All right, that's admitted.
Okay. Mr. Sledge, may I, with the court's permission, may I just
Yeah.
approach you? And I'm just going to show a couple
Yes.
to the jurors as a sample.
yes.
May I approach, Your Honor?
Yes.
Thank you, sir. Now, Mr. Sledge, is it fair to say that these exhibits, and I've numbered them all, but that they're all advertisements or posters for Jeffrey's work, concerts?
Yes,
And is it fair to say that they range from places all over the United States?
yes,
And when I say range from, shows, concerts all over the United States. Is that
yes,
true?
yes,
And the date range goes from, this is just from 2014 into 2015. Fair to
Yes.
say?
yes.
Okay. And if we could just pull up a couple. And this would be with Mr. Kokomo's and the court's permission. Jeffrey Williams exhibit number 220DD. And it should come up on your screen, Mr. Sledge. Could be, or it's maybe to your left, but yes, it's above you too.
Yeah, I think that one might be out of batteries that's on the.
Yeah, that's indeed.
Mr. Kokomo, can you clear the items on the middle of the screen?
It appears that there's some encryption, Fulton County, on all of the computers, so I'm not sure if it's anything that can be done.
Okay, that's fine. That's fine. May I approach, Your Honor?
You may.
Let me just show you this to you. Mr. Sledge, may I approach you?
Yes,
I'm going to show you what's been admitted, Mr. Williams, or JW Exhibit 220DD. Take a peek at that. And is this a performance in Chicago, Illinois?
yes,
And is it, do you recognize those performers?
yes.
Tell the jurors who they are.
Birdman and Rich Homie Quan.
And anybody else?
Jeffrey Williams.
Okay. And this is the date. Do you see the date?
Yes, December 26th.
And Christmas time,
Yes,
2015?
yes.
To your knowledge and observation, and if you don't have one,
Yes.
I do not see, and so I would ask for clarification, if the testimony is that there is a 2015 on this exhibit that I'm looking at, because there is no year of 2015, as Mr. Still has suggested, unless I'm missing it. If you could just show me, I'd be okay.
first of
They
all,
just
Yeah.
did this.
it comes from the state of Georgia when they subpoenaed Mr. Williams' Twitter account for 2014 and 15, A and B.
Your Honor,
If I go through all of them, you can see the dates in order.
Your Honor, there is no,
I mean, I think that the objection was that the date might not be, the year date might not be on this one, and I don't see it on there either, so.
All right.
But but he's already testified that the entirety of that composite exhibit shows dates from 2014 to 2015. So it's one or the other.
Your Honor, there is a difference that matters. It's a distinction with a difference, because what Mr. Steele is putting up is a picture of
It's a picture from Discovery. You claimed yourself was from 2014 to 2015. Now, if you claim these are not admissible because there are no years, you just undermined your own evidence.
Defendant Williams with a young man whom evidence has come out did not associate with Defendant Williams after a particular time.
Okay.
Now I have a motion.
All right, so we'll take up the motion in just a minute. With regard to this particular exhibit, I don't see a date on it either. Is there a date on it of a year? If not, maybe
I'll do
pick a
the-
different exhibit.
Your Honor, my motion be preserved as timely.
Yes,
May I approach?
yes.
All right, Mr. Slade, may I approach you?
Yes.
All right, let's just flip the exhibit here. How about the next exhibit? Jeffrey Williams exhibit number 220EE. Okay?
It says December 31st,
Well, let the
2015.
jurors see it first. Oh, there it is. Okay. All right, go ahead. You can look. It's the same.
It say December 31st, 2015.
New Year's
New
Eve
Year Eve.
and MYE. Do you know that stands for New Year's
The
Eve?
E, yes,
2015.
yes.
And did that come, this 220EE come shortly after, immediately after 220DD of Jeffrey Williams exhibit?
Yes.
And this one, again, the date on 220DD is in Chicago, and it is on,
26th,
thank you, tell the jurors.
December 26th.
And does this help you orient that December 26th on 220DD is 2014?
No.
Okay. Does it help you with 220EE? Is the date New Year's Eve going into 2015?
Yes.
And who is performing on New Year's Eve, December 31, 2014, going into January 1st, 2015? Who are the performers?
Jeffrey Williams,
Who else?
Birdman, and Rich Homie Quan.
Thank you.
So, Your Honor, regarding the objection as to the year of 220DD, I believe that Mr. Steele said the year was December 26, 2015, and that was where the issue was. I'm asking if now it's understood that it's 2014, if we could.
I don't know that we have that understanding because we don't have evidence that, I mean, I realize these are handed to the witness in a particular order, but I don't know that there's any evidence to suggest that the order that they're in is a chronological one. So we still don't have any evidence as to which of the 2 years that other one was. We just know that this one that we're looking at right now, 220EE, is for a concert date, December 31st of 2015 with those performers.
Yes, Your Honor, thank you.
I mean, this is ridiculous. The state themselves handed it over in
Did you wanna
discovery
ask them about
as
another?
from 2014 to 2015. And now they are objecting about the reliability of it. Their own discovery. They are objecting against their own damn discovery as being unreliable.
When you go through these, or you've gone through this, Mr. Slade,
Yes.
are they performances, and the jurors will have that exhibit out with them. They'll be able to look at it. Are those performances all over the United States?
Yes.
I'd like to, did your lawyer show you any potential exhibits yesterday or today?
He showed it to me today.
Then I shouldn't have said yes, I apologize. All right, I'm going to approach with a screenshot If you need to see the actual potential exhibit, just say, I don't recognize the screenshot, okay?
Yes.
Your Honor, I'm showing Mr. Williams number 46, 47, 49.
Right.
These are videos, but I was doing it this way, but if needed, Your Honor, Mr. Kokomo.
All right.
Well, they should be quite close to ending for today because it's near 5 p.m. on a Friday, which gives me some time to prepare for today's panel show. And these are the confirmed guests. Well, as you might imagine, Catnot Williams. As you might imagine, we will have Kayla Bumpus. As you might imagine, infamous Sylvia. She might show up a little late, but she will show up. And then a completely new guest who goes on the Twitters as Notorious Jules. If you are on Twitter about this case, you probably have seen her commenting. Now, invites are also a way to other people. And hopefully a few of them will show up. But that starts at 6 p.m. today.
Please take a look at Mr. Williams 49, 47, and 46. And if you need to see the actual item, there's no problem with the court's permission.
It's on number 3.
One more time.
It's on the.
When did you get here? Mr. Jingles! Mr. Jingles is here. Hello, Mr. Jingles. Hello. Have you had a good day? Have you had a good day? You... So... Hello, Mr. Jingles. Hello. All right, let's continue with the trial.
With 3?
Yes, sir.
Yes.
Have you, do you know what their screenshots from? Did you go over that with your lawyer?
I knew they was just professional people.
Okay, and have you seen those items before this week? Do you recognize those images from before this week?
Yeah, I probably seen them on, I think I seen all of them on the internet.
Okay, and when you say the internet, just to be clear, that's
Instagram.
before, okay, that's fine, but before this week, is that fair to say? Before
Yes,
yesterday?
yes.
Or today, okay. And I know you're not seeing the exact video. Do you need to see those videos? Or are you confident, how about that you've seen these items before?
Yes, I have seen them before.
All right, Your Honor, I move for the admission. Mark Jeffrey Williams, 46, 47, 49.
Your Honor, with the court, I apologize. Would the court permit an inquiry into foundation? Because I heard the witness say, I think I've seen them. And then when Mr. Steele said, are you confident that you've seen them? He then said, because at first he said, I think I've seen them somewhere on the internet, Instagram. And then Mr. Steele said, are you confident? He said, yeah, I've seen them. So I would ask permission to inquire where it is or in what to further inquire as to his foundation.
No, because
basis for
he's now
knowledge.
said he's confident he's seen them.
Yes, Your Honor, thank you.
They're admitted.
Mr. Sledge, now, there may be something on the screen, sounds like, that's not anyone's doing. So this may not be the best way to play it, but we're going to try, okay?
Yes.
Your Honor, can Mr. Kokomo, well, before he publishes, I know the first one is Jeffrey Williams, 46. Let me ask you a couple of questions, Mrs. Sledge.
Yes.
Do you remember the prosecutor asked you a lot of questions, or a number of questions, whatever they were, about if you know and if you've done the finger to the nose? You remember that?
Yes.
And she asked you to do it for the jurors, finger to the nose, right?
Yes.
Do you know who started? Do you personally know who started a finger across the nose, if anyone?
No.
God bless you. Is there
Yeah,
anything about an individual?
Yeah, you don't need to see Mr. Jingles cleaning himself like that.
Taking their finger, like I'm doing, and going across my nose, that means that the person is committing crime.
Objection, Your Honor. Objection calls for
A conclusion, a legal conclusion, and objection as to outside the province of this particular witness. It's an improper question to ask whether it suggests that they are committing a crime.
Okay, sustained.
With, of course, permission, Mr. Kokomo, would you play Jeffrey Williams exhibit number 46? Take a look at it, Mr. Sledge. I'll have a question for you. If it's not going to work because the item up over the screen, we'll just do it another time, okay?
That
Yes.
box that says something about a hard reset? Just click close.
We don't have access to click close on our computers.
Well, I don't- Okay. Maybe.
Technical issues.
So what, it's on this screen up here?
It's on all the other screens.
Okay, I mean, because IT. Okay, yeah, I guess it's just somebody, if you don't mind rolling the screen over where the jury and the witness can see it. Hmm?
If you turn that screen that way.
I mean.
There is a camera at the top. Of
Right.
that
Oh,
screen.
okay, stop, don't do that.
What, you can
Just,
close the camera.
That one don't have a class.
I mean, I don't know the answer to, if y'all are screen sharing from your laptops.
It's on the.
Oh, okay, I don't know. Believe me, I do not know the solution to the IT issue.
No,
I don't
this
know.
is actually live.
See enough of it around it. How big is it? How about,
We cover the.
that's fine. I mean,
And the
can you
jurors are seeing.
just come around the back, Mr. Short. It looks like it just kind of sits on top. Just take it off.
Okay.
And stick it on the back there somewhere where all it's going to see is the back.
Phrasing.
No bad.
It rolls, right?
Yeah, nobody's surprised over technical issues in this trial.
I just closed the.
Good job. Is what else? Miss Persefield said she's not here this week. We can worry about that later. All right, we now have the ability to see on a screen that is not covered by some strange IT notification.
Did you note the two
Oh,
basketball
that
players
piece of
in that
music
screenshot?
is going to
Yes.
get me.
And do you know them to be professional players?
Yes,
And were they doing something similar to what you were asked to show the jurors?
yes.
I'd like to show you Mr. Williams, number 47.
Okay.
Do you know who that person is?
Rod Wade,
Can you tell the jurors, please, into the microphone?
Rod Wade,
And who is Mr. Wave?
he's a rapper, an entertainer.
And that's W-A-V-E. And at the beginning, did you notice that young lady behind Mr. Wave?
No.
Okay. Look at the young lady right behind her, right there.
Oh, yeah, I see it right there now.
And is that similar to what you showed the jurors?
Yes,
And then 49, Mr. Williams, 49? Do you remember discussing with the jurors that you've seen Nickelodeon slime? Do you remember that?
yes.
Okay. This is going to be Jeffrey Williams, number 49. And do you recognize that person as a professional football player?
Yes.
You know who that person is?
I don't forget his name, but
Okay. And was it similar to the wiping of the nose that you were asked a lot of questions about or some questions about earlier?
yes,
And did you hear him say slime?
yes.
Tell the jurors why is slime significant to YSL?
Could you?
Is it evil?
No,
And the wiping of the nose, is that evil?
no.
I'd like to talk with you about a posting that you were shown, and I forget the state's exhibit number. Give me 1 second. Remember the exhibit that you all played for Mr. Sledge saying, "Ride to the king"? Know the number?
Do you need to
play
put
from-
Williams saying it?
No, I'll use yours. Number 4.
435Y, right?
Yes,
Yes.
that's what I'm being told. Could you? Thank you. Do you remember this, Mr. Sledge, being played this? I'm
Yes.
going to ask the court to allow it to be played one more time by Ms. Knight, and then I'd like to ask you some questions, okay?
Yes.
Yeah. Remember, there are 99 more witnesses. We aren't even halfway through the witness list. Day 124.
Lie to your kids, you lie to your mama, but you get in the courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Puss ass.
Now, Mr. Sledge, you told the district attorney when questioning that this is not a new statement. Do you remember something like that?
Yes.
And had you heard this before from growing up, from where?
Growing up, I have heard it before though.
Okay. Have you seen it and listened to it or read it on the internet?
I think I have seen it on the internet.
And you related this and you made this statement which is now memorialized as State's Exhibit 435Y. Do you remember what was going on at that moment?
No.
Okay. I'd like to show you what's already in evidence. And it's the State's Exhibit number. Do you have Jeffrey Williams making, what number is that? I'd like to show you 447Y. Your Honor, it's already in evidence.
All right.
May we publish it?
You may.
Thank you.
So nigga, a lot of they mama, a lot of they kids, a lot of they brothers and sisters, then get ready in the courtroom and tell the God and his truth.
Fuck, nigga.
Don't get it. Y'all nigga need to get fucking killed, bro.
You snitching bitches.
From me and YSF.
Were you able to hear that, Mr. Sledge?
Yes.
And was that, you were asked if that was your voice by the district attorney on direct examination. Do you remember that?
Yes.
And your response was something effective, it sounds like you.
Yes.
Okay. Do you remember the date that was made?
No, I don't remember the date.
I'd like to ask you if you remember the other persons who are speaking in that video, okay?
Yes.
And was it Jeffrey Williams speaking?
Yes.
All right. And was he the one seen on the video?
Yes.
And was it Martinez Arnold speaking?
Yes, that's what it sounded like.
All right. And was the other person Mr. McMillan?
Yes, that's
Mr. McMillan.
yes.
All right. Now, I'd like to ask you if you can hear and listen to the very beginning of State's Exhibit number 437Y. Yes. Excuse me, 447Y. I'd like to ask you if you can hear at the very beginning, does it say, I'm gonna swear to God, it's the truth. I'm gonna tell a lie on God. I want you to listen, okay? If it says that.
Okay.
So nigga, a lot of they mama, a lot of they kids, a lot of they brothers and sisters.
Did you hear the beginning of that?
Yes.
Okay. And if you want headphones, the judge may allow that. The Honorable Judge Whitaker may allow that. But were you able to hear the person speaking?
Yes.
That beginning part? And did they say, I'm gonna swear to God, it's the truth. I'm gonna tell a lie on God?
Yes.
Who said that?
Hang on. Never mind. Yes, no.
Who said that?
I think that was, it sounded like my voice, but yes.
So at the beginning of this video, audio, is it fair to say that you're talking about going to swear to God, to tell the truth, and then tell a lie on God?
Yes.
Was this video something about people who lie,
Yes.
even though they're under oath?
They don't have to be on an oath to tell a lie.
Now, the next part that I'd ask Miss Knight, the Honorable Miss Knight, to play should be Jeffrey speaking. And it's similar to what you said in the video we just saw. Okay. There's Jeffrey saying, listen to this, okay? So, and I'm just saying, and lie to their mama, lie to their kids, lie to their brothers and sisters, and get right in the courtroom to tell the God's honest truth. If you can just listen to that and tell me if that's what you hear Jeffrey say, okay?
Yes.
One more time. You can start beginning. I mean, it's so short. But can you stop it when that part's ends? Jeffrey, yeah. Thank you. You listen for my cue? Okay.
So nigga, a lot of they mama, a lot of they kids, a lot of they brothers and sisters, they ain't get ready in the courtroom and tell God that it's true. Fuck, nigga.
Was that Jeffrey speaking?
Yes.
And is that similar to what you said on the other exhibit, which is escaping me, the exhibit number? 435Y, State's Exhibit. Is that
Yes.
similar?
Yes.
And are those the words that you said are similar words that you've heard before?
Yes.
Did you hear those words before Jeffrey said those words?
Yes.
And then on the next part of it, I'm not going to say it, but it's FN. Ain't going back and forth with you, bro. And then Jeffrey saying, or then another person saying, tell nothing but the truth, so help you God. If you can listen to that, okay?
Yes.
And tell the jurors who's saying that.
Yes.
Don't get it. Y'all niggas get fucking killed, bro.
You snitching bitches.
It's true.
Fuck. Thank you.
God that is true.
Fuck, nigga.
Don't get it. Y'all niggas get fucking killed, bro.
You snitching bitches.
From me and wife said.
Okay. Did you hear that? Tell, tell nothing but the truth, so help you God.
Yes.
Is it accurate to say that in the criminal justice system, from your upbringing and your observation, people come in and lie under oath?
Objection, Your Honor. That would call for speculation about other.
He says from your observation. Of course, I don't know how he can know that.
You can know it
So
from personal experience.
For speculation until there's a foundation established for his ability to answer that. A basis for knowledge, just speculation about other people lying.
you can try to lay a foundation.
When you said this, when you were part of this, and when I say this, I'm talking about states 447Y, what's up there right now?
Yes.
Tell the jurors what you were talking about.
Talking about people lying.
Okay. Now, I want to show you, may I have one moment?
You may.
Skipping ahead a bit.
Can Mr. Kokomo show the prosecutor? This will be Mr. Williams. Thank you. Exhibit number 255.
Okay.
Yeah, I don't know why the prosecution is allowed to do speaking objections all of a sudden, but then again, the defense has done a few as well. Rich Homie Kwan was not supposed to be the next witness, Brenda. I don't think so. He was further down the line. If the prosecution ever planned on calling him, they subpoenaed him, but they don't call all the people they subpoena.
So, Your Honor, I'm looking at 62 pages. Are we talking about 62 pages? That's what this is.
I'll shorten it, but I just did the dates from
That's the same 255 that we looked at before.
no, we cut
No,
out.
it's a different,
Yeah, we stopped in July 2015.
okay, and,
Starts, I think, December or November 2012.
okay, and you were just gonna pick a couple of
Yes,
pages.
I'm not going to go through.
Is it possible to have them just specify which two so I can look at those? Or do I need to look at
I was
62
going to
and
show it
guess?
to Mr. Sledge first, obviously, and then we could do that.
Do you know which ones you're gonna use?
No, because Mr. Sledge has to identify.
Okay. I mean, you know generally what,
Yeah. I'll use the one from November 2012, I believe, and I'll look at it, but there'll be 2 or 3. That'll be it.
I'm going to keep playing here, but I need to make some coffee
same thing we
if
looked
I'm
at
going
over
to, because in 50 minutes, there's the panel show, and I need to be somewhat awake for it. So I'll be just making some coffee over there. I will be listening in, but out of sight.
It appears to be all 62 pages.
yeah, now I know.
Well, it's not accurate. It took out after July 15th.
Okay, well.
That's what, but I didn't want to cut it short for Mr. Sledge to look at, but then I was going to just, once he identifies a few, I was going to stop.
So,
Okay, so. Can you come up here for a minute?
Sidebar counter 230. I told you I was listening. I just needed to get the coffee running. And we are live, completely live. Yeah, I will not miss a sidebar. Yar! Member for 2 months. Sidebar! Yeah, this live has been going on for 8 hours and 38 minutes. Since just about 8:30 this morning. No.
I'd like to, but.
Reminder, these guys has been in trial. And think of the jury. They don't get the pauses I get. And you guys to talk to. Somebody needs to put a fart, a whoopee cushion under. Yeah, the jury had the morning off, but still sitting in the back room. Yeah.
Mr. Sledge,
Yes,
we are going to trim down some of those items for you,
yes,
for me. And we're gonna get back to that, okay?
Yes.
I will not, I promise you I'll come back to
yes.
it. If the state can show again, Mr. Williams' number and what number is it for Jeffrey Williams? 447Y. And if you can just look at it with me for a moment, if you don't mind. Now, do you see at the bottom, if any way to clear the, thank you. You see at the bottom, it says repost, whiz that,
Yes,
and then it says, it's tagging at Thugger1. You see that?
yes.
Do you know what a repost is?
Someone else posted it and it was posted to somebody else posted.
So for an example, if I posted something a week ago and you liked it and you wanted to post it, what would happen?
I hit the repost app and it'll let me repost it on another date.
So the state was saying that this was done and shown and reposted on January 26, 2015.
Yeah.
Do you remember that in the indictment?
Hang on just a second.
Just as to the characterization of that question, the test.
Okay, yes, I mean, the state would have asked a question and established that through a witness.
It's in the indictment.
They actually didn't.
As well. And if you're not familiar, do you remember?
I remember this. Their question was more or less, what's this post from around this date? And the witness said yes. If it was Detective Belknap or anybody, but they didn't really go into what is a repost, what does the metadata say, and when is the original from. That they couldn't answer.
This being in the
Okay,
indictment?
well, that's just an assertion.
Exactly. So I want to show you, are you ready? What number is it? Actually, can you show it to the prosecution first? What number is this going to be? It's going to be Jeffrey Williams, number 256.
Is this something new that's not in what you sent before?
True.
Okay,
I'm trimming down.
that's fine. Oh, I got you. Okay.
All right, can Mr. Kokomo approach Mr. Sledge?
Yes. You may.
Mr. Sledge, is that okay?
Yes.
Just take a look at this, telling me whether you can recognize it and you could hear it as well, just to make sure, but don't make it loud enough for the jurors yet.
So, Your Honor,
Mm-hmm.
prior to that being displayed, what we have not heard is the sound in that video, because this is the first time we've seen it. So
Right.
we'd ask that before anything be done with it, the state be allowed an opportunity to hear what is being said in that particular video, which is a little different.
I don't know if it's different or not.
It is, I'm looking at it, it is not the same exact thing that we just
Okay.
put up.
Okay. Yeah,
That's
I
a-
guess this will be where we break for the evening.
No, it's 11 seconds. I mean, if that matters.
Well, or we can see if Miss Love can hear it without. Do you want to step out into the hall? That would be easier than excusing all of them to the, all right. She'll be right back. We'll sit. for
This
just a
is
second, and I'll
something
let
they
Marcus-
presented themselves.
And
Now
Mr.
they claim this is new, this is slightly different.
Estimate for me, how long you think?
That
the
assertion she
testing
needs
process
to
is gonna
actually show cause for.
30 minutes.
Do y'all want to stay for, who else has, if anybody has gonna have cross for this witness? Anybody? Okay. Okay. Do y'all want to just, well, do y'all want to stay 30 more minutes? Although we'll have a redirect on Monday, but yes, I have some thumbs up for 30 minutes. Lots of nods for, okay.
The only issue I just want to make the court on the, on the
It's always something.
on the 62
Yeah.
item, that's the only thing I have to go over, which is going to take a little more time. So I just want you to, I won't finish is my
All
point.
right, yeah, we'll get 30 more minutes and then we'll see where we are. Okay, all right.
Oh,
Then I guess he's already seen it.
Yes.
So go ahead and ask whatever you need to ask.
Mr. Sledge, have you seen what is now marked as Mr. Williams number 256? Have you seen that before?
Yes,
And is it accurate? And does it depict the way it was when it was first filmed or, yeah, filmed and audioed?
yes.
And Your
Any-
Honor, I, two things. I object on the basis of the vagueness of the question. Have you seen it before? I don't know if that means before he was shown by a
Well, can you
lawyer.
clarify that?
Were you present when that was made?
Yes, I was
Is
present.
your voice on there?
Yes, my voice is on there.
Is it the same as, and I always forget, 447?
Oh,
447Y that was shown to the jurors, the repost?
yes, my voice on there.
Okay.
Okay,
Okay.
so on 256, JW 256 is that what you were just asking the questions about he was present for? Okay, all right.
With
Other-
that, I have no
Okay.
objection if he's saying he was there.
All right, go ahead.
Your Honor, with the court's permission, Mr. Kokomo will publish Mr. Williams number 256.
All right.
yeah, this stream will probably go up until the panel show. But I need to get my coffee. I will be listening in.
A lot of they kids, a lot of they brothers and sisters, they didn't get ready in the courtroom and tell God honest truth. Don't get it. Y'all niggas need to get fucking killed, bro.
You snitching bitches.
From me and YC. So nigga, a lot of they mama, a lot of they kids, a lot of they brothers and sisters, they didn't get ready in the courtroom and tell God honest truth. Don't get it. Y'all niggas need to get fucking killed, bro.
You snitching bitches.
From me and YC.
Mr. Sledge, did you hear your voice?
Yes,
The voice of Mr. Jeffrey Williams and the face of Mr. Jeffrey Williams?
yes,
Did you hear the voice of Mr. McMiller?
yes,
Did you hear the voice of Mr. Martinez, also known as Duke?
yes,
Is it the same exact video that was played earlier as the repost?
yes.
And on Jeffrey Williams number 256, I'd like you to tell the jurors, it's small writing, if you could read it to them, what date at the bottom right was this made?
Oh,
January 4th, 2015.
And on January 4th, 2015, what was Jeffrey Williams' relationship like with Donovan Thomas from your personal observation?
Objection vague.
Overruled.
They had a great relationship.
And does this video on January 4th, 2015 have anything to do from your own personal knowledge from being in it about Donovan Thomas or threatening some witness or anything?
No,
Objection, one is compound, so I don't know which part of that he's asking about. And then the second part,
he is speaking to the intent of defendant Williams when he says, does it have anything to do with threatening someone?
Okay,
Ask
well,
me
it's
personally.
his personal knowledge, and while Mr. Steele does ask long questions sometimes, he has a lot of clauses in there. I don't believe it was a compound question, just had a lot of descriptive clauses.
This is actually a bombshell. The state has argued that this is about the murder of Donovan Thomas. This is threatening towards Donovan Thomas. This original is from January 4th, 6 days. 6 days before Donovan Thomas was killed. The state's repost was closer in time, which they argued. So Mr. Steele and his team found the original, where Mr. Sludge was there. And I will claim that this prosecution have seen this. Because if you see and know it's a repost, it's your obligation as an investigator and as a prosecutor to find out the original. They claim didn't find. I don't buy it. Why don't I buy it? Because Miss Love is a lying liar who lies. So Mr. Steele actually found the original post, and it was not about Donovan Thomas.
So overruled.
So the indictment, and if you don't remember, we'll show it to you. No one's trying to keep anything from you. Says that this was done 16 days after the killing of Mr. Williams, that it was reposted. But this was made.
Yeah. Okay. 16 days, the state claims this was posted after the murder, and it was about Donovan Thomas. Mr. Steele's team found the original that was posted 6 days before the murder. This is a bombshell. A real bombshell. This is the defense proving beyond reasonable doubt that that recording had nothing to do with Donovan Thomas' murder.
6 days before, God forbid, the killing of Mr. Thomas, right?
Yes.
Now, if you can look at the very top right-hand side.
Oh, please say
you see where
Donovan
it
Thomas.
says watch your post. You see that at the top?
Yes.
And then underneath it, it says watch your post. And then it says best said at MPA Duke, DUKE 1, the number 1. Said it first. 3 exclamation points. You see that?
Yes.
Who, to your knowledge, is MPA Duke 1?
Mr. Arnold.
Martinez Arnold?
Yes.
And then it says video by at Thugger1 pound YouTube pound Young Thug pound Thugger1 pound Urban Post. You see all that?
Yes.
Okay. And when it says best said at MPA Duke 1 said it first, that's Mr. Arnold
Yes.
saying it first.
Yes.
Objection, Your Honor, as to that.
Yeah, sustained as to that.
All right. Now, I want to ask the other questions if I can. Before January 4th, 2015, were you familiar with this type of statement?
Yes.
Now, if a witness, when it says at the end, the prosecutor said, y'all should be killed. Let me make sure I got, hold on one second. Y'all should be killed, and that's from me and YSL. Do you remember that?
Yes.
If I didn't quote it perfectly, something to that effect?
Yes.
Okay. from being there and being a participant in this video, which is 256, Jeffrey Williams 256. What do you believe should happen to a witness who lies about someone in trial?
Sustained.
Okay. All right, let me ask you this. You were released from prison from the drive-by shooting. Remember, the jurors heard a lot about that, April 2015?
Yes,
And is it fair to say you were released in year 2019?
yes,
And when you were released from prison, you needed a job, didn't you?
yes,
Okay. You were financially depleted. You didn't have much money?
no,
All right. And is it fair to say that Jeffrey at that time was even more popular than he was in 2015?
yes,
And did Jeffrey offer you a job?
yes,
Was it conditional? Did you have to promise something?
no,
How about no more crime?
no,
Are you withdrawing that objection?
Did Jeffrey tell you you can't commit crimes?
That right there is hearsay.
Sustained.
When you were on tour with Jeffrey and from your personal observation, so I'm not asking you what other people said or anything. Did you ever observe people who would steal from other people, from stores or anything like that, and Jeffrey would find out about it and repay those people?
yeah,
Objection, Your Honor, relevance.
Sustained.
Well, I think it's relevant. You're the leader of a supposed organization.
I object on the basis of whatever the speaking objection is about to be.
I think it's relevant, more than relevant,
Your Honor,
to the conduct after this trial.
his character, he's trying
That's
to
not-
get into character.
Sustained.
evidence.
All right. Do you remember seeing in the days before Donovan Thomas was killed? Do you ever remember seeing, personally seeing Mr. Kenneth Copeland with an Infiniti vehicle?
no,
When you drove Mr. Copeland to the police department on the early morning hours of January 11th, 2015, is that true?
yes,
And your significant other, the mother of your child was with you as well as your youngest child at that time, right?
it was he ain't my youngest child, he my oldest son.
Apologize. Okay. And Mr. Copeland didn't have a car there, right? That's why you drove him? Am I correct?
He didn't have a car there.
Do you remember at all whether Mr. Copeland asked you to pick him up and drive him to Jeffrey Williams' house with you for safety?
I don't remember that.
Okay. Do you know how, as you sit here today, do you remember how Mr. Copeland, if you know, got to Jeffrey Williams' home on January 10th, 2015?
I don't know.
All right. Has Jeffrey ever paid for your lawyer fees?
No,
Has he ever paid for your bond?
no,
Your Honor? I believe except for the, I have to break down the
Yeah.
62, which I probably can't do in a short period of time. I don't have any other questions.
Okay, well, so is your plan to,
I'll try to do it, with the court's permission, I'll try to do it, Mr. Wright, and figure out if there's a quick way to get it through. I'm not going to speak with Mr. Slade. I don't mean any disrespect, but I'll go through his.
Your Honor, would the court permit outside of the jury's presence for the question to be placed upon the witness so that the court can hear.
Sure, yeah,
fine with
that
me.
may be a better way to do it. Okay, all right, so we are gonna break for the day and for the weekend, and I am
All
going to
right,
remind
but
all of you to
we're not done.
talk about the case with anybody, don't let anybody talk.
We are not done. There's still this little evidentiary thing. Then I can send you off to the panel show, which will start in roughly half an hour. Geez, 9 hours. This is a marathon because I don't know when the panel show will stop. Last Friday, it was 3 hours. So this might be a 12-hour stream day for me. Thank you, Hayden Harris. Been watching all day. Yeah, Vikings. And so, yeah, that will be interesting. And I had a work day today. So my alarm bell went off 4:30 this morning. I was at work at 6 a.m. I worked until around 1:30 p.m. Started streaming 2:30 p.m. and now it is 11:33 p.m. Hey, might be a 24-hour day today. Yay! Cheers.
About it with you. Yeah.
Mr. Sledge.
Yes.
I'm going to ask the court, there's no jury here, but we're still in trial, okay?
Yes.
I'm going to ask with the court's permission to approach you and show you. And I'm just going to pick out a few. And just tell me whether you have ever seen these postings online before this week, okay? Is that okay?
Yes. Yes.
And I'm going to target a couple, but it's going to take me a moment, but I think I could target a few.
Hey, Your Honor, if Mr. Steele would simply apprise the court and counsel for the state which ones he's targeting and approaching him with, so we could at least write it down.
I'm going to do that. Can Mr. Kokomo and I approach this for a minute, Your Honor?
Yes.
Mr. Sledge, can we come to you?
Yes.
And just be real clear of exactly what you're asking him, not post like this.
Mr. Kokomo is going to show you. Can you pull up the one that it's it says it's December. Yeah. You haven't, okay?
Yeah.
If you have seen it and read it, just tell us I have seen it and read it.
Your Honor, could Mr. Steele place just on the record the one he just identified for Mr. Kokomo, but I could barely hear.
Way. Or just
say
spin
it.
around and show Miss
Yeah,
Love.
if I could see it.
This is DMAC.
Just spin around and show Miss Love. It'll be easier than trying to. Some people's names or tags or whatever are kind of hard to read out.
Well, yes, I am streaming again in 25 minutes. It's the panel show. You know what? I'm going to invite Hella, an excited utterance, her input.
If you have not
I
seen
value
this,
her
just make it clear.
input
If you
on
have seen it,
things.
just make it clear. I'm just going to read it, okay? Okay. And it is, I'm just orienting myself. This is Mr. Williams exhibit number. You can call it 255A. 255A. And it's down here and it says DMAC got me to banging at DMAC to banging. And you see the date?
Yes.
December 27, 2014.
Yeah.
And this is me, I'm not reading verbatim, okay? And AN, to they mama, brother, sister, and kids, but get to the courtroom and tell the God's honest truth, question mark, question mark, question mark. I don't get it, or ION get it, hyphen at Young Thug. You see that?
Yes.
If you can remember, if you can, it's fine, and just tell us, have you seen that before this week?
Have I seen
That particular post.
it this week?
No.
Anytime
Oh, anytime.
this week.
I can't even remember exactly what day I seen it, but I don't seen this before.
You have seen it
before.
Yes.
Have you seen
Judge, is he talking about that?
In
Have you
specific
seen
post.
DMAC got to me too banging on
Yes.
December 27th? That post, you saw
Yes,
that
I
post?
saw this post
All right.
before.
Have you seen it before this week, just to make sure?
Yes, yes.
Okay. We're gonna have to mark that. Can you pull up the one that says, she dies? You know that one? Can't remember the exact term. And if you don't know it, I have my notes. I put for. Tricia. Can I step back just 1 second? Get it now.
Yeah. This seems to be a convenient time. I don't know, is this like a schedule?
Okay. This doesn't count as a sidebar, by the way. Dun, dun, dun.
I don't think that matters. State subpoena. However, he is serving as Mr. Sledge's lawyer, and he's obviously been sitting in here. And I think it would be appropriate for him to continue to sit in here for the remainder of Mr. Sledge's testimony, since he's serving as his lawyer. Is
I
the state
agree.
gonna have any problem with that?
Not at
All
all.
right, and then y'all aren't gonna make any kind of, okay, all right, that's fine. Just wanted to clarify that. Okay. And is this like a cautionary potential subpoena, or is he gonna, I mean, are you gonna let him know when you expect him to? He's got other business, obviously, after he finishes as his attorney role. will you let him know when he needs to be back?
Yes,
Okay.
yes.
All right, that's the only reason I'm asking. Okay. All right, are y'all ready with your next one?
We'll just do the one then, Your Honor.
Okay. Well,
We're
great.
gonna call
then.
it 225.
Okay, and it'll just be that
No,
one.
I said it wrong.
255.
255. Even.
Just 255.
We'll call it 25 with the court's permission, and then we'll just start with that on whatever you tell us.
All right, and it'll just be that one, and then
And we'll
you suspect
rearrange
you'll
it.
be pretty much done at that point.
I actually turned the page. I have more, but yes, it's not much.
I mean,
It'll be
that's
15 minutes,
okay.
20 minutes.
All right,
But I'm gonna start with that, and we'll make it just one, like exhibit,
Okay.
one thing. So we'll crop it.
that works.
Oh, yeah, that won't happen. She can try.
There's no A though. There's no.
Yeah,
A.
it's not, it's just gonna be 255. But yes, is
And-
that right?
And it's December 27, 2014.
All right, thank you.
That's the one we'll use.
Okay,
I just have one thing to note for the record,
okay. Are we finished with Mr. Sledge for the day?
except Mr. Wright. I'd like to stay just for a minute.
Okay, so are we finished with Mr. Sledge?
I'm finished with him. He could stay out on whatever the court wants, but yes, I'm not asking him
Okay.
any questions.
You may step out and we'll see you at 9 on Monday.
Okay, thank you.
And I'm sure Mr. Wright will be out in a minute if you want to wait for him.
Yeah, I don't know if that she will actually try to subpoena the attorney, but she can always try. Because the only
So
one
it's
who
not,
can, the only person who can take away the attorney-client privilege is Mr. Sludge.
my desire to say that, a prosecutor or any lawyer or anybody told someone, don't say something in front of the jury. But, I cleared that with Mr. Wright, and I want the court to note that the state never put us on notice. It's not Brady, because with due diligence, I found out about it. So I'm not saying it's a violation of Brady, but it's just not the way, if believed, it's not the way that I was understand that lawyers conduct themselves. So I'm sure that I wasn't there. I'm sure that Ms. Love will say whatever she says, or maybe say that didn't happen, but I just
Or
wanted to
maybe it didn't happen in quite that way, but
I
I
just wanna
don't know if Ms. Love wants to say anything.
I just want you to know that I cleared it with Mr. Wright beforehand. And he was on the actual Zoom. So I just want you to know that I didn't speak with Mr. Sledge without Mr. Wright. So,
Okay.
thank you.
Just a small follow-up. And of course, Mr. Wright will have the ability to say what Mr. Wright recalls, but I believe that Mr. Wright informed Mr. Steele before Mr. Steele asked that question, that he has no recollection of that ever being stated by me to Mr. Sledge. But I'll let Mr. Wright speak for Mr. Wright. And I inquired, I know that I would not say that. So whatever Mr. Sledge said, Mr. Sledge said. I don't know how the question was posed. I don't, that's all right. It'll happen on redirect. We can flesh it out. But this notion about, all of
Miss Love, you have been caught lying on so many occasions, so your affirmation that I wouldn't do that, you cannot be trusted because you have lied openly in court so many times. Your word is worthless.
that, Mr. Steele can ask whatever questions he wants to ask, and Mr. Sledge can answer however he feels he needs to. I'll handle that on redirect.
Okay. Yes, sir.
Sure. I want to go in and speak. I have indicated to both sides as I'm trying to stay calling this balls and strikes and staying neutral, but my client has repeated to me that that's how he heard it. I indicated to both sides that I heard her indicate that she was not going to be asking him, as in she clearly didn't like the subject matter, but I did not hear her affirmatively try to tell him not to disclose or say or secret it. So it's a slightly different interpretation of the non-lawyer and lawyer.
Sure.
And I think everyone knows I'm defense through and through. I would have no problem being able to say that, oh, that's exactly what she said. But I will not simply say it because it would be helpful.
Of course not. I would never expect, of course, our sounds out again, but.
It was at least a hot topic that it wasn't something that I thought the state was going to go into, but I can't say I have a memory of her saying the specific instruction to Sledge that he remembers. But my client does, that's how he recalls it. So my client's not being untruthful in terms of.
Well, we're not
what
gonna
he
get
recalls.
into whether you think he's truthful or not, because that wouldn't be appropriate, but you can say whatever you need to say when asked. And I appreciate you letting the court know and letting both sides know what it is that your recollection is.
Yes, sir.
All right. So do you think that Mr. Wright will be shortly on the heels of Mr. Sledge?
Right on the heel.
All righty. So you should just plan to stick around then, and then hopefully we'll be able to release you after that.
I will not do right now.
Okay.
Hopefully I'm here for you.
All right. Anything else? Sounds out again. Maybe it's back. Is it back? Allegedly, y'all, they are coming early on Monday morning to replace either the entirety or something in this box. I think they've already tried several things. This is some new thing. We'll see, but
If I buy anything, will they reimburse me?
what you mean?
If I buy some.
Who is we? Court administration?
Yeah, they, the people that are responsible for this, will they reimburse me if I buy some?
Miss Love, I cannot guarantee anything like that. I am still trying to get reimbursed for stuff from like 2 years ago. So, I mean, I wouldn't hold your breath. I wouldn't do that. If you plan to buy something, it'll just be for the good of this trial. It won't be. No.
Your
All
Honor,
right.
you
Yes.
allowed me to continue, so I don't have to ask the jurors to leave, but I made a motion.
Oh, yes. Yes.
And Mr.
Thank you
Matthews
for reminding me of that.
And what happened was, and please check the record, but what I remember happening was Ms. Love makes a speaking objection, comments, puts her own testimony before the jury and states that the testimony, that there's no evidence and it's already been proven. And I know that there's a strained relationship between Jeffrey Williams and Rich Homie Quan. That is wrong. Rich Homie Quan has given interviews shortly after January 10th, 2015, all the way up to 2024, consistently how close he and Jeffrey Williams are. The prosecution said that Rich Homie Quan, his real name is Mr. Lamar, that he was coming to court and he would be testifying. And the prosecution did not call him. He was on a short list. He was under subpoena. They did not call him. I have a good faith belief. They didn't call him because, what? I'm sorry?
Yeah, you need to.
I have a good faith belief that the state did not call him because he gave exculpatory information about his relationship with Jeffrey Williams. So for the prosecutor to then say in front of the jury, and please check the record to make sure that what I'm saying is what was said by Ms. Love, but I immediately would have made this motion if you did not allow me to preserve it. And a lawyer can't tell the testimony. This is what happened. Brian Steele knows this. That is untruthful. In fact, I know the opposite.
Uh-huh. All right, so my recollection is that Miss Love said that the evidence shows that after a certain date, one of the people in this picture no longer hung around Mr. Williams.
Okay, good.
That's a
That-
closer
That is not true.
account.
What the state was trying, their crazy theory, in my opinion, is that in the fall of 2014, Mr. Williams somehow cared about Rich Homie Kwan signing with a third party. His name is Mr. Brian Williams, which is Birdman.
Right.
And somehow that because Donovan Thomas said, no, Mr. Rich Homie Kwan, don't sign with Birdman, that Jeffrey Williams has now a motivation to kill Donovan Thomas. None of that comes out. And it's untruthful. As you saw, they are playing together, they being Jeffrey Williams and Rich Homie Kwan, on New Year's of
Well, you know what?
2014.
There are plenty of band members who play together and hate each other. So them playing together doesn't establish anything. But
Yeah, but it does not say they hate each other, which is the evidence the prosecution brings forward. And they can't prove it.
so Miss Love, you maintain that it is in evidence. So can you
That there was,
what part of the evidence and who said it?
yes, and I would ask if the court has in front of it my exact words, or if there's a way
I
to
don't
grab.
have
Okay,
your exact words in front of me, but I'm sure we can get them by Monday.
okay.
But it was
So what I was referring to was the testimony that has been given that after a certain date, at least one witness, there may have been two, testified that the relationship between one person in that photograph and defendant Williams changed. I can definitely say that I can definitely say that apart from that testimony that the jury has already heard, personally, I definitely have a great faith basis
okay, but that's
for
not what
saying
you
it, but that is not what I said. I said what I was referring to the second part of what was asserted by counsel.
Do you know which witness or witnesses it would have been? Because I think Miss Weaver's probably transcribed a good bit of this, and she's pretty fast. I'm happy to ask her to.
I believe it would have been Mr. Thomas Sr., who was asked about the relationship between one of the people in the photograph or having seen them after a certain time, or that it was strained. That's why I'm asking. And then I'm not certain whether Detective Dennis talked about it. That I'd have to look back.
Detective Dennis, that's your evidence?
I mean, did Mr. Thomas Sr. testify for any real length of time? I mean,
He
would
was
that
there
be
for a
easy?
day.
Okay, that'd be easy enough for Miss Weaver to put together. I'd imagine Mr.
And-
Dennis testified for longer.
Yes,
All
but
right. Maybe you could look at your notes on that and maybe pinpoint that more directly, and then I could ask Miss Weaver, with
I
some
will.
parameters, maybe.
And I'll also just check with the team because it's not been a topic that has been discussed. So we've discussed those things anyway, and I can clarify because it was not. It was, I think that was Miss Hilton's witness, so she'd probably have a better memory than me. But the reason that I asked exactly what I said is because I think I chose my words carefully before I said them.
Okay.
And I want to make certain of exactly what I said, and I want to point back to exactly what I was referring to.
Okay, and Miss Winfrey over the weekend will be kind enough to find us that little portion of Miss Love's statement that resulted in Mr. Steele having a motion and saying, can I just bring it up later, and me saying yes, and then we'll take all that up first thing on Monday.
Okay.
Thank you.
And
Okay.
the point is, a lawyer, I do remember the father attempting to say things like that, but he couldn't explain later photographs, whatever, that goes to weight.
What?
But the issue is a lawyer to tell a jury what the evidence is testifying. It's inappropriate.
Your Honor, what I think was inappropriate was attempting to mislead the jury by asserting that a photograph that Mr. Steele was aware was taken, or at least that particular concert or whatever, that was not a December 2015 concert as he stated to Mr. Sledge, and Mr. Sledge said yes. Even after Mr. Steele put up the next flyer or whatever it was and led Mr. Sledge by saying, this happened December 2014,
That
New
was
Year's Eve
actually
2015.
that was 2015.
That was it was going into 2015.
You asserted to this court that was from December 2015, and now you change your mind? You lying sack of... Yeah.
Second one.
So that was 2014.
Yes,
Okay.
the first one was 2014.
All of those.
And so when Mr. Steele said, the reason that I said that I objected the way I did is that Mr. Steele said that posting that was defense exhibit.
Folks, I need to start the panel show. It starts in 2 minutes, and I have to take a leak before. So, folks, let me post the link to that. Here it is. Get over there, and we will continue this on that one, okay? Because I need to... Okay, everybody, as per usual, thank you for being here. Thank you for the super chats, gifted memberships, all of that things. And I will see you in a few minutes on the panel show that will start within a couple of minutes. All right, thank you all, and I will see you all in a minute, but I will send you off with this.